morning and welcome to the LawNewz Network. I'm here, your host, Stephanie L. Willis, and I'll be your host today from 9 to 11. We have a great day set up for you all. You're not going to want to miss it. You're going to want to tune in. We have the Eric Campbell case, we have the Dr. Joseph Urich trial, and we're going to do some tidbits from OJ today. It's going to be amazing. I'm here today with our guest, Kenneth M. Willis. He's actually a criminal defense attorney from Louisiana. He practices both here in Louisiana and in New York, so we should have a great time today. Just to kind of recap what we did or what we saw over the last week. Last week during the Joseph Urich trial, the judge, I believe the prosecution completed their case in chief, and the judge denied a motion of acquittal for the defense. The defense essentially stated that they wanted the motion for acquittal due to the fact that the state failed to prove beyond a reasonable doubt that Dr. Urich was guilty of the charges that he has been charged with. In the Campbell case, there was another slam dunk, I guess, for the prosecution, you might want to say, only because the judge denied the defense's motion to use Edward Campbell, which is Eric Campbell's father. They denied the defense's motion to use his transcript, in which he actually stated that Eric was not involved in the case. So we're going to talk a little bit today, Kenneth. Thank you so much for being here with us today. What are you thinking? I'm going to talk about Dr. Urich's trial a little bit. So what are you thinking about Dr. Urich's trial and the judge essentially not granting the defense's motion for acquittal? How does that usually take place when we have a case like this? Well,
first of all, thank you for having me. It's a pleasure to be here. I think as a defense attorney, that's really standard practice after the state presents their case in chief. Essentially, what they're asking for is a motion for a directed verdict stating that the state failed to prove that there was sufficient evidence to sustain a conviction. This is typically general practice for any defense lawyer. However, the fact that the state prevailed, the defense has an opportunity to get inside the mind of the judge, since this is a bench trial. The fact that the judge denied it, I wouldn't read too much into this because the judge has to look at the facts in the most favorable light to the state, so the state may prevail. However, I'm pretty interested on the defense's case that they present. Certainly, we don't know too much about their theory, and I think this is a great opportunity to find that out.
Now, as a defense attorney, do you think that you would actually present a case if you firmly believe that, the prosecution in this case did not meet their burden? Are you going to take the chance and actually put forward a case, put on a defense? What would you do essentially as a defense attorney, or what do you think would be a useful tactic?
Well, I think we have to remember this is a bench trial. And so we're taking this case out of the hands of the jury, and so now we have a judge. And typically a judge, you have to be careful with judges because sometimes judges try to read right through the lawyers to get to the meat of the case. In this particular situation, I would be very concerned that the state has compelling evidence to support their conviction. So I would not sit and just rely on the fact that the state did not prove the case. I think the judge wants to see more. I think there is significant evidence to at least support the state's position to warrant a conviction. And I think I wouldn't stand still and just rely on that technicality that the state failed to prove their case.
Well, I mean, this is a kind of a risk that a defense attorney, well, not a defense attorney, that a defendant, because ultimately it's their choice, that a defendant would take when they decide to waive a jury trial and go before a judge. We all know that judges know the law. They are attorneys themselves. And what do you think about the fact that the judge essentially was the one who actually heard the hearing regarding the urine analysis and the fact that that was thrown out? I mean, we now know that the defendant's blood alcohol content was above the limit, but the judge actually knows this, but yet he can't, or he's not really supposed to use it. Do you think that that will come into play at all?
Well, I think the defense right now, they were at a catch-22. On one hand, it was a great idea to put this in the hands of the judge because you got to remember, this is a homicide offense.
Kenneth, I'm sorry, I'm going to have to cut you off real quick. We are getting some live movement in the courtroom in the Dr. Urich trial, and we're going to take you to there right now so you don't miss a thing. Thank you.
If he needs a break, I told him he could just lean over and ask you.
Yes.
Okay, I thought so. Thank you.
Yeah, you're gonna sit right here, but the judge is gonna swear you in as soon as you get up on this top level here.
Can I sit down or not?
Let him swear you in first if you
If you
don't.
would raise your right hand.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may be seated.
Good morning.
Good morning.
You're incredibly soft-spoken, and as I told you, this is a huge courtroom. There is a black microphone right there on the bench to the left of you, but I would ask if you can speak up so everyone can hear you. Would you please introduce yourself by stating your name and spelling your last name for the record?
My name is Miles Augustus Beam III. My last name is spelled B as in boy, E-A-M.
And in what city do you live, Mr. Beam?
I live in Raleigh, North Carolina.
Can you tell the court, please, what is your business, occupation, or profession?
I am an accident investigator focusing on recreational boat accidents.
And can you tell us how long you've been doing that, approximately?
I've been involved in accident investigation of this type since approximately 1994.
Can you tell us generally what an accident reconstructionist does?
My job is to, I look at the physical evidence, which includes the damage to the vessels in the case of a collision, to determine the facts of the case of what happened, how the boats interacted, and what I can about vessel speed. And then I make my report to my client about my findings.
Do you look at other evidence as well besides the physical findings of the boat?
I look at what is available to me. Sometimes, for example, with regards to boat speed, there may be data stored in a computer chip related to boat speed that gives us somewhat of a black box type functionality, if you will, with regards to boat speed as a function of time.
Do you look at other evidence as well that's available, such as witness statements or accident reports?
Yes, I'll look at any previous accident reports and statements that have been collected by the Coast Guard or local state agencies, such as DNR officers.
By whom are you employed, Mr. Beebe?
I'm self-employed, and I'm retained on a case-by-case basis by various parties. It might be law firms or insurance companies. Again, it varies from case to case.
And how long have you been doing that?
I've been in this work since 1994.
Can you tell us, before you began doing this work, what was your previous employment?
I was an engineer at Underwriters Laboratories in the Marine Department of that facility, which is in Research Triangle Park, North Carolina, located just outside of Raleigh.
How long did you work for Underwriters Laboratory?
6 years.
And what sort of work did you do there?
I was a test engineer that set up test programs to evaluate products submitted by manufacturers to determine their compliance with various safety standards.
Can you tell us a little bit about your education, starting with post-high school? Can you tell us, did you go to college?
Yes, sir. I went to North Carolina State University in Raleigh, North Carolina, and got a degree in mechanical engineering.
And what year did you receive your degree in mechanical engineering?
I graduated in 1985.
And after that, did you obtain any licensure?
Yes, sir. I earned my professional engineer's license in 1990.
Can you tell us generally what's involved in that? Is that just graduating from school and taking a test, or are there things you have to do prior to that?
Fundamental requirement is to have an engineering degree, and beyond that, there's a certain number of years of work experience that's required. And then there is an exam that has to be passed.
So you had to go through some years of work experience between college and getting this licensure?
Yes. I think the minimum is 5 years.
I'm sorry?
I'm sorry, I think the minimum is 5 years.
5 years? And do you remember then when you were licensed as a professional engineer?
Yes, it was 1990.
So I'm not sure if I asked you this. Do you remember what years, can you tell us please, did you work for Underwriters Laboratories?
It was from 1988 to 1994.
So was it during the time that you worked at Underwriters Laboratories that you received your licensure as a professional engineer?
Yes, sir.
Are there classes or courses or continuing education requirements that you have to maintain that licensure, or is it once you get it, you have?
There are annual requirements for a certain number of continuing education requirements.
And have you met those to keep your license?
Yes, sir.
Do you belong to any professional associations?
I'm currently a member of an organization that writes and develops voluntary standards for the marine industry, known as the American Boat and Yacht Council.
The Boat and
American Boat and Yacht Council.
Now, have you worked on any special projects during your employment with Underwriters Laboratory?
Yes, sir.
Can you tell us about that?
One of my largest projects was to conduct research on how to reconstruct boat accidents, in particular collisions, based on physical evidence. And that was a 3-year study that was funded by the Coast Guard. And I was the lead engineer on the project that handled that.
So the Coast Guard basically funded a study done by Underwriters Laboratory?
Yes, sir.
And you were the lead engineer on that project?
Yes, sir.
Can you tell us Have you done work in a number of jurisdictions?
I've worked in a number of states.
Have you also worked outside of the United States?
Yes, sir. I was employed or retained by the government of New South Wales in Australia
For what, please?
to do an accident investigation and reconstruction of a collision in Sydney Harbor between a ferry and a private yacht.
So since you've been working for yourself, has accident reconstruction been primarily what you do for a living?
Yes, sir.
Now, besides the things that we've talked about, have you also been a teacher or presenter at any courses, seminars, anything like that?
Yes, sir.
Can you tell us about that, please?
The National Association of State Boating Law Administrators, organization referred to as NASBLA, has continued a project that was started by UL, which is a course designed to teach advanced investigation techniques to law enforcement officers to help them identify causes of boat accidents. Not just collisions,
What
but
was your
prior
involvement in
accidents.
that?
Originally, I helped develop some of the material for that, and I was one of the instructors initially.
Have you presented materials at any other courses for lawyers or other professionals?
I've been a guest speaker at continuing education conferences for lawyers practicing in the Marine area. I gave a presentation to a group of lawyers in Charleston, South Carolina on the current state of the art of boat accident reconstruction.
Have you testified before in court as an expert witness on accident reconstruction?
Yes, sir.
Can you tell us, have you testified in both civil and criminal trials, or just one or the other?
Both.
Have you testified in criminal trials for both the prosecution and the defense, or just one or the other?
Both.
And how about in civil cases? Have you testified for the plaintiff, for the defendant, or for both?
Both.
Can you talk to us specifically now about this case? First of all, were you engaged to perform an accident reconstruction in this case?
Yes, sir.
By whom?
By the law office of Lynn Merrill.
And can you tell us then, please, did you review materials as part of the accident reconstruction that you performed?
Yes, sir.
Can you tell us what materials that you reviewed?
I was provided a list of materials that was quite extensive by Ms. Merrill's office, which included photographs, reports from state agencies of their investigation.
Are those items listed anywhere?
A list of those items can be found in the report that I presented as attachment A.
So attachment A to your report lists those materials?
Yes, sir.
Besides reviewing those materials, can you tell the court what, if anything else, that you did as part of an accident reconstruction?
I traveled to Ohio to do an inspection of the boats after the accident, and I worked with a firm that I subcontracted to supervise the gathering of data through a technique called 3D laser scanning.
I'm going to ask you to keep your voice up because I see Kathy leaning in towards you and she's right next to you. So tell us again about that. You engaged a firm
to perform a type of data collection known as 3D laser scanning.
And what's the use or purpose of that when it comes to accident reconstruction?
We gather data that can be used to literally rebuild the boat inside the computer. And with that data, we can manipulate it and determine how, you know, the boats interacted with each other much easier.
Okay, when you say manipulate the data, tell us what you mean by that.
I mean simply alter the orientation of the boats in the computer so we can see them from different angles. We can take measurements of certain things that are hard to get to, maybe physically, on the real boat. We can get those with great precision in the computer using the data that was scanned.
All right. So did you come to Ohio to physically view the Bayliner that was owned by Joseph Urich in this case?
Yes, sir.
Did you come to Ohio to view the Bassmaster that was owned by Mr. Bruce Lindemood in connection with this case?
Yes, sir.
And you engaged this firm to do these scans that you talked about earlier, is that right?
Yes, sir.
Were you present when those scans were conducted?
Yes, sir.
Is there a general method or methodology that you use to ensure that the results of your accident reconstruction can be relied upon? You just sort of describe for the court if there's such a process.
Well, the general steps to the process are to review the data provided by the law firm on what documentation has been collected to that point, the vessel inspections, and then documentation of the damage to the vessels. And in this case, and some other cases, I've done the 3D scanning so that we can work with the models in the computer. In the days before this technology was available, it was not uncommon to use forklifts and other types of equipment to literally move the boats around physically to try to help match up particular points of each vessel that came in contact with each other. That was a somewhat difficult and dangerous process, as you might imagine.
So this computerized process sort of takes the place of that physical moving of the boats to line them up with the damage?
It does.
May I approach?
Yes.
Thank you.
Oh, yes.
Mr. Beam, I've handed you what we've marked for identification purposes as Defendant's Exhibit Y. Can you tell the court, please, first of all, when you came to Ohio and viewed, let's start with the Bassmaster, did you and your subcontractor take a number of photographs?
Yes, sir.
Have you since reviewed those photographs?
Yes.
And did you use those photographs as part of formulating an opinion in this case?
Yes, sir.
In addition to your own physical viewing, is that right?
That's right.
Okay. Have you reviewed all those photographs to make certain, and can you tell us, do those photographs fairly and accurately depict the Bassmaster as you saw it in Ohio when you came up here?
Yes, sir.
Did you likewise, when you came to Ohio, take photographs of Dr. Urich's Bayliner 185?
Yes, sir.
And have you since reviewed those photographs?
Yes, sir.
Did you use those photographs in addition to your personal observations in formulating the opinions you've arrived at?
Yes, sir.
Do the photographs of Dr. Urich's Bayliner fairly and accurately depict the Bayliner as you saw it when you came to Ohio?
Yes, sir.
In addition, did you prepare or have prepared under your direction a number of reproductions based upon the scans that were taken?
Yes, sir.
And have you likewise reviewed all of those to make certain that they fairly and accurately depict the scans that were computer generated?
Yes, sir.
And then finally, there were several photographs that you specifically selected separately, I think 7 photographs. Do you recall that?
Yes, sir.
Those were photographs of one boat, the other boat, or both of them?
Photographs of both boats chosen.
And you selected those photographs separately, correct?
Yes, sir.
Have you reviewed those photographs to make certain that they fairly and accurately depict the boats as you saw them?
Yes, sir.
And do they?
Yes, sir.
Exhibit Y contains all of these items that we've discovered. Have you reviewed all those items to make sure that they fairly and accurately depict what's portrayed in them?
Yes, sir.
And do they?
Yes, sir.
Now, of those scans, did you select several today for purposes of illustrating your testimony?
Yes, sir.
Tell me where it's most convenient for you if I put this.
Start with closer.
Okay. That's a start. If I put it up here so you and the judge can see it, does that work?
That's fine, sir.
Now on this board, which we have marked as Defendant's Exhibit Z, can you tell the court, first of all, just generally what's on there? That is the number of items and a general description of the items.
All right, we have 6 items on the board here.
And what are those? Are those photographs or those scans? What are they, please?
These are different views of the boats from the scan data that was taken. And we'll begin with the upper left and go through the sequence, if that's all right.
Okay, are they placed on the board then in sequence?
Yes, sir.
Okay, and so in the sequence, can you tell the court, and since we're making a record, I want to identify it verbally, which of those 6 is the first in the sequence?
All right, this one at the upper left.
Okay, so the first one up in the upper left-hand corner?
Yes, sir.
And can you tell the court that scan was generated as you had described earlier from the damage?
The scans of each individual boat are from the items that you're looking at, the top-down view of the boats that were created from the scans of the individual boats. The position of the boats relative to each other is based on what we established as the general impact orientation prior to the collision, and based on physical data as well as witness statements.
Okay. Now, do you do anything to fix the position of those boats relative to north, south, east, and west, or is your concern more the boats relative to each other?
The primary focus is the boats relative to each other. In this particular case, I wasn't asked to try to ascertain the direction of each vessel in regards to a north-south or east-west type of grid.
All right. So directing your attention back then to the first of those photographs, the one in the upper left, or excuse me, the first of those scans, the one in the upper left. Can you tell the court, please, what that scan represents and what the significance of it is to your findings and conclusions?
The boat that is higher in the photograph is a top view of the bayliner of Dr. Urich's boat approaching the general area of where the bass boat is located. Perhaps the most significant thing is that the bass boat is oriented in the direction of travel that leaves the bayliner to its starboard side.
And why is that significant?
It's significant because according to the navigation rules, the boat which is to the starboard side of a vessel is what's referred to as the stand-on vessel, and you become the giveaway vessel, which means you have to yield to the course of the other boat. So in this case, the bayliner is considered the stand-on vessel, which means that the bass boat would have to yield change its course in order to avoid being in the path of the bayliner.
Because the bayliner is to the starboard side of the bass boat.
Yes, because the bayliner is to the starboard side of the bass boat.
All right. Is there anything else of significance to your opinions and conclusions with regard to the first of those scans, or should we move on?
You can move on. I think
Okay.
that those are the main things.
All right. Then could you tell us, by describing its position on the board, what's the next scan in the sequence?
The photo that's in the upper right, and again, this is a top-down view. The individual boats, just as in the previous photograph, are generated from the computer scan data. The orientation of the vessels is my analysis as to how they appeared at first contact, with the bow of the bass boat making contact with the port side near the bow of the bayliner. And I'm pointing to that if you can see it. It's in this area.
So the starboard side of the bass boat makes contact with the port side of the bayliner.
Yes, sir. We describe it more as the nose, the most forward projection of the bass boat that makes that contact initially.
Is there anything else of significance to that scan relative to your conclusions that we need to discuss?
It does show the distortion beginning to take place on the hull of the bass boat.
Can I stop you there for a second and ask you, do you recall the construction of the bass boat? And when I say construction, what material was it constructed of?
The bass boat is made from metal. It appeared to be a type of aluminum.
And how about the bayliner?
The bayliner was fiberglass.
So you were, with reference to that upper right-hand scan, you were starting to talk about the distortion. Can you describe for the court what you mean by that distortion and how it would occur?
The damage to the bass boat after the collision showed that the bow of the boat had actually been displaced from one side to the other slightly. In simple layman's terms, it was bent to one side, and in the process of bending that bow to one side, it caused the port side of the bass boat to be deformed, and I'll describe it as crumpled. It's what happens when you get a structure, especially a metal structure, under compression. The material buckles and distorts. And in
Can you
doing
give sort of
so,
an everyday example of how that happens?
if, for example, you take an empty soda can and you were to step on it, if you started and got, started to smush it a little bit, what you would see before you smashed it to turn into a pancake size, round disc, the sides of that soda can would be bent in and out and different types of shapes that occurred because of that buckling. And they may be bent inward even though you didn't press directly on the sides of that can. And this is a similar phenomenon.
So if I understand you, you're stepping on top of a soda can, it may bend in and out on the sides even if you're not putting pressure directly on the sides.
That's right.
Okay. Is there anything else with regard to the second scan that we need to talk about concerning your opinions or conclusions?
The general orientation of the vessels and the way the impact initially occurs is going to create a fairly rapid rotation of the bass boat because the initial impact force is on the bow of the bass boat, directed somewhat from the side.
This is not, if I can interrupt you, sort of like a T-bone crash that we would think of in an automobile accident. Is that right?
That's right.
Now, can I ask you, as part of your work in this case, have you had a chance to review the report prepared by the state's accident reconstructionist, Mr. McCullough?
Yes, sir.
Do you have general agreement with Mr. McCullough's angle of approach of each of the boats relative to each other, or do you not? In other words, do you agree with his assessment or do you not?
I'd like to see the diagram again that you're referring to that describes his assessment.
May I approach?
Yes.
Thank you. I've handed you 3 diagrams. They've been previously marked as defendant's exhibits R, S, and T. Would you take a moment to look at those, and then when you finish, just look up and let me know that you've finished?
Yes, sir.
Thank you. Okay?
Yes, sir.
All right, let's start, please, if we can, first with defendant's exhibit R. Can you describe for the court generally what's depicted in that exhibit?
The bayliner is on a course that is in a general northeast direction, approaching the bass boat, which would be pointed due south, assuming that north is pointed vertically straight up. And it shows the bow of the bayliner on the port side hitting the nose or the foremost section of the bass boat.
All right, so let's break that down. First of all, do you agree with the general directional orientation, assuming the bass boat is facing south?
I agree with the general path and orientation of the vessels relative to each other. But as we discussed earlier, I did not do an analysis to try to establish the direction of each vessel individually as it relates to, say, a compass heading.
All right. In the course of reviewing Mr. McCullough's report, do you recall that he listed an angle of, approximate angle of impact between the two boats?
I remember seeing a diagram to that effect. I don't recall the number.
Okay. The next exhibit, I think, is exhibit, was it S?
Yes, I have an exhibit S.
Is it S?
Yes, sir. I have an answer.
Can you tell the court and describe for the record generally what's depicted in defendant's exhibit S?
It's consistent with what we've already discussed with the port side of the bay liner near the bow coming in contact with the nose of the bass boat. In this diagram, it's pretty clear that the nose of the bass boat penetrated, shows it penetrating some distance into the bay liner. And he also indicates that the bass boat is rotating, so the nose is being pushed away from the bass boat's nose is being pushed away from the bay liner as the bay liner, continues on its course for some distance.
Okay. And did your reconstruction effort, did it agree with the fact that the bass boat was pushed into a spin?
Yes.
And now, if you would, exhibit T.
Yes, sir, I have it.
I'm going to put this up. Does this appear to be a, I'll take this one down first. Does this appear to be a blow up of exhibit, is it T?
Yes, sir. Yes, T. Yes, sir.
Now, tell us, please, generally what's depicted in this exhibit.
It shows the vessels in the relative position to each other that we've discussed before. And this time it also shows the US 224 overpass, the bridge that travels over the lake in that location. And it shows that the bay liner and the bass tracker are to the north of the bridge. The bay liner is headed due south.
And did you read things in preparation of your accident reconstruction that suggested that the bay liner was heading in a southerly direction when the accident happened?
I don't recall specifically because I wasn't looking for that. I was concerned only with the relative position of the vessels.
Okay. If you assume from that picture that north is the top, and so the bay liner is traveling in a southerly direction, do you agree with or disagree with the orientation of the boats as shown in that exhibit, exhibit T?
I agree with the general layout, yes. I'd like to clarify that in one term. That is in my analysis, the orientation of the bass tracker was closer to an orientation that would represent closer to a head-on orientation, instead of being something that, in this case, in the diagram, it shows the stern of the vessel being presented more towards the bow. In my analysis, the nose of the bass tracker was pointed more in a direct, just say closer to a head-on orientation to the bayliner.
But this orientation in Exhibit T, can you tell us, with reference to that navigation rule that you talked about earlier, which vessel would be the vessel that would have the right-of-way and why?
Objection. Already testified to.
Overruled.
This shows a crossing situation, and the bayliner is still to the starboard of the bass tracker, which indicates that the bayliner is referred to as the stand-on vessel, and the bass tracker is the vessel which would have to yield to the bayliner.
I'm going to place up here again Defendant's Exhibit Z, and that's the one that's got the scans, am I correct?
The one in the lower right, is that the one you're referring to?
No, actually, I'm just trying to refer to the fact for the record that we're putting back up in front of you something that you saw before, which is Exhibit Z, correct? It's up in the upper right hand.
Yes, sir.
And that has the 6 scans that you were testifying about previously, correct?
Yes, sir.
Okay. I think we left off actually with number 2, the one in the upper right-hand corner. Is there anything else about that scan that's pertinent to your conclusions or your testimony here today, or can we move on?
I think we can move on.
Okay. And can you tell us then, by its position on the board, which one would be next in the sequence?
The middle one in the first column.
Okay, so on the middle one on the left?
Yes, sir.
All right. And can you describe generally what is depicted in that scan? Need me to move that closer to you?
If you don't mind.
May I, Your Honor?
You may.
Thank you.
It may just be the position with the glare.
Glare? Okay.
Trying to get it so everybody can. Can you see that better now?
Yes, sir. That's much better. Thank you.
Okay.
Just going to ask you, since you're leaning up, to keep your voice up so that we can all hear you. So can you describe for us, please, what's portrayed in that scan?
In this scan, the nose of the bass boat is making contact with the port side of the bow of the bayliner. The buckling of the sides of the bass boat is becoming apparent in this photo. It's clear in this diagram that the side of the hull of the bayliner has been penetrated at this point.
And are you able to tell from your reconstruction what it is about the bass boat that penetrated the bayliner?
There's an aluminum plate that is fastened to the top of the bass boat right at the bow. That area of the bass boat penetrated the hull of the bayliner.
This may be difficult. I'm going to ask you to do your best with it. Can you give us an idea of the timing or the sequence? Like how quickly would all this have been going on?
Would have happened very, very quickly. Fractions of a second, most likely.
All right. Is there anything else about the third scan that we need to talk about in relation to your opinions or your testimony here today?
Not that we haven't covered, no, sir.
All right. Thank you. Can you tell us then, please, in the sequence, by describing its position on the board, what is the next scan in the sequence?
The middle diagram on the second column.
Okay. So on the right?
Yes, sir.
All right. And can you describe, please, for the court and for the record, generally what's portrayed in that scan?
In this scan, the collision has progressed just slightly further than it was in the previous scan. And this is the biggest difference is this is a top-down view of the boats in the early stages of contact, whereas the other one was more of a perspective viewpoint. In this view, it's very apparent that the very tip of the bass boat has been pushed to the port side of the center line, and that's begun to cause significant distortion to the sides of the bass boat. Don't know that it's clear on the diagram, but it's certainly at this point, if not before, the bass boat would have begun fairly rapid rotation to the bow would have rotated to port of the center line. Or said another way, the boat is rotating counterclockwise from the top-down view.
Are you able to tell us to a reasonable degree of engineering certainty what would happen if there were occupants in that bass boat, assuming they weren't fastened to their seats?
Yes, sir.
What would that be?
In general, the tendency would have been for the bass boat to literally move out from under the occupants.
So it's less a question of being ejected and really being ejected sort of because the boat, your ground moves out from under you. Is that what you're saying?
Yes, sir.
Is there anything else of significance to this fourth scan to your testimony here today or the opinions you rendered?
Not at this time. I can't tell anything else.
All right. And then how about what is the fifth scan? Can you tell us what that is?
The lower left photograph or diagram.
And what is depicted in that scan?
In this scan, we see the boat interaction continuing to the next phase. So the collision occurs in terms of the interaction of the boats, how they contact each other somewhat in phases. There's an initial contact, which mostly is what we've talked about so far in the early stages. And during that early phases of contact, we see the penetration of the bass boat into the bow of the bayliner. As the collision sequence progresses, the bayliner pushes the nose of the bass boat to the bass boat's port side. In addition to causing the bass boat to rotate, it brings the starboard side of the bow of the bass boat in contact with the bayliner in such a way that the bayliner hull actually it meets the bass boat in such a way that the bass boat conforms to the bayliner, sort of wraps itself around the bow a little bit. And as that happens, the two for a brief moment are at one point they're moving together. And as the bass boat continues to be rotated, the stern of the two vessels starts to get closer together. And as that happens, there's a point at which it's difficult to describe, but the starboard side of the bass boat, some distance back from the nose, has to break away. Can't pivot, but so far it's very much like the effect you would have if you're in your workshop and you're working with a wood saw and you want to get the saw unstuck from the groove it's in. You push down on the handle so the saw blade pivots around where you've stopped cutting. And that's very much what happens here is there's a hole in a big gash in the side of the bayliner. And that bass boat can only pivot next to it so far before the two break apart from each other. And that's the part of the collision sequence we refer to as separation or disengagement.
I asked you a couple of minutes ago about what would happen to the passengers assuming they were not secured to their seats during this collision. Is there a sort of an everyday example, like earlier you used the pop can example to describe to us this crushing that took place, or this formation that took place on the bass boat. Is there an everyday example you can use that would help explain what would happen with the passengers?
Yes, sir. It's very much, I'm sure most people have seen the illustration where somebody can yank the tablecloth out from under a dish or a napkin out from under a cup that it's sitting on. And it's very much that kind of effect.
And is that, and the boat being forced rapidly and violently in one direction would sort of be like yanking the tablecloth, is that it?
Very much so.
And the passengers would sort of be like whatever's on the
It
table?
would be much like the cup or the glass on the napkin.
The fifth of those scans, is there anything else that scan tells you in terms of the positions or elevations of the boats relative to each other?
Not that's readily apparent from the top-down view that this shows.
All right, and then I believe that I'm sorry, is there anything else that we need to discuss about the fifth scan relative to your opinions or conclusions?
No, sir.
Then there's the sixth of the scans on Defendant's Exhibit C. That's the one in the lower right-hand corner, am I correct?
Yes, sir.
Can you describe for the court and for the record, please, what's portrayed in that scan?
This is a perspective view of the vessels early in the collision phase, but after the penetration of the side of the bayliner by the bass boat. And it's from a perspective of somewhat looking up from the bottom, as if you were underwater watching this thing happen. And what it shows here is that in this view it appears that the bass boat's bow is depressed. The gunnels of the two boats, the gunnel being the top of the side of the boats, is oriented such that the gunnel of the bayliner is above the gunnels of the bass boat, which is a complex way of saying it. Looks like the bass boat's sitting a little higher than the bayliner's sitting a little higher than the bass boat.
And is there anything about the accident that causes the nose or the bow of the bass boat to depress or go down in any way?
The curvature of the bow of the bayliner is such that it would tend to deflect the bass boat's bow downward.
When you say the curvature, are you talking about the curvature looking at the deck from the top down, or are you talking about the curvature looking from the gunnel down to the keel?
If you were to stand in line with the center line of the bayliner and look at a cross section, what you would get if we were to slice it across like a piece of pie, you would look at that would tend to depress the bow of the bass boat as the bass boat gets, I don't want to say underneath, but I'll say as the bow of the bayliner starts to ride over the bow of the bass boat. And again, I'm just talking about that, that first tip of the bass boat being deflected downward some.
So the curvature of the bass boat is basically pushing the nose down, is that what you're saying?
The curvature of the bayliner bow
I'm
is
sorry.
pushing just the nose of the bass boat down slightly.
Is this a quick process or a long drawn out process?
It would still be fairly quick. It would still be fractions of a second.
May I approach Your Honor?
You have continuing permission to.
Oh,
I'm going to hand you now.
what we marked as defendants exhibits AA through EE. If you wouldn't mind, just take a moment and go through each of those, and then when you finish, please look up and let me know.
All right, sir.
still need that diagram.
No, you want me to take that down? Yeah.
All right, sir.
Okay, have you finished?
Yes, sir.
I'm sorry. Can you, I mentioned earlier that when we were identifying the disc, which I believe was Defendant's Exhibit Y, there were some photographs that you particularly wanted singled out, correct?
Yes, sir.
Are those photographs, exhibits AA through EE?
Yes, sir.
Let's start, if we can, with AA. Would you tell the court, please, just generally what's depicted in AA?
I might need you to locate that one for me.
Sure.
Is there? I don't know that. I'll ask Brian. Okay. Yeah, I don't think they generally do.
All right, sir. I have a AA.
All right.
I'm going to take that from you if I can, and we're going to try to put it up on the Elmo and see if that helps.
So this is Defendant's Exhibit AA. Are you able to see that okay from over there?
Yes, sir.
All right. Can you tell the court, first of all, which of the two boats is depicted?
This is the Bayliner.
All right. And tell the court and the record which side of the Bayliner is depicted in this photo.
We're looking at the port side of the bow of the Bayliner.
And then what is the significance of this photo, or what's portrayed in this photo that's of significance to your opinions?
This photo shows the area where the bow of the bass boat penetrated in the initial contact early in the collision.
Okay. Now, as a result of what you see here and the other things that you found, are you able to tell us to a reasonable degree of engineering certainty how that bass boat penetrated, as you described earlier?
Can you clarify by what you mean by how?
Well, can you give us, we've been using some sort of everyday examples like pop cans and tablecloths. Is there something that you can use to describe for us how this penetration took place?
Yes, sir. See if I can do it this way. The shape of the outline of what you see here, this area it's almost shaped like a triangle. This top line is fairly close to horizontal parallel with the water line. This section over here, kind of on the bottom, and then it meets at a point, forming a triangle. This section of fiberglass here in the middle was pushed out of the way. It was pushed inward when the bow of the bass boat penetrated into the bay liner. And this gash here is created by the penetration, and the gash grows longer as the bass boat gets deeper and deeper into the side of the hull. And because it's triangular shaped, it has that effect. It's basically, if you were to take a triangle, something that's shaped like a piece of pizza, and push it through a piece of cardboard, the deeper you go as that triangle gets wider, the longer this line that it creates because of the penetration. So that's really what we have here, is a triangle in the shape of being the nose of the bass boat, penetrating the side of this bay liner, and the further it penetrates, the longer the gash here becomes, because the wider the bass boat becomes, the further back you go.
Okay. Is there a way to tell with a reasonable degree of engineering certainty how far the bass boat penetrated, or can you not tell?
It's possible to tell that. I did not provide that value specifically, but it would be easy to get it from the computer.
Is there anything else about the placement of that damage on the bay liner that is of significance to your opinions or conclusions?
The location of the damage here is on the side of the bay liner. It's not exactly at the center line. In other words, I was looking for information to determine if this was something closer to, say, a glancing blow, as opposed to an override where one vessel rides over the top of the other. And if this had been an override type of an accident, the damage that we see here, we would have seen some type of similar damage of gouges and material transfer, broken fiberglass right along the center line of the bay liner, but it isn't there.
When you say the center line of the bay liner, are you talking about up in this area, or down here? I'm trying to figure out when you say center.
By center line, I'm talking about the part of the bay liner that you would cut it as if you cut it in half, so you had two equal halves. Just like you would cut a piece of pie in half, where you have two sides the same.
You had mentioned earlier that these two boats sort of stayed together for a bit. You used the example of the saw getting caught in the wood. You recall that?
Yes, sir.
Is there anything about this damage that helps you or disputes that?
Not necessarily.
Okay. You've read the report, Mr. McCullough indicating or suggesting that this bay liner was on plane when this collision occurred, correct?
Yes, sir.
Do you agree with that assessment or do you not?
I don't believe there's enough information to say that it was for sure on plane. I think that after reading his report, that his assumption that it was on plane was based on a false assumption that he made about the way that the damage to the side of the bay liner was made.
This damage that we're looking at here in Defendant's Exhibit AA?
Yes, especially this top part here.
Okay.
This top part, as I mentioned, it looks like it is mostly possibly parallel to the water line.
Uh-huh.
And I believe the assumption was made that he made was that the bay liner was level with the water and that line was, that gash was created as the bass boat, he believes, was stationary, and this bay liner went past the point of the bass boat.
So why do you say that's a false assumption?
Because he assumed that gash had to be made in that manner, but there was the other way that it could be made was what we just went through with the triangle going through the piece of cardboard, or the pizza slice example, where the further it penetrates, the wider the line gets, and that's what we have. I'm convinced this is what we have here.
So are you saying this damage could have been caused even though the bay liner was in transition?
Let me answer that a slightly different way. I would say that the bay liner could have experienced that damage without having to be parallel with the water line, without having to be on plane.
Are you able to explain or show us how that can be?
Trying to think of a simple example. Is there a board we can use?
There's a blackboard.
Okay. Might work.
Wherever you're comfortable drawing. Yes, so if you could, the prosecutors are over there so they can see what you're doing. If you just keep your voice up to tell them, if in case you're talking while you're doing this, to show the judge what you're doing. Can you clarify for me?
If you are able perhaps to switch positions so Kathy can...
Can you come over here so Kathy will be able to hear you better?
Can you clarify for me what you're asking me to do?
Yeah. If I understand your testimony, you're saying that the conclusion of the state's reconstructionist that the boat was on plane is premised on a false assumption. correct?
Yes.
And that this damage could be caused without the boat necessarily being on plane, correct?
Yes.
Okay. So, however you're comfortable doing, is there something you can do to show the court what you mean by how that could have been caused without it being on plane? Can you even move this?
Move this one, it's not that a little further back.
Yeah.
Just drawing water line here. This is the top surface of the water. Top water art isn't the best in the world.
I'm sorry.
But we have a situation
John.
where the,
You need to speak up. The judge could not hear you. He's not that far away, and neither can Kathy. All right, you know what the one on the left represents. What's the one on the right represent?
just step back away so you can see it.
Keep your voice up, please.
All right. Okay, we've got the profile. Look at the side view of the baler and look to the water. The boat to the right is the bass boat. And I've given you the top-down view of the bass boat here, showing the bow of the bass boat. So you point toward your view. I didn't know at exactly the right height, but I believe that the state's investigation assumed that this gash was made when the bow of the baler went by the nose of the bass boat, scraping against the taking this gash. Now, the way I've drawn it here is just for illustration purposes. It isn't meant to show you correct orientation and collision took place. Because in this drawing, we're looking at the starboard side of the baler, but of course the damage is to the port side. I'm just trying to illustrate the manner in which I think he believed that such damage occurred. So this action would have taken place with the port side of the baler rubbing against the nose of the bass boat. But in this case, the idea is that the bass boat would have been, the nose would have been pointed toward the side of the baler, and that gash was created as it rode by it. He believes that's how that horizontal line, the horizontal gash was created. But I believe what he didn't consider was that this gash could have been created as the bass boat penetrated the side of the baler, just as we discussed over there.
All right. Does that explain the difference between his assumption and why you're saying that's a false assumption?
Yes.
Okay. Go ahead.
He also said that if the boat had been, if the baler had been on a plane, and it had to be on a plane because it was level,
Because the damage was level?
Because it's above the actual level. Did I answer your question, sir?
Yes.
I think he poured you some water. Oh, very good. Yes. Right.
Does they need more water?
Can you say to a reasonable degree of scientific certainty whether or not the bayliner was on plane one way or the other, or is it not possible to do that?
I didn't feel I had enough information to say conclusively whether it was or wasn't.
From the information you had available, is it possible to determine, or is it not, to a reasonable degree of scientific certainty where there was a point of impact? In other words, is there a one point where the boats came in contact?
Depends on how you define point.
Okay. How do you define a point?
In a case like this, I would think of a point is going to be a relatively small area. It's not going to be a point like a pinpoint, as you know, the head of a pin or something. It's not going to be that small. It would be an area.
You able to give us some idea about how big that area might be?
Roughly the outline of, you know, say the palm of your hand, or if you ball up your fist, maybe the front face of a fist like this. So maybe an 1 by 3 inch square, something of that nature.
Are you able to tell us with a reasonable degree of scientific, engineering certainty, what the speed was of the bayliner at the time of the collision?
No, sir, I didn't find enough information to quantify that to a small value.
Okay. Are you able to give the court, to a reasonable degree of engineering certainty, a range that the bayliner could have been traveling?
A range.
Well, let me ask you this first, before we go there. We've heard some talk about planing, and you've talked a little bit about planing. Were you able to find any scientific studies or engineering studies that had been done to determine a planing speed for the bayliner 185?
There was some tests done by one of the boat magazines where they did record time to plane and the boat's time to reach 30 miles per hour from a dead stop.
That was done by a boat magazine?
Yeah, it was referred to as boattest.com.
So, based upon the information you were able to gather, is it possible or is it not possible to tell us to a reasonable degree of engineering certainty a range between which this boat could have been traveling in terms of miles per hour? You know, between X and Y miles per hour.
using their data, it suggests that the minimum planing speed of the boat would have been in the neighborhood of 10 to 13 miles per hour as far as minimum planing speed.
Now, we've heard some testimony earlier in this trial about different phases that a boat goes through as it accelerates. So as to not belabor this too long, do you agree that there are 3 phases that a boat goes through?
Yes.
Beginning with idling?
Idling or dead stop, yes.
Okay. And then what's the next phase?
The next phase would be the beginning of a plane, which is as the boat starts to move forward, it begins to rise out of the water. As that happens, it moves from what we refer to as a displacement hull, where the boat's weight is supported on top of the water solely by the boat pushing water aside, which means it's what we call buoyancy. It's what allows things to float. As the speed of the boat increases, the water is deflected downward by the hull, and it provides the lift to keep the boat up on top of the water. It's a common example that you see of that frequently would be water skis. Water skis keep the water skier up by planing on the water, not by the buoyancy of the water ski, because the water ski doesn't have much buoyancy. So that's the idea I'm trying to convey here.
All right. And is there a name given to that phase between idling and planing?
There is what we refer to as a transition phase, where the boat goes from sitting level in the water, stationary. It goes from being a displacement hull to being the boat on plane. And that is referred to as a transition phase. Some people refer to it as getting over the hump.
Some people refer to it as placing?
Getting over the hump.
Getting over the hump? All right. Now, is there a magical number for every boat where it just goes from transition and then 1 mile an hour faster, it's on planing, or is it not that precise?
It's not that precise. Planing is a fairly subjective term. It's because there are various degrees of being on plane, if you will. It's a judgment as to whether or not you would decide if a boat is on plane or not.
Are you able to tell us to a reasonable degree of engineering certainty if the bass boat was moving at all during immediately before the collision?
I can tell you that I did not see convincing evidence that it was moving at what I'm going to describe as a significant rate of speed compared to the Bayliner. And again, I can't put a hard number on that. But if the bass boat had been moving at say a speed of 10, 15, 20 miles per hour, I believe I would have seen evidence of that. I didn't find it.
All right. Is there anything that you can tell us about whether it was moving at all or whether it was stationary?
If it was moving slowly.
Okay.
Yes.
I have maybe 10 minutes. Do you want Kathy a break?
Yeah, I think good opportunity for our morning recess. We'll come back here in about 15 minutes. Thank you.
All right. Court is in recess.
and welcome back to the LawNewz Network. I am your host, Stephanie L. Willis, and we just heard some testimony from the defense expert, I believe, which is Miles Beam. He's actually an accident reconstructionist. He was informing us or rendering his opinion as to exactly how he believed the accident occurred. You know, some people may at times believe that this testimony is a bit dry, but as a matter of fact, as we know, Kenneth, it is sometimes necessary for us to have this type of testimony in order to, I guess, render an opinion, because sometimes we find that an opinion before the eyes of the court is very important. Wouldn't you agree?
Oh, absolutely. And of course, this is a bench trial, so the judge is making a decision. So as a defense attorney, we're not concerned about boring the jury, because we have a judge who understands he has to pay close attention to the information that is being provided by the expert witness. So that's not a concern. The major concern is this expert presenting a compelling case in terms of his opinion in an alternative version as to what may have occurred.
And I think that he actually did a great job in doing that. I mean, his alternative opinion, I think, was a little bit different as to what we would have expected, but I know that during the break that we were talking about it a little bit. I mean, were you able to determine from his, I guess, his drawing exactly maybe what he was trying to display regarding the diagram that he showed?
Well, I think first I think it was important for him to show that we don't know the rate of speed in which the doctor's boat was planing. And that's significant because, of course, the defense is trying to show a case that the doctor was not even negligent when this incident occurred. There was no indication of speeding. So with the expert witness, he could not support, based on his findings, that there was any indication of any speeding. And of course, his testimony was different than the state's expert in terms of how this accident occurred.
Okay. Well, I think that's a great point that you brought up. It's actually really important for the defense actually to bring this out, to bring out their alternative theory. Now, in speaking about alternative theories, we have a case here that we are going to be taking over this week. It's actually the OJ parole hearing case, and I know that you're really excited to talk about this because we've been talking about this case all weekend.
Absolutely.
I'm not sure if you guys know, but Kenneth is actually my husband, so we've been talking about this case all weekend long, and we've been so excited to actually bring this case to you all at the LawNewz Network. So we have OJ here coming from a parole hearing coming up real soon. I believe it's on Thursday, July the 20th, and he has his parole hearing regarding the armed robbery that actually took place in Nevada. So we're here, and I kind of just want to talk about this case really quick before we throw back to Campbell. We have O.J. Simpson, who a lot of people are looking at this case, and it's like whenever we think of O.J., a lot of people don't even think about this robbery. We think about the trial of the century. We think about the people versus O.J. Simpson. What are you thinking about this parole hearing that's coming up soon? Well,
I actually think that O.J. Simpson has a chance of getting his freedom back.
Okay.
I think on all accounts from my research that Mr. Simpson has been pretty much a model prisoner in Nevada at Lovelock. Everyone loves Mr. Simpson. I mean, we can imagine that because Mr. Simpson has this personality that's infectious, and everyone has something to say that's good about Mr. Simpson. I've watched various documentaries. They would call it the OJ effect. And in the prison system, I'm hearing that as well, that everyone loves him. Well, not love him, but everyone likes him. He's a guy that most of the prisoners look up to. Mr. Simpson, at his previous parole hearing back in 2013, he talked about how he intervened matters that may have been that caused other inmates to get in trouble. So he was kind of a senior citizen, a grandfather type of person in that environment, and he has never had any disciplinary actions to my knowledge. So I think he's closer to seeing his day in civilian society.
Well, I mean, let's take this into consideration. We have an individual here, O.J. Simpson, who was already came to fame because he was a great football player, and then he became an actor. He also did a lot of sponsorships during a lot of the time in his life. Excuse me.
Right.
But you talked about this O.J. effect. And the O.J. effect, I mean, we've seen it in the documentaries. I mean, he goes from like anybody who meets him in the street, whether it's a fan or anybody else, he just seems to take over. You want to hate him, but you end up liking him at the end of the conversation that you have with him. Do you think that the parole of the individuals during the parole hearing will take this into effect? Because a lot of the times what happens is during the parole hearing, the individuals are taking into consideration what will he do if he is released. So we saw that after he was acquitted of not being I guess guilty for the murders of Nicole Brown Simpson and
Right.
Ronald Goldman, we found that he was acquitted, and then he went kind of on an alternate path, and we see what happens afterwards. Essentially he went in and he attempted to get some of his items back, but he did it in a kind of way that probably wasn't such a good thing. So how do you think that that's going to come to play with the individuals during the parole hearing?
I think that's something you can't get around. O.J. Simpson is O.J. Simpson. He's obviously a big figure, big public figure. And I think what's helpful to him is you would think that he really learned from this situation. O.J. Simpson is much more older. He's 70 years old at this point. He's very young to actually still have maybe a third or fourth act in his life. However, if I'm Mr. Simpson, I would try to convey to that parole hearing that he's more interested in getting back that time with his children that he lost, maybe playing some golf. Nothing, he's a big ticket item. If he gets released, there are gonna be a lot of individuals, a lot of marketers that would want a piece of Mr. Simpson. And that is a concern, a legitimate concern that the parole hearing would want to have is, would Mr. Simpson find himself back into that downward spiral in which he experienced when he was found not guilty, in which the people that he considered friends had pretty much shunned him, and he found a new environment. And that's a great point. That's something that the parole board will be looking at, and that may not be in Mr. Simpson's favor, but he has to present a compelling case that he is now a changed man and he wants to do right.
Okay. Well, let's take a look at this. We know that O.J. Simpson has always been before the media. I mean, kind of took it to his advantage. Like you said, the O.J. effect. He used the media to, I guess, try to portray him in a good light. Right. Now, the media, whether we like it or not, I mean, we're both in the media right now, sort of an opinion was rendered about O.J. after he was acquitted of the Nicole Brown Simpson and Ronald Goldman murders. What role do you think the media has in the parole hearing that's coming up? Do you think that it may, in the court of public opinion, let me ask you this, do you think that the media is going to play a role in how we look at O.J. if he is released?
I don't, of course. I think the media is always going to play a role in O.J. Simpson and if he's released. I think what's important is the parole board itself is not swayed by the court of public opinion, and I don't think they will be. I think they are looking at Mr. Simpson as any other person, and the indication to demonstrate that is what occurred on the past hearing back in 2013. The fact that he was a public figure was no moment to them. He was scored a very low score in terms of being a risk to society, which was to his benefit. So I don't think the media will play a big role at his parole hearing. However, O.J.'s O.J., and we will look at O.J. in a certain light based on him being released. The media will have their own spin to it. You know that. And I think it will play a role in him as a person and what he wants to do as a 70-year-old man.
Well, okay. I can't get away from, you know, the role that the media actually played in OJ becoming OJ, because not only do we have, you know, we have the trial of the century, but so many things have come as a result of this one particular trial. I mean, you have Jay-Z rapping about O.J. Simpson in his latest album, 444.
Right.
You have the People versus O.J. Simpson
Absolutely.
on FX. I mean, how do we take this one particular case, and how can we not expect it to have some kind of an influence in, you know, the individuals who have a say in whether or not he's going to be released?
Well, I think you mentioned an interesting point, because what we had from the O.J. Simpson, and now, you know, like you said, Jay-Z, and as well as the documentary series and the FX show, is now the new generation knows who O.J. Simpson is.
Mm-hmm.
O.J. Simpson was in their living room, on their phone. People who would probably just know of him, now they know the story. So, of course, there's more media hype. The fact that we have this parole hearing, there's definitely going to be much more hype. I don't think the parole board is interested in that. I think the parole board understands that the entire world is looking closely at them, and what information or what demonstration that they're given. If they're going to treat Mr. Simpson as though he's somebody else, they need to treat him as any other prisoner. They see prisoners all the time. What demonstration will they show by saying, let's treat him differently? He's been a model citizen. Mm-hmm. He's paid his debt to society. He's asked what they asked from him. He's given them. He told them he would be the best prisoner they ever had. And on most accounts, he has fulfilled that promise.
Okay. Well, OJ's fame, let's talk about OJ's fame and the impact that may have had on this particular sentence. We know that I believe it's Judge Jackie Glass presided over the charges that he obtained in Nevada, okay? And we see that he was sentenced to up to 33 years in prison for conspiracy charges, burglary charges, first-degree kidnapping, and this is all for someone who had never previously been convicted of a crime. We know that, correct?
Right.
Okay. Well, I want us to talk a little bit about whether his fame had anything to do with this sentencing, because we have to realize that I believe his co-defendant, C.J. Stewart, who was also his co-defendant, he also took a part of this, this incident, the robbery situation over at the Palace Hotel.
The one guy who didn't snitch.
The one guy who didn't snitch, exactly, because we have a lot of co-defendants who actually did decide to snitch or rat, as they would say, and they got little to no time in jail. But C.J. Stewart was actually the one who actually, as people would say, that he took his lick and he decided that he wasn't going to say anything, and he was found guilty. He was actually sentenced to 7 to 27 years, but his conviction was later overturned. And the Supreme Court actually said that his conviction was overturned because of the fact that they believed that OJ's fame had a part to play in the amount of time that he was sentenced. So after that, he actually pled guilty and then spent less than, I think, around 2 years being in jail. Now we go back to OJ.
Right.
We have OJ who was sentenced exactly, I believe it was 13 years to the day that he was acquitted of the murders for Nicole Brown Simpson and Ronald Goldman. And he's sentenced to 33 years, which is kind of coincides with the $33.5 million judgment that was rendered against him.
Yes.
What are you thinking about that? I know Judge Jackie Glass said that it had nothing to do with, his previous conviction, but what are you thinking? Tell me.
I think that had everything to do with his not guilty verdict. I think it only wasn't just O.J. Simpson's fame. I think it was, like you said, the fact that he, on a large amount of people in this world, thought that he beat a double homicide case. And this was an opportunity for the state of Nevada to get back at Mr. Simpson. This was payback. We know this was what it was. However, the charges were severe. armed robbery is a serious charge, kidnapping serious, not only armed robbery, but armed robbery with a deadly weapon. So if you look at the charges in and of itself, it gave the judge broad discretion to come up with a very severe sentence. And that's essentially what the judge did. That's why that sentence was not overturned. If you looked at the facts of the case, the videos, the interesting people that Mr. Simpson was with, he was with a bunch of misfits.
Right.
I mean, this was a funny situation. I couldn't stop laughing at it, looking at the video.
I know, we were thinking it was like Ocean's 11, right?
It was crazy. It did not look like something criminal, right? But I think what Mr. Simpson did when he brought guns, or he advised his friends to bring guns, that changed the entire circumstance.
Okay.
And that gave the judge and even the victims an opportunity to say, this is something serious. The victims had a legitimate fear at the time. So that allowed the judge to say, listen, this is serious. I'm going to go on the record and say, no, this is not payback, but I'm going to give you 9 to 33 years. And we all know by looking at this case and looking at the entire circumstances where all the individuals didn't do any time, only one other person did time. The person who set up Mr. Simpson, this guy got immunity.
Right, Tom Riccio.
So was this justice? And really, I'm looking at the prosecutor's office. They wanted Mr. Simpson. They got Mr. Simpson. They had a jury. The jury wanted Mr. Simpson. The jury came back. I think they came back with a guilty plea on all the counts.
Well, Kenneth, I'm sorry. I think we may be getting some movement back in the courtroom. Are we getting some movement back in the Urick trial? Okay, so we actually have live trial. As much as I love talking about the O.J. Simpson case, I do want to take some time to thank everyone for sitting with us today. I had a great time. We had a great time discussing O.J., even though it was a little bit short, but it's a little tease because Mr. Abrams will be here on Thursday to discuss, provide you with some more analysis. We're going to take you back to the Dr. Urick trial, and thank you so much. Have a great day. And Heather Hansen is up next.
If I can, I want to direct your attention again back to the screen, the Elmo, and I'm handing you what we've marked as Defendant's Exhibit Double B. Do you recognize that photograph?
Yes, sir.
I'm asking you to keep your voice up again.
Yes, sir.
Thank you. Is that a photograph of the Bayliner?
Yes, sir.
And does that fairly and accurately depict the damage that you saw when you came to Ohio and viewed the boat?
Yes, sir.
There's actually an area here where you can sort of see all the way through to daylight, is that right?
That's right.
And did you view that damage also from the top side of the boat down?
Yes, sir.
You had mentioned earlier that some of this fiberglass was pushed back or displaced, I believe. Is that right?
Yes, sir.
Could you see that when you looked at it from the top down?
Yes, sir.
I'm placing on the Elmo and up on the screen is Defendant's Exhibit Double C. Do you recognize that photograph?
Yes, sir.
Can you tell us, please, what's depicted in that photograph?
This is the forward area, the bow of the bass boat. The black objects you see laying on the deck of the bass boat are, I believe, parts of the trolling motor.
Now, on this bass boat, can you tell us, did you observe any marks or striations?
Is that all?
On the bass boat, did you observe any marks or striations?
Yes, sir.
Do those marks or striations tell you anything in engineering terms about what may have happened during the collision between the boats?
Yes, they do.
And can you describe for us the nature of the striations that you saw?
The most prominent striations on the bass boat are actually captured in that photograph.
Okay.
The bow plate I referred to several times is this area in here, this piece. And you can see striations and transfer marks that go in this direction. And they start here and go all the way back to this area and beyond. Some of them are obscured by this mount.
Are these, are they the marks down here where I'm pointing with my pen?
Yes, in that area.
Okay. And you say they go back this way?
Well, they're going, direction of travel is across, but they do go back fairly far on the gun, on the top of the side, to what would be about right here.
And what, if anything, does that tell you about the relative speeds of the boat? The boats, excuse me.
What we get out of that is we get an impact angle, which is, I believe, how the DNR came up with their value, was to measure the angle of those marks relative to the center line. And could you repeat your question, please?
Well, let me ask you another question then. Did your opinions or conclusions vary materially from the DNR conclusions when it comes to the angle that the boats struck each other?
No, sir. My answer was approximately the same as theirs,
okay,
as far as impact angle goes.
All right. And I'm sorry, I don't think I asked you this with regard to double B. Does that photograph fairly and accurately depict the bass boat as you saw it that day when you came up to Ohio?
Yes, with one possible item of discrepancy, and that would be that the precise location of the trolling motor mount and the way it's oriented on the foredeck, that front deck of the bass boat. That wasn't something that was placed in a precise way when I arrived. It looked like it had been broken loose and then just placed there.
Okay. Did you find it in this position when you arrived to look at the boat?
I'm going to say approximately.
Okay. So if I understand it, you and your subcontractor did not place the trolling motor in that position?
I can't tell you for sure for that photograph, but there was a time where we did try to place the trolling motor in what we thought would be its approximate orientation during impact or prior to impact. And we did take some photographs that way.
Let me show you for a second Defendant's Exhibit Double D. Do you recognize that photograph?
I'm not sure I do.
Yeah. Oh, you already gave me permission, didn't you? I'm going to approach that and hand you so you can look at it in person. Defendant's Exhibit Double D.
All right, sir.
You recognize that photograph?
Yes, sir.
That appears to be someone taking measurements of the height of the trolling motor. Is that right?
Yes, sir.
Did you folks take those sort of measurements when you were there?
Yes, sir.
And does that picture fairly and accurately depict what you saw on the trolling motor as you measured it?
Yes, sir.
This is Defendant's Exhibit Double E. Do you recognize that photograph?
Yes, sir.
And tell us, please, what that photograph depicts.
It's a view of the bass boat standing just in front of the bow looking pretty much straight down the center toward the aft end. We can see the effect of the crumpling of the aluminum on the port side of the bass boat in this photo, how it's bulged out. And to some degree it's there on the starboard side as well. On the port side of the bass boat, near the bow, there's a curved section that actually is where that part of the bass boat conformed to the curvature of the hull of the bayliner during what we would refer to as maximum engagement.
And would maximum engagement be when these boats sort of spun around after the initial impact?
It would be as they started to spin around and there was a contact along a fairly broad area of each vessel. And the bass boat, to some degree, you could think of it as wrapped itself around the side of the bow of the bayliner.
And I think you said earlier the bayliner continued on, correct?
Beyond initial contact, it continued to progress relative to the bass boat some distance, yes.
Okay. And does Defendant's Exhibit EE fairly and accurately depict the scene of the bass tracker as you saw it when you came to Ohio?
Yes.
Now, was there anything from what you observed in the scanning that you did that made you able to render an opinion to a reasonable degree of engineering certainty as to whether or not the bayliner actually went over top of the bass tracker?
Yes, sir. I had some conclusions about that.
Okay, can you tell us about those, please?
Yes, sir. It was clear to me that the bayliner did not travel over the top of the bass boat.
What are you basing that on?
Oh, there's a series of things. Some of the most obvious ones are that there wasn't damage to the bottom of the hull of the bayliner that would be consistent with that. Similarly, there wasn't any striations or material transfer on the top surfaces of the bass boat along the gunnels where that contact would have been to indicate that there was an override.
And is that opinion to a reasonable degree of engineering certainty?
Yes, sir.
I'm going to hand you what we've marked as Defendant's Exhibit F. Take a second, if you would, and then tell me if you recognize that.
Yes, sir. I recognize it.
Can you tell us, please, what that is?
This is the report that I submitted to Lynn Merrow's office following my investigation.
And does that report summarize your investigation that you've conducted and testified about here this morning?
Yes, sir.
Do you reach certain conclusions in that report?
Yes, sir.
Are each of those conclusions reached to a reasonable degree of engineering certainty?
Yes, sir.
Now, conclusion 1 has to do with the bass tracker, and you conclude that it's in violation of Rule 15, correct?
So let me catch up to you here.
No problem.
Yes, sir.
And so as not to reinvent the wheel, is that what you've already described to us about this this crossing situation with the bayliner being on the starboard side of the bass tracker?
Yes, sir.
Conclusion 2 has to do with the bass tracker being the give-way vessel and the bayliner being the stand-on vessel, correct?
Yes, sir.
And is that also what you testified to earlier based upon the relative positions with the bayliner being on the starboard side?
Yes, sir.
I want to turn, if I can, to the next page, to conclusion 4.
Yes, sir, I'm with you.
All right. Do you have an opinion to a reasonable degree of engineering certainty as to how the gash in the bay liner that you talked to us about and showed us earlier was created?
Yes, sir.
Can you tell us what that is, please?
It's, as I've described here, it's consistent with the discussion we had earlier about how the gash lengthened as the depth of penetration increased of the bow of the bass boat.
And you have a section headed cause of accident. Do you see that?
Yes, sir.
You mentioned in the second on the things that you told us about today as far as the striations.
Yes, sir. And to some degree, areas where there's a lack of striations.
Now, you've also mentioned that there's a regulation that each vessel on the water is required to proceed safely, correct?
Yes, sir.
So does that include both vessels in this case?
Yes, are you referring to the, basically the rules in the beginning of the NAV rules, which discuss the fact that each operator has a responsibility to take whatever action is necessary to avoid a collision?
Yes.
Yes, sir, we've discussed that.
And so would the bass tracker have an obligation to try to avoid a collision as well?
Yes, sir.
And is that opinion to a reasonable degree of engineering certainty?
Yes, sir, it is, and it's consistent with the navigation rules and requirements.
Just a second.
You may.
I want to jump back, if we can, to the previous page. Do you see conclusion 3 there?
Yes, sir.
You have an opinion about additional lighting, correct?
Yes, sir.
Is that opinion also to a reasonable degree of engineering certainty?
Yes, sir.
Can you tell us what that opinion is and what it's premised upon?
The bass boat, according to certain witness statements, was displaying an additional light on the aft end of the bass boat that was described as a lantern in some reports. So it was described as a fairly bright light that was placed in the aft end of the bass boat. And this light could have made, and I believe would have made, recognition of the bass boat by the operator of the bayliner more difficult.
How so?
When a person stares into a bright light at night, it can make it difficult to see things that are around that light. I believe the brightness of that lantern would have made it difficult for someone some distance away looking at the bass boat from, say, the location of where the bayliner was, make it difficult to see the bow lights, for example.
Could that lantern be confused with another light source?
Yes, it could be easily confused with what we refer to as background lighting, lights on the shore, the street lights, dock lighting.
Is that one of the reasons why boats are required to have, besides the white 360 light, also to have starboard and port lights?
It certainly helps in that regard. One of the purposes for the red and green bow light is to assist in the determination of which side of the vessel you're looking at night and which way it's pointed, which way its direction of travel is. So if you only see the all-around white light, it's difficult to tell which way a vessel is pointing and therefore which direction it's traveling.
I'm not going to ask you, unless you think you know the specifics, but do you know if there are regulations concerning the requirements for visibility of those lights in terms of distances?
Yes, there are.
And you mentioned earlier that you worked at Underwriter Laboratory, correct?
Yes, sir.
Are there procedures where you can test to determine if those lights meet those legal requirements, that is for how many nautical miles from which they must be seen?
Yes, sir.
Speaking of underwriters, was there also an underwriter study about confusion? You talked earlier about confusion between the lantern source and lights on the shore.
Yes, sir.
Objection.
Basis.
Nothing in the report, nothing in his background says anything about this.
Sustained.
If I may, I don't know that he has to list every single authority on which he applies. It's buttressing a conclusion that he isn't.
I'm sorry.
Could you, for
Oh,
Kathy?
I'm sorry, forgive me. I don't know that there's anything that requires him to list every single authority upon which he relies. He does have to give opinions and conclusions, and he's done that, and this study buttresses that conclusion.
May I see the report? It's difficult for me to make a ruling
Well,
when I don't have the opinion that's being tendered.
Do you have that opinion with you, or that study with you, or do you not?
I do not have a copy with me, no, sir.
Not his report.
Oh, I'm sorry. I thought you were asking for the study. Forgive me.
I have the report, I don't have the study you're talking about.
May I see counsel?
Counsel, you may proceed.
Just want to talk to you with reference to your conclusion about the lantern. There was an underwriter study done concerning these other lights on boats, other than what's required by the navigation rules, correct?
Objection.
When I worked for the Marine
Hold on
Department,
one second. Rephrase.
In connection with conclusion number 3, the lantern, have you seen any studies where this particular subject of confusion has been studied?
I've seen related studies.
You've seen,
Related studies that I believe cover the same basic issue.
I didn't hear what you said. What kind of studies?
Related studies.
Related studies? Done by who?
Done by the Marine Department of Underwriters Laboratories and sponsored by the Coast Guard.
And what was the general subject area being studied?
Nighttime visibility of navigation lights on recreational boats.
And did the study report anything in terms of other light sources and the possibility of confusing boaters?
The study noted that the all-round white light of a vessel is easily confused with background lighting, which is lighting on the shore.
That's all I have. Thank you.
Attorney LawNewz.
Good morning, Mr. Beam.
Good morning.
My name is Dawn Cantalamesa, and I'm one of the prosecutors on this case, okay?
Yes, ma'am.
I'm going to be asking you a few questions. First, I had some questions about what you reviewed. And with regard to your background, you don't have any law enforcement experience, do you?
No, ma'am.
No. Were you ever in the Coast Guard?
No, ma'am.
So you never had to patrol the waters or enforce any of these navigation rules?
No, ma'am.
Did you help in writing any of these navigation rules?
No, ma'am.
And you're not a lawyer, that's right?
No, ma'am.
Now, did you look at, you mentioned the U.S. Coast Guard navigation rules. Did you ever compare those to the Ohio regulations with regard to boating laws?
Yes, ma'am.
Okay, so you did look at something else other than the U.S. Coast Guard navigation rules?
Yes, ma'am.
You didn't write that in your attachment A, that you reviewed that. Did you review other things besides what was listed in attachment A?
If it wasn't mentioned, it's either because it was submitted and I became aware of it later in the investigation to where it wasn't something that I relied on to form my conclusions and opinions.
Okay, so you didn't use the Ohio rules to form your conclusions, is that right?
That's right.
Did you go to Berlin Reservoir while you were here inspecting the boats?
No, ma'am.
Okay, so you didn't go check out the scene of the crime, essentially, where this collision occurred?
I have seen it, but I did not see it that trip.
Okay. Did you take any measurements on previous trips at Berlin Reservoir of the opening under the causeway or the measurement from the bridge to the no-wake buoys, anything like that?
No, ma'am.
Did you take any measurements on any previous trips as to how deep the reservoir is?
No, ma'am.
I'm going to show you. What is it up there?
Oh, I don't know.
Yeah, sure.
You may.
Let me see your exhibit there. Can I see this exhibit? Thank you. I turn it back to the page you had. Take that back? No. Hand you what I've marked as State's Exhibit 116, just so we can be sure what we're looking at. Do you recognize that?
Yes, ma'am.
And what is that?
It's attachment A, list of items reviewed.
And that's a list of items you reviewed in preparation for your report?
Yes, ma'am.
And did you type this? Or did you create this?
I created a list.
Okay. You obviously didn't create the things that you used in order to type this list, right?
I don't understand the question.
Okay, so you created this list of items, but it's based on what Attorney Morrow sent you, is that correct?
Yes, ma'am.
Okay. On this list, you list an interview with the witness Robert Cease. And you list that under number 1 and number 5. Do you see that?
Yes, ma'am.
Did you ever review an interview of Dustin Cease?
I reviewed the notes from the interviews that were provided as part of the DNR documentation.
Okay. So, was that interview in there, is what I'm asking.
I don't recall if it was or not.
What about notes from an interview of James Miller? Did you review that?
I don't recall that name.
Okay. On your attachment, you also list some dates of October 1st, 2015. Do you see that on item number 2, statement of Melissa Navy?
Yes, ma'am, I see it.
Is that a date that you're referring to, or is that an additional interview that was done on October 1st, 2015?
That date would likely have been the date that was given on the documentation, the way the DNR presented it.
Okay.
They typically would do an interview, write a summary,
Okay.
and the summary would typically say something like, summary of interview conducted with the person's name and on this date.
Okay. It's not, you didn't go do separate interviews of these people?
No, ma'am, I did not do direct interviews of any of the witnesses or the people involved.
All right. You looked at the reconstruction of a 2-boat collision prepared by Richard McCullough. Do you remember that?
I looked at the reports that were completed by various DNR officers. I
Okay.
don't recall specifically the names of the officers at the bottom of the pages of which name was associated with which report.
Okay.
There were several reports.
And under item number 9, you list Bruce Lindemood statement. You see that?
Yes, ma'am.
Did you review both of his statements, if you recall?
If it was part of the DNR report, I would have reviewed it.
Okay. Did you review any 911 calls, any audio 911 calls?
I don't recall. I was provided with some audio recordings by Ms. Merrill's office. And I don't recall if there was a 911 recording in there or not.
Okay. You do list, however, audio from interviews with Urich after the accident. You did list those, right?
What's the number? Item number?
Number 15 on your list.
Yes, ma'am.
Okay, so you listened to those audio files?
Yes, ma'am.
Did you review any BCI reports with regard to this case?
Can you clarify?
It's Ohio Bureau of Criminal Identification. They would have been as a result of testing that was done. Did you review any of those reports? They would have had the Attorney General's heading on them.
And what was the subject of those reports? What would they have been testing?
DNA, light bulbs, serology.
I do remember reviewing some reports that related to the testing of evaluation of navigation light filaments.
Okay.
I'm sorry, navigation light.
Navigation light filaments.
Okay, that's not included on your attachment, though. Is that right?
If it was part of one of the DNR reports, I would have considered it to be covered by mentioning the DNR report that included it.
Okay. Then, is that the same as the photographs? Did you see the ODNR photographs? Were those included for your review? It was about 300 some odd photographs on the disc.
Yes, ma'am. I reviewed a lot of photographs from the DNR.
Okay. You don't recall if you specifically reviewed the ODNR photographs?
I reviewed a lot of photographs that were identified as taken by the DNR, yes.
Okay. Did you, and this attachment, you also list on number 17 and 18, the U.S. Coast Guard report, research you've done, and the navigation rules. Is that correct?
Yes, ma'am.
All right. Where in this list do you list this magazine that you supposedly reviewed?
I don't see it here. I did draft and submit a supplement.
You did?
Yes.
Oh, and do you have that with you today, a supplement?
I don't have it with my papers here. I did submit it to Ms. Merrow's office.
And when did you submit that?
It was after this report.
Okay.
It was issued as a supplement when I became aware of.
So that was sometime after June 15th of 2017?
Yes, ma'am.
And was that a supplement to your report? Did it change your report? Did you put new items in your report?
Yes, ma'am. It affected the information that I was able to ascertain regarding potential planing speed of the Bayliner.
You know, maybe approach.
You may.
Let's take 10 or 15 minutes.
All rise. Court is in recess.
Welcome back to LawNewz Network. I'm Heather Hansen, and I am here with Kenneth Willis. And we are taking a little break in this Uric case, which is great because it gives us the opportunity to sort of go over some of the testimony from this accident reconstructionist and speak a little bit about what he reviewed and what he didn't review and what impact that might have on the judge. So Kenneth, we've been watching a little bit from the accident reconstructionist who's here for the defense. And
Yes.
the cross-examination started by going through a whole list of things that he did not review.
Right.
What do you think of that? What's the impact of that?
Well, when I think of this, I think of what we learn as defense attorneys. It's called the power of not. And what we do is we pay attention to everything that that expert did not do,
Right.
and we make light of that. And in this case, the prosecutor is going through a litany of things that the expert did not do. She's asking questions, and he's saying, I did not do this, I did not do that. And that, of course, is critical in making an assessment of, in an expert opinion, things you did not consider. I think what was really important is he could not even say that he had his report in terms of the lighting in the magazine report that he relied on, which was, I would think, was significant for the defense, and it wasn't even in his report.
I completely agree with you. You know, one of the things that they're pointing out in the chat room is he did not even go to the scene. If you're an accident reconstructionist and you're asked to reconstruct an accident,
Absolutely.
I would think you'd want to go to the scene, right?
Right, absolutely. I mean, if not him, at least an assistant to go there, take pictures, make some notes. He is basically relying on everything that's provided to him. I think you want to have somebody to be much more hands-on as your expert witness.
Well, and that's sort of the other point, is that we can't really hold this against the expert because experts only review what we lawyers give to them to review. So ultimately this comes down to really the fault or maybe a conscious decision on the part of the defense attorney. Have you ever been in that situation where you've consciously sort of decided what you're going to give to your expert to review and kept some things that you just didn't give him or her?
Yes, I think sometimes there are things that is not absolutely necessary to submit to the expert. The expert has a responsibility to assess everything that's given to them, and certain times, certain evidence can be damaging.
Right.
And so we have to assess that in a sense of, is this favorable to our case? Sometimes it's so important that you get an expert involved so early in the case. And that can be detrimental to you if you wait so long and you don't have an expert that can come and assess the scene right away.
Right.
You understand?
Very good point. Very good point, because we don't know the timing of when this defense expert came on board. I can tell you, though, on cross-examination, if I were that prosecutor and he says, you know, I wasn't given this, I would have said, isn't it important to you to go to the scene? Because worst case scenario, he says, no, that's not important, and that sort of doesn't sound right, given that's your job.
Right.
And if he says, yes, it is important, then why didn't you do it? So it's sort of a win-win no matter how he answers.
Absolutely. I think with the attorney saying it or not saying it, it's almost understood, but certainly her asking that, but sometimes you don't know what that expert can say. He may have something definitive that may explain why he did not go there.
Well, and another reason she may not have asked it is these cases are so different when tried in front of a judge. Some of those sexy, slightly snarky comments don't play as well to a judge as they might to a jury. A jury sort of enjoys that a little bit, especially when the testimony has been relatively dry. Do you think a judge sort of thinks that that's just smoke and mirrors and they want to get down to the basics?
Absolutely, Heather, and I think that's a great point. The fact that this is a judge trial, we have an expert that on a lot of accounts may be very boring, but we know that this judge is paying very close attention to the specific details of this case. And I think sometimes the dramatic effects of the attorney on both sides is not appropriate in this juncture.
Let's talk about, because we were talking about this a little bit as we were watching the testimony. I said that I feel like this is a difficult case for the defense to overcome, and you made a really good point as to what the defense's ultimate goal might be in this case. Tell us what you said about that.
Well, I think the defense is actually making a case that their client was not at fault at all to begin with.
Right.
And I think that is important because I think if you get down to the bottom of this case, the defense wants to at least give the judge a compelling case that this was not on the fault of the doctor where the judge can at least meet maybe halfway, maybe a negligent homicide event. So I think they're presenting facts that perhaps the victim's boat, being the boat being there, there was a lantern on the boat that may have distracted the doctor. That's evidence to show that the victims were more probably at fault.
Right.
And go ahead. I'm
no,
sorry.
and I think that is definitely, we heard so much. I know when Misty was on the other day, they were talking so much about filaments and lights and which light belongs where. And I know so many of our viewers, so many of our chatters are boaters. And for them this makes a lot more sense than it does to those of us. I mean, I've been on boats.
Right.
But I've never, paid a lot of attention to the red and the green. But there's reasons for those rules, and there's reasons that boaters have to follow those rules. And if the victim's boat did not have the requisite lights, that makes a big difference, doesn't it?
Absolutely. This case, the charge that they're pursuing the doctor is, was he impaired by alcohol, and was that a proximate cause of this accident? If the defense can show that there was a cause, an intervening cause that may have caused this accident, then that takes away a successful verdict for the state. And I think the expert is somewhat presenting a solid case for the defense.
No, and listen, he definitely is well credentialed. He definitely has the credentials to speak to this, and he also comes across to me as very honest. I was watching from home this morning when you guys were on, and he was answering the questions in a way that sometimes weren't the best for the defense.
Right.
But definitely building some credibility there. We'll see how hard the DA goes after him on cross-examination, given the fact that he may in fact give her what she needs.
Right.
You know those witnesses who you sort of want to battle with them a little bit and go a couple rounds and they just kind of fold?
Right. Well, this you brought up an interesting point, because there was one period in which the experts stated that the boat where the victims were on was not going fast. Or it may not have been going at any speed at all. It may have been sitting idle.
Right.
And that was a showing of, okay, I'm being honest. I'm not giving all my facts swayed in favor of the defense. At the outset of his credentials, he testified that he gave testimony for the state and the defense in his history.
Yeah.
So that's critical for a defense lawyer, to make sure you present someone who's been on both sides.
Let's talk about the defense's ultimate goal, because one of the things that I think is very important in this case is the fact that this defendant happens to be a doctor.
Yes,
and
absolutely.
We were talking about this as well, and we've talked about this before, I think last week when I was on, that he might lose his license to drive, but he also could lose his license to actually practice medicine. How much do you think that's playing into the overall defense here?
I think that's absolutely important. That is as important, or if not more important, than the actual outcome of the case. If the defense can present a case where this is not a felony, perhaps this may look more favorable to the doctor, and it's just a misdemeanor. And I think that may not be said for the defense, but that's what they're looking for. Maybe this is not a conviction outright on the felony, but possible a lesser included offense.
And that's such a huge distinction, Kenneth, because if you are a professional, a nurse, a doctor, any of those, for the most part, in general, across the United States, your conviction of a felony has to be reported to the state board. And then the state board will then investigate whether or not to take away your license to practice.
Yeah.
So, it's smart. Here, Dr. Urich has a phenomenal, very well-known, very well-respected defense attorney, Lynn Marrow. And I'm sure that she sat down with him and said, what is the bottom line here? What are we aiming for? And if that is to save your license, what's the best way to do that? Because the license isn't automatically taken away for the most part, generally. There has to be a hearing in order for that to happen. So no matter how this case comes out, chances are Ms. Merrill will be defending him, or someone from her office in front of the state board as well. When you have a case like that where you know you have another case coming up with the same defendant with the same facts, are you extra careful with the record to make sure that the things that everyone is saying are consistent with your defense in the next case?
Absolutely. It's sort of preparing for two cases at one time.
That's right.
You're thinking about how this affects when we present our position before the board. And as you stated, when the doctor may have sat down with the lawyers and they ask, what's the bottom line? you're assessing this case, thinking about both cases at the same time, because you know once it's in the record, it's no taking it back.
That's right. That's right, and it can be used in a subsequent case. So you definitely have to be, and especially if your client's main goal is to be able to practice medicine.
Yes.
You know, so you've really got to go for that hearing and keep that hearing in the back of your mind, step by step throughout the case. Now we're going to continue to hear from Miles Beam. He'll continue on cross-examination, and I have the feeling that it might be a little bit of time on cross-examination before he's done. Do you think the defense will call more witnesses? And if so, I know that this is just reading tea leaves, but what types of witnesses would you anticipate if you were defending this type of case?
I wouldn't be surprised if the defendant in this case testified.
Tell us why.
Well, this is a bench trial, right? And I think the judge may want to consider his story, what occurred. I think there's one the judge cannot undo, and that's the fact that he has knowledge that the blood alcohol. Now the judge threw this out,
right?
And we have reason to believe if it was thrown out, then potentially it was tainted,
right?
Given the fact that it was not in the refrigerator. But that evidence is almost like unringing a bell.
I agree
right?
with you.
The judge knows about it, and so that's always in the back of his mind. Was the doctor actually impaired?
Right. And his blood alcohol level was, according to the test, which was thrown out, although there's been a lot of argument about the fact that it was thrown out because it was by the statute that sort of may be outdated. Right. But if you believe the blood alcohol level, it was high. It was to the level where he was drunk. So if you're defending the doctor and you want him to say, oh, I just had a few beers, that's a little bit dangerous given that the judge knows that number. Right. Even if he's supposed to not know it, there's no way that a judge can just sort of disregard something that's already in his head.
Absolutely. And so I think the doctor has to be able to explain that, yes, I may was drinking, nothing close to the level of it had me impaired, and there were facts to suggest that he probably wasn't. There's no indication that, I think one of the lieutenants testified that he wasn't disoriented. Right. He was walking at the time of the scene, no slurred speech. Right. So all the indicators that this person was probably impaired was not present, even though they had the blood alcohol content test.
Yeah, it's going to be an interesting decision whether or not they call Dr. Urich, because from all accounts, you know, he doesn't have a very smiley face, but from all accounts in that community, as I read the articles about it over the weekend, he's a very well-respected surgeon. His patients like him. If you look up his grades on health grades and those types of things, they all say that he's very pleasant and very patient and very sympathetic and empathetic with them. So he probably would present fairly well.
Absolutely.
But you do have to be careful with that blood alcohol, even though, as you said, it's a bell that cannot be unrung. And by any judge, as much as they may want to.
I think it's there. It's already damaging, so I think it cannot hurt him. Certainly you have to be concerned. I'm always concerned when I'm putting my client on the stand, but I think in this case, a doctor well-respected, I'm sure he's well-spoken. I think he can conduct himself. The defense are hoping that he can conduct himself accordingly, but I think that may very well be helpful to him.
Yeah, I agree with you, and we'll see what happens here. It's going to be interesting. They've been having a discussion about something to do with this accident reconstructionist report and what he did and did not review. So it'll be interesting to see whether or not there's been some ruling based on that discussion. And it sounds as though there seems to be a little bit of movement back in the courtroom. But in the meantime, we are back in the Campbell case, and this is a case that you guys may not be right in the middle of your thought process because we haven't covered it live on the channel, although it's always been available. But this is the case against Eric Campbell, who's accused of killing an older couple with his father. His father then killed himself in jail. And one of the interesting things in this case that happened last week is the father, before he killed himself, admitted to police officers that he did the killing of the elderly couple and that his son had nothing to do with it. That statement thus far has been precluded by the judge. So we're going to take you back to that courtroom so that we can get a sense of what's going on. I will bring you back to Urich when that's live because I know we're all invested in that. But let's touch into Campbell and see what's happening so that we can continue to follow that case throughout the week ahead.
And State's Exhibit 388.
This is a receipt from CVS Pharmacy, dated December 28, 2014. The address here is Suwanee, Georgia.
Is that the same place that the map is from?
Yes, ma'am.
And number 389, what is this?
This was a piece of mail we located in the front of the Suburban there as well. And you can see the obvious address there is Hillsborough, North Carolina.
And what is the road there?
Pronounced Huff Road.
May I approach?
Yes, ma'am.
I'm showing you what's been marked as State's Exhibit 506. Do you recognize that, sir?
Yes, ma'am. This is an evidence bag containing the maps and receipts that were found in the front floor and seats and on the console.
And that was of the Suburban?
Yes, ma'am.
And did you package it in this bag?
Yes, ma'am.
And has it been in the care, custody, and control of the Greenville County Sheriff's Office since then?
Yes, ma'am.
Does it appear to be in substantially the same condition as it was when you bagged it?
Yes, ma'am, it does.
No, the state would ask that Detective McPhee be allowed to open 506.
He met this,
Do you recognize the contents of State's Exhibit 506?
Yes, ma'am. These will be the items that were collected from the center console and front floorboard of the Suburban.
And are there a few things here that weren't in the pictures there?
Yes, ma'am.
And where exactly were they found?
In the center console.
We are back live in Urich, so we're going to take you right back to that case and finish up the cross-examination of the accident reconstructionist.
Let the record reflect that I have had an opportunity to review the supplement to the report that was prepared by Miles Bean. I have provided a copy of that supplement to counsel for the state of Ohio, Attorney Cancela Mesa.
Your Honor, the state requests that we move to strike any portion of Mr. Bean's testimony with regard to his minimum planing speed of 10 to 13 miles per hour that he testified before on direct. First of all, that part was not in any of his reports. It was my plan to just ask him about it on cross, but now that he has this whole section where he actually called Bayliner after our trial started, the day Mr. Ford testified and Mr. McCullough testified, got more information from Bayliner, brought in this indication, all this information he got from both tests and both U.S. I'd ask to strike it, Your Honor, as not being a discovery, as not part of his report. It's not anything that we have time to go and discredit at this point. It's prejudicial to the fact that we don't have any time to go see if this has any clout to see if we could discredit these numbers, to see if we could look and see if there's any other places that these could be found in order to ask this witness about these numbers.
Thank
I
you.
can't even properly cross-examine the witness about it.
Attorney Uhas, Attorney Morrow, any reply?
Thank you, Mark. Mr. Bean's original report indicated that he disagreed with the assessment from Mr. McCullough's report with regard to planing. Mr. McCullough's report, in part, relied upon a phone call he made to Dayliner about minimum planing speed. This email appears to have been received by us yesterday on the 16th, according to the top, and as we indicated at the sidebar, Attorney Uhas and I opened this email, did not realize it was a supplemental report. We thought it was an email with additional information for us for trial preparation to review with him. He is an engineer. They knew he was an engineer from the inception of us disclosing him. Did not hire an engineer to refute any engineering standards. What this supplement does is simply buttress its additional authority to buttress his original opinion that he does not believe you can say to a reasonable degree of engineering certainty this boat was unplanned. For those reasons, one, I do not believe there's prejudice to the state. They were aware that was his opinion. He specifically in his report indicates the ODNR report is flawed in its methodology. I think it is entirely reasonable and consistent for an expert in engineering to keep reading journals and articles and seeking out additional information. It is labeled supplement to his report, and for that reason, Sunday morning when I read it, I should have read it more thoroughly and produced it when we got here this morning. It was an oversight. I thought the email was to provide additional information to counsel to review for a trial. But they knew there was an engineer testifying, so as far as refuting the calculations and numbers, I don't believe their choice to not hire an engineer prior to trial should now be an issue to claim prejudice. And again, his initial report very clearly indicates he did not agree with the methodology of the state's expert on planing.
I've had a chance to review the original report dated June 15th of 2017 that has been marked as Defendant's Exhibit FF. And again, for the purpose of the record, I'm going to mark this supplement that is now under discussion, if counsel has no objection, as Court Exhibit Number 1. I think, reviewing it, that the Court Exhibit Number 1 does more than provide additional authority for the opinion. It, in fact, adds an additional conclusion or opinion that was not contained in the original report. There is reference that the DNR spoke with the Bayliner tech who said that they could not provide a minimum planing speed. I agree with Attorney Morrow that Mr. Bean has testified that the data relied on by the state's expert to render an opinion is flawed, but there's nothing in Mr. Bean's original report that references the conclusions reached in this supplement, specifically the time to 30 miles per hour at 10.9 seconds, the time to plane at 3.8 seconds, and the conclusion that the estimated speed of the boat in 3.8 seconds is approximately 10.5 miles per hour. So Rule 16K requires that the written report and summary of qualifications of an expert shall be subject to disclosure no later than 21 days prior to trial, and that failure to disclose the written report to opposing counsel shall preclude the expert's testimony. As it relates to this additional supplement and the conclusions reached in it, I am going to sustain the state's motion to strike that portion of the testimony from trial and not permit any testimony regarding or contained in this supplement that's been marked as Court Exhibit 1. Attorney Cantalomesa, you may proceed.
Thank you, Your Honor. Mr. Beam, did you review any weather reports with regard to the date in question, May 9th, 2015?
Not weather reports, but I did make note of the weather-related check boxes on the DNR's reports where they noted visibility, wind, weather, waves, so forth, temperature.
Do you recall what the weather conditions were according to the DNR reports?
They indicated the clear visibility, winds were calm.
Did the DNR reports indicate a time of the collision?
Yes, I believe they did.
Do you recall what time they said it was?
It was after midnight.
Okay, so it's dark outside, correct?
Yes.
Did you review any, I don't know what it would be called, like a water level report or anything that's produced to show whether the water was rising or lowering in that Berlin Reservoir, anything like that?
No, ma'am.
Okay. What about any coroner's reports? Did you review those?
I don't recall.
Okay. What about coroner's photographs? Did you review any of that?
No.
LawNewz, I need you to speak up. I'm losing you.
No, I didn't review those.
When you're doing an accident reconstruction, you're trying to recreate that same situation that happened during the collision, isn't that correct?
Well, reconstruction is a term that we use in our world for understanding what happened and being able to study the evidence to see what happened.
Okay. And being on the water is a lot different situation than it would be being on a roadway, correct?
Yes, ma'am.
There's no...
In what regards specifically are you asking about, though?
Well, like there's no skid marks on the water, like you can't measure skid marks or see exactly where something occurred.
Object to the form of the question.
Isn't that correct?
Overruled.
Go ahead.
As an expert in analyzing boat collisions and establishing relationships of impact between two vessels, I would say that the skid marks, if you want to call it that, are on the boats themselves.
Okay, so there's nothing on the, like there's nothing on the waterway, you know, that you're measuring.
There's nothing permanent that's left behind. In the short term, there's some wreckage on top a lot of times, and there may be pieces of boats or even an entire vessel that is sunk near the point of impact.
But you don't have any information, do you, that there was anything like that in this situation?
In regards to sinking of a vessel or any debris pulled from the bottom, is that what you're referring to?
Yes.
No, I don't have any of that.
Most of your conclusions in your report have to do with the navigation rules, don't they?
Many of them do, yes.
Okay. Do you have to be an engineer to understand those navigation rules?
I don't believe so, ma'am.
And in fact, there are a lot of law enforcement officers who have to enforce those navigation rules who aren't engineers, correct?
I would say so, yes.
When you talked about Navigation Rule 15, did you look to see if Ohio has a comparable Rule 15
yes,
with regard to crossing situations?
I did.
And do they?
Yes, ma'am.
Okay. Now, does a crossing situation with regard to Navigation Rule 15 apply to vessels in sight of each other?
Yes, ma'am.
And are vessels at night considered in sight of each other?
I want to ask you to rephrase your original question.
Okay. Are vessels, is nighttime, let me ask it this way. When it is nighttime, is there a different set of rules with regard to navigation? Not a different set, but maybe you might look to supplementing those rules or looking at the general responsibility rule.
The biggest difference regarding nighttime is the requirements for displaying the appropriate navigation lights.
Did you see in what you reviewed multiple witnesses who talked about the navigation lights on the Bass Tracker being on?
Objection.
Overruled.
There were comments made by some of the witnesses regarding navigation lights being on.
And you said you saw that BCI report with regard to the filament testing of the light bulbs from the Bass Tracker?
Yes, ma'am.
And those appear to be working light bulbs, correct?
Objection.
I don't recall the specifics of the report. I did review it at the time.
Okay. When you have a crossing situation with regard to Navigation Rule 15, does that apply at nighttime if you have vessels that aren't in sight of each other?
To my knowledge, the rule applies
Okay.
regardless of whether you're in sight of another.
When you're on the waterway at night and can only see a navigation lights of another vessel, can you tell whether that vessel is crossing or not?
Yes, ma'am.
You can? What do you do to tell that?
If you're in a situation where another vessel is crossing or is to your starboard side, you will see the red portion of the navigation of the red-green light on the bow. You will see the red side. If you are the giveaway vessel, you will see the red. And a lot of times that's taught as, you see the red, that indicates danger. That means you need to get out of the way.
Okay. Does that apply in every situation? Should the vessel to the port side of the starboard vessel always give way to that starboard side vessel?
Objection.
Overruled.
Can you give me a specific scenario?
Okay. Let's say in our situation,
Yes, ma'am.
we have the Bass Tracker, right?
Yes, ma'am.
And you have the bayliner coming. Is it always that the Bass Tracker should give way if this is a crossing situation? Is that absolute right that he has to stop and give way to this vessel?
I'm not aware that Rule 15 states any differently.
Okay. What about if say this isn't a Bass Tracker, say this is a big freighter in Lake Erie. Does a big freighter have to make way or give the right of way to this little bayliner
Objection.
coming in this direction?
Objection.
To the original question, I certainly know where this is going. It's overruled.
Go ahead.
There are a number of clauses and explanations in NAV rules that apply to.
Could you keep your voice up? I'm sorry.
That apply to situations that could be covered by what you're describing.
So you're saying there's fallback rules, right?
I'm saying there's rules that could cover situations as what you're mentioning.
Okay. And one of those, you already mentioned that general responsibility rule. That's in the navigation rules as well, right?
Please refresh my memory.
Well, you've mentioned before that all boats have a duty to act responsible on the waterway, to look out where they're going, to maintain a safe speed, and be responsible on the water. Is that correct?
Did I say all that today? Are you saying? I don't recall all
I don't
that.
know if it was in those words.
Sorry, Counselor, I'm just having a hard time remembering what you were saying I said.
What is Rule 2?
I don't recall the specific wording. Could I see it?
I'm going to hand you State's Exhibit 117. I'm sorry, it's not bound there. Do you recognize that?
Yes, ma'am.
Can you tell us what that is?
The cover says Navigation Rules and Regulations Handbook.
And is that part of what you reviewed in order to write your conclusions in your report?
I reviewed the navigation rules that were published on, I believe I referenced a site in my list of attachments that were on a Coast Guard site.
And is that from there? Does that look familiar?
I'm aware that the Coast Guard publishes a book that has the NAV rules in it.
Okay. And you can't tell that that's printed from that website? That that's that same website and location you gave on your report?
It's a bit unwieldy.
There.
I just want to look at the first few pages if I might.
Okay. Let me take the rest. Okay.
May I see counsel when the witness is looking for that?
For the record, there is significantly more cross-examination, so I think it's a good opportunity for our noon recess. We'll see everyone back here at 1:15.
All rise. This court is in recess.
Welcome back to LawNewz Network. I'm Heather Hansen, and we are on a lunch break in the case against Dr. Joseph Urich, but we are live in the case against Eric Campbell. That is the case involving a son and father who went on a cross-country rampage, and the father has since killed himself, so the son is on trial for the death of the Faulkner couple who were killed during the course of that rampage. We're hearing now from a detective who recovered some evidence from the scene, including a notebook. I'm going to take you live to that trial, and then we'll discuss and catch up on that Campbell trial during the first break. So catch up with the Campbell trial, and we'll be back during the first break.
This was, as soon as you open the rear area behind the driver and passenger, this will be the middle seat. There's actually another row of seating in this vehicle as well. But this just shows you just how packed this vehicle was. These are obviously tubs. Here is the hose basket I referred to earlier that's poking between the front seats. It's just how much stuff they have in here.
And states number 401.
We started taking close-ups, of course, of each area. Here you've got some food, some mud. This appears to be the top of some type of pump sprayer, cast iron skillet.
States 402.
These, again, we just take photos of certain areas. We have a plug here. We have items that were taken out of this back seat. There were some IDs and more paperwork that were taken out from there.
And when you say IDs, what sort of IDs were taken?
This, I believe, is where I got the passports from, and they were turned out to be, if it's the passport, is that the passports belonging to I believe they were an Israeli one.
And I'm sorry, what did you say about the passports?
I believe they belong to an Israeli woman.
And do you know where they came from?
Yes, ma'am.
And where did they come from?
Mr. Hilson's house.
I'm showing you what's been marked as State's Exhibit 510. Do you recognize that?
Yes, ma'am. These are the miscellaneous passports that were in the pocket of the front passenger seat.
And did you package them in this packaging when you collected them on January the 13th of 2015?
Yes, ma'am.
And does this packaging appear to be in the same or substantially the same condition as it was in on that day?
Yes, ma'am.
Has it been in the care, custody, and control of the Graham County Sheriff's Office?
Yes, ma'am.
I would ask that Detective McPhee realize to open State's Exhibit 510.
Yes, ma'am. Do you recognize the contents there?
Yes, ma'am. These are the passports that were taken from the seat of that Suburban in the passenger.
And I would mark these as State's Exhibit 510A, which appears to be, what is 510A?
Appears to be a North Carolina driver's license.
510B.
Also a North Carolina driver's license.
What are the names on these driver's licenses?
I'm not sure how you pronounce the first name. It's spelled T-S-A-F-R-A, Safra Shalev, S-H-A-L-E-V.
And State's 501C.
Also a North Carolina driver's license.
501D.
This is a passport.
And who does it belong to?
It also belongs to Ms. Shaloff.
And 510E.
Also a passport belonging to Ms. Shalev.
510F.
Another passport belonging to Ms. Shalev.
510G.
It is an ID of Ms. Shalev, but it is in foreign writing.
510H, I, and J.
H is a passport belonging to Ms. Shalev. I appears to be an older passport as well of Ms. Shalev. And J as well, a passport belonging to Ms. Shalev.
And did you take individual or did you take pictures of those passports?
I do not remember. I did follow up with the North Carolina ID.
I'm sorry, what did you say?
I followed up with the North Carolina ID just to check the welfare of this individual.
And what did you find out?
That she had been deceased for 5 to 7 years, somewhere in that neighborhood.
And I'm showing you State's Exhibit 443. Is this how they were packaged?
Oh, yes, ma'am. This is how they came out of the back seat.
And State's Exhibit 444.
These are the passports and IDs as we spread them out on the table there, yes, ma'am.
And State's 445.
This is the close-up of the North Carolina ID showing her name and the driver's license number.
And State's Exhibit 403. What is this?
This is another photo of the back seat area, just overall photos. We've got the blue totes in here that just packed everywhere. Some with this, some with that. You also have a sleeping bag on top, and again the clothes basket.
State's Exhibit 404.
This will be the driver's side rear. In other words, the door behind the driver's door. You can see again, everything in the place is packed. You have mud everywhere. You have another blue tote here. You had some food items. You also have a black, looks like a shaving kit case there.
And did you open and take pictures of the contents of the shaving kit?
Yes, ma'am, we did.
And I'll draw your attention to States 405. What is that?
This is the contents of that Chevy kit when we opened it. Appears to be various pill bottles.
And I'll draw your attention to States 406. What are those?
Close up again of the pill bottles. You have Jerome Faulkner's name on this particular prescription.
Do you notice the name on the other prescription?
The other name is from CVS Pharmacy, and it appears to have the name of Edward Campbell.
Showing you States 407. Do you recognize that?
Yes, ma'am. This is from the passenger side behind the driver again. This will actually be a third row of seating underneath these items here. Again, this is just how packed it was. This is the front passenger seats. Your rear passenger seats will be underneath all of these items. You have a boot, you have a green case in there, the black coat.
So just for clarification, when you say this is the passenger seat from the driver's side, are you looking in from the driver's side of the vehicle when you are taking this picture?
That is correct. This will be the second door. You have the driver's door open, and then you have the passenger driver's door open. So this is where he's taken from.
And did you look in the black coat there?
Yes, ma'am, we did.
And did you find anything in it?
We found paperwork, yes, ma'am. A handwritten note here, yes, ma'am.
And States Exhibit 408, is you say that's what you found?
Yes, ma'am.
And States Exhibit 409, do you recognize that?
Yes, ma'am, I believe that's the other side.
The other side of that same paper?
Yes, ma'am.
Your Honor, may I approach?
Yes, ma'am.
I'm showing you what's been marked as States Exhibit 511. Do you recognize that?
Yes, ma'am.
And what is it?
This is the scrap of notebook paper taken from the pocket from the coat, middle row of SUV.
And that's what you see here?
Yes, ma'am.
And did you package it on January the 13th of 2015?
Yes, ma'am.
Does it have additional markings in addition to yours?
Yes, ma'am. Also from the North Carolina State Crime Lab.
And has this been in the care, custody, and control of the Granville County Sheriff's Office except when it went to the State Crime Lab that you know of?
Yes, ma'am.
Is it in substantially the same condition as it was when you packaged it?
Yes, ma'am.
Your Honor, the state would ask that Detective McPhee be allowed to open States 511.
Yes, ma'am.
Now we'll mark this as 511A. Do you recognize it?
Yes, ma'am. This is the note in question, also photographed there.
Your Honor, the state would move to admit States Exhibit 511 and 511A into evidence.
Yes, sir.
Your Honor, I would ask if Detective McPhee could hold up 511A.
Yes, ma'am.
Now, Detective McPhee, it appears that the paperwork 511A may be look a little bit darker or dingier.
Yes, ma'am.
Why is that?
The State Crime Lab attempted to pull fingerprints.
Were any able to be pulled?
Not that I'm aware of.
So there were no identifiable prints?
No, ma'am.
And drawing your attention to State's Exhibit 408, does that appear to be one side of that paper?
Yes, ma'am. It'll be this side.
Okay, and if you can read, starting sort of in this picture midway, and read what that says to the best of your ability.
First one where it says belt, then you have nurse uniform, you have spear, gig, Vaseline, plaster, alginate. On the right side of that, you have John Hilson Hillman, March 5 B-Day. Underneath that, you have the word telescope, the word sword, the word glasses, soldering gun, and solder.
And is there something else written there?
To this side?
Yes, sir.
It says eat, fix, light, and clean. Here's to say clean ship car.
And on the other side, not the other side, but the other half of that paper,
yes,
can you tell what that says?
The first one is 2223 W Bay Area Boulevard, Webster, Texas. I'm sorry, Webster, I'm not sure the state. Zip of 775898 and the number 2214. Several other phone numbers, or appear to be phone numbers, all down through there. And then again, it appears to be an email address, possibly eacampbell65 at edge454@hotmail.com.
And drawing your attention to states 409, is that the back of States Exhibit 411A?
Yes, ma'am, it is.
And drawing your attention to the top of that, what do you believe that that says?
Appears to say the word bank, and then cash, 550, BOA, jeweler's check, local, cash 700, Holly check, need old tax record. I'm not sure of the symbol there in her SIG, which I would mean signature. And then did my DL come, want spinners, make more.
And then the next paragraph there, what does that say?
What did we discuss up there in the forest? Specifics and base plan.
And what's the next line?
Why the interrupt in me?
Could it say interest?
Why the interest in me? Yes.
And this is what's written on the back there of States 511A. Is that correct?
That is correct.
Drawing your attention, sir, to States Exhibit 410, do you recognize that there on the screen?
Yes, ma'am. This is a photo taken of the rear of the Suburban as we opened the hatch.
And States 411.
This is a close-up of photos I take when, as soon as we opened it up. This appears to be an old metal bucket. These appear to be the tops of propane lanterns, the type that you would screw a propane can onto.
But there's no propane can on it?
No, ma'am, no propane cans visible.
Do you see any mud, same kind of red dirt clay?
Yes, ma'am, as you can see, you have the red dirt clay throughout.
States 412.
This is a close-up of what appear to be file paper boxes, or copier paper boxes that you would use to hold papers, personal and otherwise.
States 413.
This is the right side of the Suburban, close-up of some photos. You appear to have some type of tool bag here. Clothing items on the right-hand side as well. An empty drink bottle.
Detective McPhee, when you unpacked this Suburban, did you find a bag that had clothing in it?
Yes, ma'am.
A black trash bag?
The trash bag here contained clothing inside of it as well, underneath all the other items.
Were there several black trash bags in there that contained clothing? In one in particular, if I can draw your attention to State 414, as you unpacked that, did you find these two items?
Yes, ma'am. These items did come out of the black trash bag.
And what are they, or what do they appear to be to you?
This appears to be some type of possibly a jumpsuit, and of course a pair of tennis shoes.
Detective McPhee, I'm showing you what's been marked as State's Exhibit 512. Do you recognize that, sir?
Yes, ma'am. This is the green jumpsuit in question taken from the Suburban. That's photographed up there.
And did you package it there in that bag, and are those your markings?
Yes, ma'am.
And other than, are there some other markings on there?
Yes, ma'am. State Crime Lab.
And did you put this in the evidence with the Greenville County Sheriff's Office?
Yes, ma'am.
And other than those markings, does it appear to be in substantially the same condition as it was when you sealed it up?
Yes, ma'am.
On January the 13th?
Yes, ma'am.
Your Honor, I would ask that Detective McPhee be allowed to open State's Exhibit 512.
Yes, ma'am.
And do you recognize the contents there?
Yes, ma'am.
And what is it?
The same clothing that was photographed there on the table.
So this green jumpsuit,
Yes, ma'am.
and I would mark this as 512, Your Honor, 512A, and ask that 512 and 512A be admitted into evidence.
Need Jackson? Move the line.
Judge, and ask that Detective McPhee be allowed to hold this up in front of the jury.
Yes, ma'am.
Do you notice anything that seems to look like what you described as chemical residue that you also saw in the
A
truck?
large portion of the leg is what appears to be the chemical residue, also of the mud.
If you could show the back, sir. Thank you. And I'm showing you now, Detective McPhee, State's Exhibit 513. Do you recognize that, sir?
Yes, ma'am. These are the white New Balance tennis shoes found in the black trash in the back of the black trash bag in the back of the SUV.
And did you package them in that bag there?
Yes, ma'am.
Those are your markings?
Yes, ma'am.
Did you put it in the evidence room of the Greenville County Sheriff's Office?
Yes, ma'am.
Are there some other markings on here?
Yes, ma'am. The North Carolina State Crime Lab.
But other than that, does it appear to be in substantially the same condition as it was when you were arrested on January 13th?
Yes, ma'am.
Your Honor, I would ask that Detective McPhee be allowed to open States 513.
Yes, ma'am.
I'm going to mark. Well, what are these?
These are a pair of white New Balance tennis shoes.
Are these the same that are in the picture there?
Yes, ma'am, they are.
I would mark the left shoe as 513A and the right shoe as 513B and move to admit 513, 513A and B into evidence.
Jackson.
Yes, sir.
I would ask that Detective McPhee hold these up.
Yes, ma'am.
And if you can show the soles of those shoes as well, sir. I would draw your attention also to the tongue of the shoes. And do you notice anything on those?
The side.
I'm sorry, the outside?
The New Balance, but they also have the symbol for breast cancer.
Breast cancer awareness?
Yes,
the pink ribbon?
Yes, ma'am.
Do these appear to be support shoes?
Yes, ma'am.
Perhaps the kind that a nurse would wear?
Exactly. These are made for New Balance walking. It says so inside.
State's Exhibit 415, I would draw your attention to that photo. And what does this describe?
These are a pair of brown boots. Continuing to that black trash bag here, these are other items focused on the black trash bag. Brown boots, green glove. I think this may be a sock, maybe another, I'm not sure.
May I approach? Detective McPhee, I'm showing you what I've marked as State's Exhibit 514. Do you recognize that, sir?
Yes, ma'am. These are the brown boots that were located in that trash bag as well.
And did you package them and seal them in that bag?
Yes, ma'am.
Are those your markings there?
Yes, ma'am.
Are there additional markings?
From the North Carolina State Crime Lab.
And other than that, as it is substantially the same condition as again, and you collected it and packed it?
Yes, ma'am.
I would ask that Detective McPhee be allowed to open 514.
Yes, ma'am.
Welcome back to LawNewz Network. I'm Heather Hansen, still here with Kenneth Willis, and we are taking a little break to fix something on our feed. And while we do that, we want to talk a little bit about this testimony that it sometimes seems sort of laborious. Yes. Somebody pointed out that every time he opens these packages, it's like, hurry up, hurry up. But explain to us why it's important for them to get this in this way.
Well, I think the state is presenting their case, and they're telling the story, and every evidence really matters. And as boring as it may be, they still have a case to prove. This evidence that they're presenting is significant in terms of supporting the story as to what actually occurred. So this is the state going step by step through the process.
Okay, it looks like we're back, so I'm going to, is that right, guys? Okay, so I'm going to throw it right back to, as he continues to go through the shoes and the notes and everything that was found in the back of that SUV. Kenneth and I will be back to discuss all of this during the first break.
drawing your attention to State's Exhibit 416, the picture that's on the screen there. What do you recognize that, and what does it show?
This is the new balance shows that were entered earlier, but you also have one green, appears to be some type of cotton glove.
Did you collect that?
Yes, ma'am.
May I approach?
Yes,
I'm showing you what's been marked in State's 515. Do you recognize that?
yes, ma'am. This is the green work glove, the right back trash bag of the SUV.
And did you package it?
Yes, ma'am.
Did you seal that package on January the 13th of 2015?
Yes, ma'am.
Are there any markings there?
Yes, ma'am.
Are there additional markings?
Yes, ma'am, from the State Crime Lab.
Did you put this in evidence at the Granville County Sheriff's Office?
Yes, ma'am.
Other than going to the crime lab, has it remained in the care, custody, and control of the Granville County Sheriff's Office since
Yes, ma'am.
then? I would ask that Detective McPhee be allowed to open 515.
Yes, ma'am.
Do you recognize the content?
Yes, ma'am. This is the green glove in question. Also has the photo.
And it's other than, are there some markings, additional markings on this glove?
Yes, ma'am, from the State Crime Lab.
And except those, is this in substantially the same condition that was in when you collected it?
Yes, ma'am.
Your Honor, the state would move to admit States 515 and 515A into evidence.
Need that, just for your mention addition, that apply.
I would ask the detective to hold that up for the jury.
Yes, ma'am.
In drawing your attention, sir, to State's Exhibit 417 on the television screen there, what is that?
Continuing on, this is some more clothing. This appears to be a gray shirt and a pair of blue jeans.
And State's 418. What is that?
This would be the blue jeans in question that we just removed as well.
And did you collect those?
Yes, ma'am.
May I approach? I'm showing you what's been marked in State's Exhibit 416. Do you recognize that?
Yes, ma'am.
I'm sorry, 516. Do you recognize that?
Yes, ma'am. These are the signature Levi's, the black trash bag in the back of the SUV.
And these is the same that's pictured here in State's Exhibit.
Yes, ma'am.
Are there additional markings on here?
Yes, ma'am, from the State Crime Lab.
And other than those, is this substantially the same condition it was when you collected it?
Yes, ma'am.
And you put it in the Granville County Sheriff's Office?
Yes, ma'am.
Other than when it to the lab, the crime lab, as far as you know, has it been in the care, custody, and control of the Granville County Sheriff's Office?
Yes, ma'am.
State would ask that Detective McPhee be allowed to open State's 516.
Need that.
And do you recognize the, well, I'll wait till you actually open it there. Do you recognize the contents of State's Exhibit 516?
Yes, ma'am.
And what is it?
These are the blue jeans in question, also photographed here.
They appear to be in substantially the same condition that they were when you collected them?
Yes, ma'am.
Your Honor, the state would move to admit State's Exhibit 516 and 516A into evidence. And I would ask that Detective McPhee be allowed to publish these.
Motion to addition evidence is allowed. Mr. Public is allowed.
If you can hold them up in front of the jury, please, sir. Do you see on those jeans at the bottom there what is similar with what you called the chemical residue that you saw earlier?
Yes, ma'am.
And I would draw your attention to the front part of these jeans. Do you see that same chemical residue?
Yes, ma'am.
And where do you see it?
In the front part,
Yes, sir.
on the knee and on the front pocket. On both pockets are where your hands would go. And then a little bit lower on the knees as well as near the cups.
If you can walk and show that to the jury, please. And what about the back? Do you see any of that chemical residue there on the back?
Yes, ma'am. On the cup, along the middle of the seat of the back.
And drawing your attention on the screen to States 419, what is that?
Give me a photo of that T-shirt we saw, or not T-shirt, the actual shirt we saw earlier. We noticed some markings on it up here in this area as well, so obviously wanted to flag it.
States 420.
The close-up of the substance that was on the shirt.
May I approach?
Yes, ma'am.
When you show what's been marked for State's Exhibit 517, do you recognize it?
Yes, ma'am. This is the gray shirt taken from the black trash bag in the back of the SUV.
And did you package it there in that package?
Yes, ma'am.
Your markings on there?
Yes, ma'am.
Are there any additional markings?
State Crime Lab.
Other than that, is this in substantially the same condition as it was when you collected it?
Yes, ma'am.
You put it in the evidence of the Granville County Sheriff's Office?
Yes, ma'am.
And has it remained there as far as you know, except when it went to the lab?
That is correct.
I would ask that the Detective McPhee be allowed to open State's Exhibit 517.
Yes, ma'am.
And I would mark the content as 517A. What is that?
This is the gray shirt that we have photographed here that was taken from the trash bag.
And is it in substantially the same condition as it was when you bagged it?
Yes, ma'am.
Your Honor, the state will move to admit State's Exhibits 517 and 517A.
Need Jack. Motion to addition evidence allowed.
Permission to publish.
Yes, ma'am.
have a seat there, Detective. Drawing your attention back to well, actually, just drawing your attention to State's Exhibit 421. What is that, sir?
This was another travel bag that was taken out of the back of the SUV.
And did you look inside of this travel bag? It appears there's some pill bottles in there.
Yes, ma'am. There was all kinds of medication bottles and jewelry also inside.
And drawing your attention to State's Exhibit 421. I'm sorry, 422. What is that?
Some more photos of inside the box. As we took the medicine bottles out, you could see the jewelry that was attached down inside of it.
Did that all appear, or most of that appeared to be women's jewelry?
Yes, ma'am.
And how deep is this bag?
Bag is probably at least 10 inches, 8 to 10 inches deep.
How deep is the jewelry in there?
A couple of inches.
So did you sort of have to scoop down
Yes,
to look what was in there?
Yes, ma'am.
Show you State's Exhibit 423. Is that a better depiction of that?
Yes, ma'am. Just a different angle. You can see down inside of it all the different costume jewelry and some jewelry still in containers and boxes as well.
Did you find any badges in there?
Yes, ma'am, we did.
What kind of badges?
I believe there was Granville County EMS as well as Cornwall Fire Department badges located inside here.
And State's Exhibit 424?
Some of those items we've taken and laid out.
And those were inside of that travel bag?
Yes, ma'am.
I'm going to zoom in on several of these, if you can describe what you see.
Obviously, you had some photos, keys, some quarters, small jewelry boxes. I'm not sure of the pin, but you had captain's bars, more keys. This is a lensatic compass, and of course, you've got some medication here from Jerome and Dora Faulkner. You have a baby bracelet over here on the right with the name Faulkner on it as well.
Does that appear to have blue? The baby bracelet is blue?
Yes, ma'am.
State's number 425.
Some more of those, the close-up of the medication. You can see this one has Dora Faulkner's name on it. This one has Jerome. And Dora again, Jerome, and Dora. This will be Dora Faulkner, Tramadol. And this one will be Jerome Faulkner, hydromorphone.
State's Exhibit 426.
More items taken from the rear. If you went back to the very first picture of the top, this would have been that black bag on top with the yellow handles.
Oh, is this pocketbook back there as well?
Yes, ma'am, it was underneath this bag as well.
And State's Exhibit 427.
This is obviously a firefighter bag, it's also known as a jump bag, would have their turnout gear in it. Whenever a fire come out as a volunteer, you would have your stuff ready to go, so you could just grab your bag and go. You never know what you're going to get till you get on scene, so you're not going to take the time to dress till you get there.
And drawing your attention to the black bag there, what was the contents of the black bag? Just more miscellaneous?
This one had more personal items and stuff from the Faulkners, yes, ma'am.
And State's Exhibit 428. Do you recognize that?
Yes, this is inside that bag, but it's also been placed. It has ammunition for pistols and rifles. You have 22 long and shorts. You have 12 gauge. You have 38 special. You can see some of the shotgun shells in the background. This is the first responder light that you would stick up on the dash when you're en route to a call.
Under the light there, does there appear to be some sort of sheath?
Underneath this light?
Yes, back towards the top of it there.
Oh, yes, ma'am.
Perhaps housing a knife of some sort?
This would be your knife case, yes, ma'am.
States Exhibit 429.
Close up of the same bag, as you can see the different various. You got 22 long rifle, 22 short, 38 specials, your knife sheath again, your light, toilet paper.
States Exhibit 430.
This came out of the back of the SUV as well, and it's pretty self-explanatory. It's a small air compressor.
Is there an air compressor in that box?
I don't believe so. I don't remember.
States Exhibit 431.
This is after removing all the tubs and boxes out of the rear of the vehicle. As you can see, we still haven't even got to the third seat area. It's still packed full. Here we have 2 rifles in cases, a box containing blue gloves. This is some type of metal rod. We never really did determine what. They also have what appears to be the bolt from a crossbow in here.
May I approach?
Yes, ma'am.
Detective McPhee, I'm showing you what's been marked but not admitted as States Exhibits number 206 and 207. First with 206, do you recognize that, sir?
Yes, ma'am. This is the same gun case that was taken from the back of the SUV.
And did you place it in a separate bag, or did you just actually tag?
No, we just tagged this and kept it like that.
So you put your markings on this particular piece of evidence, is that correct?
Yes, ma'am.
And what did you do with this after you got it? Did you put it into evidence at the Graham County Sheriff's Office?
Yes, ma'am.
Has it been in their care, custody, and control as far as you know?
Yes, ma'am.
Is it in the same or substantially the same condition it was in when you collected it?
Yes, ma'am.
Your Honor, the state would move to admit State's Exhibit 206 into evidence.
Any objection?
And Your Honor, I would ask to open this.
Yes, ma'am.
Okay.
Should be on the
206A, and do you recognize it?
Yes, ma'am.
And was it inside of 206 when you collected it on that day?
Yes, ma'am.
And is it in substantially the same or similar condition it was when you got it?
Yes, ma'am.
Your Honor, the state would move to admit State's Exhibit 206A.
Any objection? No allowed.
And I'm showing you State's Exhibit 207. Do you recognize that, sir?
Yes, ma'am. This is the same gun in the black case that you can see in the photo there.
And do you recognize your markings on that?
Yes, ma'am.
Did you place that into evidence of the Graham County Sheriff's Office?
Yes, ma'am.
Does it appear to be in the same or substantially the same condition it was in when you collected it?
Yes, ma'am, it does.
Your Honor, the state would move to admit State's Exhibit 207 into evidence.
Any objection?
and ask that Detective McPhee open it.
Yes, ma'am.
What are these that are contained in the bag?
The bullets.
Was this weapon loaded when you found it?
I believe this one was. Yes, ma'am.
And so are these bullets that you or someone from the sheriff's office cleared from the weapon?
That is correct.
And is that states 207A? Do you recognize that gun?
Yes, ma'am.
And was this found in 207 and found in the Suburban?
Yes, ma'am.
Does it appear to be in substantially the same condition as it was when you found it?
Yes, ma'am, it does.
Your Honor, the state would move to admit states 207A into evidence.
Good, Jack. The motion to introduce and act line.
Is there a medallion or some sort of medal on that gun?
Yes, ma'am, there is.
And what does it say?
It says 150 years of progress, Illinois Sesquicentennial.
I would ask that if you put that back into the bag.
That's fine. Ladies and gentlemen, we're going to take our lunch and recess at this point. During our lunch and recess period, it is your duty not to talk among yourselves about this case. It is you not to talk to the parties, the witnesses, or the lawyers about anything at all. Further, did you not to talk to anyone else, allow anyone else to talk with you or say anything in your presence about this case. If anyone communicates with you in any way, in any fashion, you need to let the sheriff know about it.
Welcome back to LawNewz Network. I'm Heather Hansen here with Kenneth Willis, who has been nice enough to sort of stick it out with me today as we heard a bunch of unwrapping of evidence. There's not a whole lot there for us to work with as far as, analyzing the evidence. It's really just been showing it to the jury. I do, though, want to talk to you about some of the chemicals on the pants. The prosecutors seem to be focused on, are they in the back of the pants or the front of the pants? Evidence like that sort of gets put into context with later witnesses, right? Sometimes that jury just sees something and doesn't know the meaning until they hear more about it later on.
Right. You have to put things in chronological order, and it'll make sense, maybe not now, but just give it some time and everything should come together.
Well, that is a very good segue into what I want to do next, which is about O.J. Simpson, who has been given some time in jail and is now facing his parole hearing on Thursday. We're very excited about this. I know that everyone is eager to see this hearing on Thursday. Our own Dan Abrams is going to be hosting here at LawNewz Network. But right now what we wanted to do is show you his last parole hearing, which was very interesting when I watched it for the first time myself last week. We'll show you that. We will bring you back to the Uric case as soon as they're live. I know a lot of you are invested in that case, as I am. But for right now, let's go to the O.J. parole hearing from the last time. This is not from 2017. And then Kenneth and I will discuss it a little bit.
Simpson.
Correct, yes.
All right, and your Nevada Department of Corrections ID number for the record, 102-7820.
Correct.
I am Parole Commissioner Susan Jackson, and with me is hearing representative Mr. Robin Bates.
Good morning. Good morning.
And Mr. Bates and I are a panel to hear you for your first parole hearing before our board, and we are hearing you today on case number C237890, counts 4, 5, 6, 7, and 8. Count 4 is a 26 to 120 month sentence for burglary with a firearm or deadly weapon. Counts 5 and 6 are kidnapping 1; those are 60 to 180 month sentences. And count number 7 and 8 are 2 60 to 180 month sentences for robbery. You are eligible for parole on these sentences on the 2nd of October of 2013. Projected expiration date currently is the 6th of May of 2016. If you were to be granted a parole by our board, it would be to a consecutive sentence. There are 4 running concurrent, all of which are 12 to 72 month sentences for use of a deadly weapon enhancement. Is that your understanding?
I believe so. 4 that are running concurrent.
That is correct, sir. The consecutive sentences are running concurrent as well.
Okay. Yes.
Okay. About a month ago, you received notice of this hearing and advisement of rights through your caseworker. I'm going to put that document up on the screen and ask that you would please verify your signature.
My signature.
All right, thank you. That indicates to our panel you've been properly noticed for this hearing today, and we can go ahead and continue on. And so with that, Mr. Simpson, is there a statement that you would like to make to our panel today?
Yes. You know, I arrived here at Lovelock nearly 5 years ago, and when I met the then warden and Miss Megan and Mrs. I can't think of Carpenter, they told me what was expected of me here, and I gave them my word that I would try to be, or would be, the best prisoner they've ever had here. And I think for the most part I've kept my word on that. I've not had any incidences, despite all the stories in the tabloids and everything. I haven't had one incident since I've been here. I think on a daily basis I speak to more inmates and COs than anybody here. Inmates tell me their stories. Some of them tell me their crimes, and as far as burglary, which I'm here for, or robbery, I should say, they've told me every kind of story you can hear. Guys who have robbed banks, have robbed casinos, even one guy who robbed a gun shop, which I thought took a lot of guts. The difference between all of their crimes and mine is they were trying to steal other people's property. They were trying to steal other people's money. My crime was trying to retrieve from my family my own property that had been stolen from me, and property that since I've been here at Lovelock, the state of California's judiciary has ruled was my stuff, and I have it back now. Make no mistake, I would give it all back to these guys. They can have it all to get these last 5 years back. They've been somewhat illuminating at times and painful a lot of times. I've missed my 2 younger kids who we worked hard getting through high school. I've missed their college graduations. I've missed my daughters, my sisters, I should say, funeral. I missed all the birthdays and various things. When I went to that place that night, I had already discussed it with my kids. I spoke about it with my sister and brother-in-law, older sister and brother-in-law, who were originally going to go with me up until the last hour. I even talked to 2 lawyers about it. One the night before that I knew, and had a conversation with a lawyer that day who I didn't know. I had no intention. My intent was not to rob from anybody. I knew both of these guys who had my stuff. I was a little upset with them, and I think I wasn't as civil as I should have been. I brought some guys with me who I didn't really know, and one I didn't trust, and that's on me. For that, I've been here for 5 years, and all I could do about it since I've been here is be as respectful and as straightforward as I could be with the staff here at Lovelock, and do my time as best as I can do it. I am sorry for what has happened. I have spoken at length to both of the victims. They've apologized. I've apologized. I know their families. They know my families, and I just wish I had never gone to that room. I wish I didn't. I wish I'd have just said keep it and not worry about it. Other than that, you know, I'm just sorry that all of this had to happen.
All right, thank you for your statement. We are going to take a look at your risk assessment. That is a guideline that we use here at the Parole Board. It is a statistical instrument giving us an indication what kind of a risk you would be, and also a recommendation that the board does consider. It is similar to what you went over with your caseworker to prepare for this hearing today. It's an important document. It's important that it's accurately scored, and I want to go over it with you factor by factor. All right? Okay, your age at first arrest was how old?
61, maybe? 60 or 61.
Okay, the PSI indicates that in 1994 you were arrested at the age of 46.
We're talking about this case?
No, the age at first arrest, even as a juvenile. How old were you the first time you were arrested, for any reason?
I think about 46, yes.
Okay, no juvenile arrests then?
No.
Okay. You've had no revocations of supervision, either of probation or parole. You were retired, and that is considered full-time employment in the 12 months prior to incarceration. The instant offense is a property conviction, so we've scored you for that. How about substance abuse? Did alcohol contribute to this instant offense in any way or manner?
You know, it could have. I was celebrating a wedding, and I had been drinking all day. I didn't feel that I was drunk, but I also didn't feel that I was capable of driving an automobile and would not have driven an automobile. That's why I was looking for someone to take me.
Okay, and has substance abuse been a problem in your past at all, or caused a serious disruption in functioning for you? Okay. Currently you are 66 years of age?
Yes.
All right, and you are not a gang member. The NDOC does not have you validated as being a member of a gang. I do see that you have done some programming. Have you had an opportunity to do any long-term program?
No, I think I've done the victim impact. I'm listed on the commitment to change. I've been waiting to get into that, and I'm listed at this point on the waiting list. And I'm told that some of the programs they have here, I don't qualify for yet. But I've been outside so long programming.
Right. We note that you've had no disciplinary write-ups. That is expected by the board, and we appreciate the fact that you have not had any disciplinary write-ups there at the institution in Lovelock. And you are in medium custody currently at Lovelock. You score 3 points on the risk assessment instrument, which is in a low-risk category. And we take the guideline risk and couple it with the offense severity of highest. And the guideline recommendation for the board is to consider factors. So we are going to be considering aggravating and mitigating factors. Aggravating factors in your case are the impact on your victims here, as they did fear for their safety, and also incurred a substantial financial loss. Mitigating factors are you have been disciplinary free during your term of incarceration. You do have multiple consecutive sentences that are yet pending, and you have no conviction history in your criminal history. So if we were to parole you to your consecutive sentence, what would be your plan? What do you plan on doing there?
I continue to work the way I am here, take what courses are available to me. Once again, I would take the one that I'm waiting for now, commitment to change. I find the courses somewhat educational, even though at times it's tough to hear some of the other guys' things, but it has been somewhat educational for me. And I would probably take the AA course, just more to help my kids, when the day comes that I get out, and just to understand it better. I've never have taken any kind of AA or NA courses.
All right, Mr. Bates.
You're approaching 5 years now at Lovelock. Tell us about your work assignments. How have you occupied your time for the past 5 years?
When I first came here, I was a porter, which comprised of cleaning things in the unit that I was in. And basically, after a relatively short period of time, I started working as a gym worker, where I help supervise the activities in the gym. I start each day disinfecting workout equipment in the gym, mopping floors with the other group of us that work in the gym. I've coached teams since I've been here. And I like to say we won the championship, and we were old guys and a totally mixed group of players. I didn't play, I just coached. I umpire games, essentially. That's what I do. Also, because I guess my age, guys come to me. I'm sure the powers here know that I advise a lot of guys, and I've like to feel that I've kept a lot of trouble from happening since I've been here by getting involved in some conflicts that some of the individuals here have had. But essentially, that's what I do.
We talked about your future plans as far as programming, and you said that you're on waiting lists for programming at Lovelock. If you were granted a parole, do you have any plans to request a transfer? Is there some other place that you'd like to be in the Department of Corrections?
No, I found that I, to some degree, feel lucky I ended up here. As to some extent distasteful as some of the majority of the crimes are that's here, I find that there's no stress. I find that there's virtually no gang activity happening here. And honestly, I feel respected to some degree by most of the inmates here, and they, as I say, come to me at times for advice and to talk over their problems.
Thank you.
Thank you. Mr. Simpson, I'd also like you to know that there are 2 letters of support that are contained in your file, one being written by Dr. John Rouse. He's written a letter of support. And your eldest daughter wrote a letter of support to our board on behalf of your 4 children.
No. Well, understand that I have worked diligently to keep my kids out of the media over the years, to the point where most people wouldn't recognize my kids other than my oldest daughter. And even though they all wanted to come here, I was told there was a lot of media was going to be around, so I asked them to write a letter and not to come.
All right. Before we excuse you and deliberate on your case, is there anything that you would like to consider or anything else that you would like to say today?
Other than what I've said, I wish this wouldn't have never happened. When something's done by friends, I think in my case it hurt me more than the actual fact that they had these things. The fact that guys that I knew their families, they've eaten at my home, and maybe that upset me more and made me less civil than I normally would have been under those circumstances. But I will reiterate that at no point did I go there to take any property from anybody that didn't belong to me, and that's no excuse, probably by the way we acted, by the guys that I brought with me and the way we acted when we were there. I really regret that. I've had that conversation, this conversation with both Bruce and Beardsley, and we, for the most part, has put it behind us. But I am just sorry that I had to send the state of Nevada legal system through all of this, because I know it's not been fun for the people involved, as much as it's not been pleasant for me.
All right, and you would agree this had some great impact on your victims in this case?
Yes. I think it has.
All right. Mr. Bates and I will deliberate on your case today, give a recommendation to the full board. It does take a majority of 4 of the 7 commissioners to grant or deny parole. An order is then forwarded to your caseworker and should have results within about 2 weeks. Okay?
Well, thank you.
Thank you.
Good luck.
Thank you.
Welcome back to LawNewz Network. That was old testimony from O.J. Simpson at his parole hearing. I think that was in 2013. And we have the new parole hearing coming up on this Thursday. Kenneth, I know you discussed this with Stephanie earlier this morning, but I do want to talk to you a little bit about not only his chances, but also some of the answers that maybe he could give a little bit differently to improve his chances.
Right.
So first of all, I think that you said this morning that you think he has a pretty good chance of getting parole on Thursday.
Yes, I think so. OJ, even in this hearing, has demonstrated exceptional behavior as a prisoner. I stated earlier, on all accounts, he appears to be a model prisoner. He seems very focused. He seems like he is on a mission to be released and to be granted parole. I have no reason to believe he has not maintained that behavior since his last parole hearing. So I think he has a good chance of being release. However, O.J. Simpson is O.J. Simpson,
That's right.
So you just never know.
Let's talk a little bit about that focus, because you talked about it this morning with Stephanie, and I heard you say something like he may have 1 act, maybe 2 left in him. He's 70 years old now, right?
Yes, absolutely.
So if he does have 1 act, maybe 2 in him, and those acts bring in some financial reward, that would actually be beneficial to the Goldman family and the Brown family, correct?
Yes, it would. But you have to remember, O.J. Simpson, as skilled as he was as a football player, he has been dodging the Goldman family in terms of satisfying that judgment. That's one of the reasons why he is, he was living in Florida. Florida has that shield against judgments on putting liens on houses. And so he has an opportunity to make much more money than he's scheduled to make. He has a $25,000 pension, which is a pretty good sum of money, but definitely has an opportunity to make much, much more. However, the Goldmans are relentless, and they're coming for him, and they're going to be watching every move he makes, and he has to be careful, and if he wants to make more money, he has to understand he has a judgment to satisfy as well.
Yeah, I mean, it's going to be interesting to see what he does. He does seem in that hearing to want to help people, and he says that he's helped the people who are in prison with him.
Right.
When he talked about, I asked you this while he was testifying, he said he would want to take an Alcoholics Anonymous course to help his kids. I thought that was interesting. What was your take on that?
I think part of Mr. Simpson wanted to say, I don't need that.
Right,
But I think he understands who he's in front of, so he has to somewhat use that opportunity for his advantage. I think he was talking more so to be proactive to his children. In the event they had a drug alcohol problem, he can be somewhat of an intervener, just as he's been in prison.
Right, and he wasn't adamant that alcohol didn't play a role in his crime. In fact, he said he had been drinking all day and knew that he wasn't in a place where he could drive. But at the time of his conviction, I don't think that was a major part of the defense. Did you remember it being so?
I don't. I think the defense probably did not want that to make an issue. That probably would have made it much worse for him if that could actually be possible.
Right.
But
we're going back to Uric. I just want to do bottom line. Your prediction, and mine I think, is that he will likely be released on Thursday.
Yes, but he has to walk a fine line once he gets out.
Agreed, 100%. Thank you, Kenneth. We're going to take you right back live to the Uric trial. They are back. The accident reconstructionist is back on the stand in cross-examination. We'll be back during the next break.
Before break, I was having you look at State's Exhibit 117. Do you have a working knowledge of the U.S. Coast Guard navigation rules?
I have a knowledge that I would say is equivalent to what a boater would have.
Okay.
I'm not one who is, I don't consider myself to be an expert in all the finer points of navigation rules.
Okay. So you're not an expert on those rules, correct?
I have some knowledge of them, but I wouldn't say that I have an in-depth expertise on all the fine points, no.
Okay. So you would have to look up those rules just as anyone else if you were looking at a certain fact scenario. Is that right?
I'm sorry, can you rephrase that? I'm not sure I understood what you said.
You would have to look up the rules just as anyone else would if you were looking at a different fact scenario. You'd have to look up rules.
It depends. I mean, there are some rules, some situations I know the rules for.
Okay.
And there are some I would look up, yes.
So, do you know what Rule 5 is?
If I knew the title, I might know the content, but I don't specifically have the rules memorized in order by head.
Doesn't Rule 5 describe the proper lookout required?
Like I said, I'd have to look it up to verify that.
Okay. And in this scenario, is there something called a stand-on versus a give-way vessel?
Yes.
What is the stand-on vessel?
Stand-on vessel is the vessel that is obligated to maintain course and speed.
Okay. And what is the give-way vessel? What does that mean?
The give-way vessel has the obligation to yield, to stay out of the way of the other vessel.
Are there any exceptions to this stand-on vessel in the rules that they should have to deviate from maintaining course and speed?
Well, there are some situations where a vessel that is encountering a larger vessel which is restricted in its ability to navigate, say, in either shallow water or a narrow channel,
Okay.
You know, should not interfere. You know, for example, if I'm on a small boat on a river and a freighter is coming toward me and he doesn't have room to get out of the way, I don't, you know, the rules don't allow for or require that freighter run aground and ditch this vessel on the shore in order to not run over the small motorboat.
Right. Okay. So the stand-on vessel would have to avoid that collision or avoid that give-way vessel in that situation.
The stand-on vessel is, by definition, the vessel that has the obligation to continue on its maintained course and speed.
But there are exceptions you just talked about, right?
Well, in those exceptions, I would rephrase which one is, I guess, stand-on and which one is the giveaway vessel.
I'm sorry?
By definition, the stand-on vessel is the one that, you know, maintains course and speed. If you present a situation where you have what you describe as an exception, then the stand-on vessel in one situation is no longer the stand-on vessel in another.
Okay.
So,
are you familiar with the Rule 17? Actions by stand-on vessels?
I've read it.
I'm sorry?
I have read it.
Okay. And doesn't that say when, from any cause, the vessel required to keep its course and speed finds itself so close that collision cannot be avoided by the action of the giveaway vessel alone, it shall take such action that will best aid to avoid collision? Doesn't it say that?
I don't have it memorized. I'd have to read it.
Does it sound familiar?
Yes.
Do you have any reason to doubt what I just read to you is in Rule 17?
Let me put it this way. I don't rely on my ability to memorize navigation rules. Those kind of things I would look up. And in fact, if you don't mind, I'm going to ask you to show me what you just read.
I'm sorry?
I'd like to see what you just read.
Okay.
In context.
May I?
You may.
You see number 117 in front of you? I'm going to show you Rule 17. So page 27 shows Rule 17. Can you review that for me?
Yes, ma'am, I've read it.
I'm sorry?
Yes, ma'am, I've read it.
You've read it? Okay. Do you agree that there are exceptions to the stand-on vessel?
I don't know if exceptions is the word I would use, but there are certainly scenarios where the rules allow for each operator to take the best action possible to avoid a collision.
And that's like in Rule 8, correct? Actions to avoid a collision? Are you familiar with Rule 8?
I believe so.
Can I show you that rule as well?
Sure.
May I?
You may.
I'm showing you now page 17 of State's Exhibit 117. Do you see that?
Yes, ma'am.
Do you see Rule 8 on that page?
Yes, I have Rule 8.
Does Rule 8 talk about actions to avoid collision?
Yes, ma'am.
So a lot of these rules talk about being responsible boaters and making sure that each boat is looking out for something in the way of that boat. Isn't that correct?
Yes, ma'am.
Okay. When you talked about the crossing situation in Rule 15, does that apply to boats only in sight of each other?
I believe there's two sections.
Go ahead. Go ahead.
There's two sections that are, I guess I would call them headings in the rules. One is which, a set of rules that apply under the category of when vessels are in sight of each other, and another set that's under a heading of rules which apply regardless of visibility.
Okay. And what rule is that?
What rule is it that says that?
Yes.
I'm just saying that it's the way that they're organized in some of the NAV rules publications, that it's just headings they're under. It's not a rule per se. It's the way they're broken up.
But do you agree that you can only see if you're in a crossing situation when you're in sight of the other boat?
Yes, unless you're on a larger vessel equipped with radar or something of the sort.
Right.
But for smaller recreational boats, yes.
Okay, we're talking just about boats that aren't equipped with radar, just by boats that you have to be able to see one another, correct?
Sure. Yes.
And this collision happens at night, correct?
Yes, ma'am.
Now, when you talked in your second conclusion about both vessels being underway, and underway simply means that they weren't anchored, correct?
Aren't anchored or tied fast to a pier or dock.
Okay. And so you talked that you agreed with Rich McCullough's report that the bass tracker was either not moving or moving very slow. Is that right?
Yes.
And you didn't have anything else to tell you other than that? Tell you anything else other than that, right?
I didn't have anything else to tell me. I'm sorry, I don't understand your question.
You didn't have anything else to tell you that it was moving fast, that the bass tracker was moving fast. Everything you did and everything you reviewed said the bass tracker was either moving slow or sitting still. Is that right?
That's a fair statement.
Okay.
I didn't find any evidence that would indicate to me that the bass tracker was traveling at a high rate of speed.
Okay. Did you have evidence to suggest that the bayliner was moving at a high rate of speed?
Define what you mean by high rate of speed for me.
Over the speed limit. Did you have anything to suggest that the bayliner was traveling over the speed limit?
And you're referring to the specific numerical value of what value?
Miles per hour.
Yes.
Do you know that the speed limit on that reservoir at night is 10 miles per hour?
Yes.
Okay. And did you have any evidence or anything that you reviewed which suggested that that bayliner was going over 10 miles per hour?
I didn't have any physical evidence that I felt was something that I could, show by calculation or with, specific objectivity to come up with a specific value.
Okay. You said before that you had the defendant's statement, correct? The audio files of his statement?
Yes.
And in that statement, how fast does he say he was going?
I don't recall him saying a specific number.
You don't recall him saying that he was going 25 miles per hour?
Now that you mention, I think I recall him saying that he was pretty sure he wasn't going over 25.
Okay. And that he was going at 25 or below 25, is that right?
Well, that would be another way to phrase what he said. It means the same thing.
Okay. Did you ever measure the distance covered by the bayliner going at 25 miles per hour?
I don't know what you mean by measure the distance.
Could you tell me how far he would go in distance-wise at 25 miles per hour?
Well, sure, I could tell you that.
Did you that's right, you weren't at the lake, right? You didn't go over to the reservoir?
Objection. This won't be testified.
Sustained.
Did you go to the reservoir in relation to this case?
Am I allowed to answer? Or?
Yes, you may answer this one.
I did visit the reservoir.
And when did you do that?
Yesterday on the way in. I stopped and surveyed the area from the bridge.
Did you take any measurements from the campground to the bridge?
No.
But you didn't do that, you didn't visit the lake prior to writing your report?
No.
Why is it that the speed limit at night on the water would be so low?
Objection.
Sustained.
Do you know why they lower the speed limit on the water at night?
Objection. Can you really testify as to why somebody else set the speed limit?
I think this is beyond the scope of this witness, so the objection is sustained.
In conclusion number 3 in your report, you talk about the lantern. Is that right?
That's right.
I'm sorry, did you answer?
Yes, ma'am, that's right.
You talked about the lantern in that conclusion. Do you recall listening to the defendant's statement about seeing any lights that night?
My recollection is that Dr. Urich didn't see any lights on another vessel prior to the accident.
Okay. So from what you remember him saying he didn't see any lights prior to the collision. Is that right?
That's what I recall.
Yes. Yes. You keep trailing off. If you could try to keep your voice up.
Yes,
thank you.
You measured the height of the stern light. Is that correct?
I measured the length of the stern light pole.
The length of the pole. Were you able to see how far it projected out from the stern deck? Did you put it in that socket that was in the back?
I did.
Did you measure that?
I don't know that I measured it after it was in there. It was a fairly short socket, so after measuring the pole, I didn't measure it again.
So if you could then tell us how long the stern light pole was, the 360-degree light.
I don't recall the number.
You know, do you have it anywhere in your, do you have it, any notes or?
Not on anything I have with me.
Okay. Is it depicted in a photograph that you took as part of your investigation?
It should be, if it was visible, which I recall that it was, laying on the deck surface, it should be part of the scan data, so it should be in, its dimensions should be recorded in the scan data.
Okay.
Yes.
I'm sorry, I'm going to show you State's Exhibit 15. I know you're holding something. Do you recognize that?
The card or the item you're holding?
The item I'm holding, not necessarily the card. Does it appear to be that stern light that you measured when you went out for your inspection?
It will be. It's an all-around white light on a pole.
Okay. When you went out for your inspection, did you also see the lantern?
Yes.
I'm going to show you State's Exhibit 6. Does that look to be the lantern? Does that look familiar?
Yes, it does.
Okay. Can you tell us for the record, is State's Exhibit 115, the stern light, taller than State's Exhibit 6, the lantern?
As it sits on that table, yes.
You talked about the bass boat violating Rule 20. Is that correct?
Yes. Yes, that's correct.
You said rules concerning lights shall be complied with from sunset to sunrise, and during such times no other light shall be exhibited. except such lights which cannot be mistaken for the lights specified in these rules, or do not impair their visibility or distinctive character, or interfere with the keeping of a proper lookout. So people are allowed to have other lights as long as they don't impair the required navigation lights. Isn't that correct?
That's one of the clauses.
Okay.
It's one of several. There are several conditions that are listed that allow that.
Okay. What are the other conditions?
Shall not impair their visibility or distinctive character or interfere with the keeping of a proper lookout.
Was this a night of restricted visibility?
According to the DNR reports, the visibility was good that night.
Right.
It was at night, and it is common sense that it's not as easy to see as clearly at night as it is during the day.
But there was no fog, right?
There's no mention of any fog or mist, no.
Or rain, correct?
That's right.
Isn't restricted visibility also defined in the rules?
Yes, I think it is.
Would you say that there's, being an engineer, there's a difference in the circumference or the size of these two lights?
Well, certainly there's a difference in the size of the two enclosures, if that's what you're referring to.
Yes. Well, we've already talked about the difference in height, correct?
Yes.
And so there's a difference in the circumference of these lights, the enclosures?
Of the containers, if you want to think of it that way, the housings.
You make a conclusion in your report, don't you, that the lantern must have blinded the bay liner. Isn't that correct?
I'm looking to see my wording because I don't think I used the word blinded.
Okay. Page 2 of your report, last paragraph.
Okay.
Okay. Did you use the word blinded?
I did.
And tell me again, do you remember what the defendant said about seeing lights?
Recollection is that he didn't see any lights prior to impact.
So you didn't have any information to base your conclusion in that paragraph, that he was blinded by the lantern. Did you?
Only 50 years of life experience that have shown me over time that it's difficult when there's a bright light at night to see objects that are, nearby, very close to it or around it.
Okay. And when did you see this light at? What time of day was it?
When I saw the lantern?
Yes, when you saw the lantern.
I saw it. It was daylight.
Okay. And so in your 50 years of lifetime experience, it's your experience that someone would be blinded by that light at night and then drive into it?
Objections to the compound form.
Rephrase.
Mr. Beam, is it your experience through your 50+ years, plus all your professional experience, that someone would be blinded by that light at night?
I would phrase it as saying that the ability to see clearly objects that are in the immediate vicinity of that light would be difficult to see the details of. And that bright light could be very difficult to ascertain its precise location.
Okay, so and then through your experience and training and whatever else, it's your conclusion that someone would drive into it?
When lights are viewed on the water reflects and refracts light much like a strong mirror, but with the waves making it somewhat unpredictable as to the ability to tell exactly where a light is. And when you combine that with background lighting on shore, it can be very difficult to tell where the light is. It can be easily confused with the light on shore, and the distance that it is from you may not be apparent.
And would his speeding have slow his reaction time in order to correct himself about that light?
Objection.
Would you repeat the question?
Would his speeding have anything to do with his ability to correct himself with regard to that light?
Objection.
Would you rephrase?
You've already said that it's your experience that someone might confuse that light because it reflects on the water. So someone has to take extra time, don't they, in order to kind of deduce where that light is coming from?
That's often true, yes.
I'm sorry?
That's often true.
Okay. So you need the extra time to make a good judgment about where that light's coming from if you see it out on the water, don't you?
Objection.
Would counsel approach?
Mr. Bean, using your engineering experience and to a reasonable degree of engineering certainty, would the defendant's speeding down that lake make it difficult for him to have enough time to ascertain whether that light is a dangerous situation?
Objection.
Overruled.
Go ahead.
Your Honor, do I proceed with answering the question?
Yes.
Your question sounds like it assumes that I came to the conclusion that the defendant was speeding.
Okay, but he admitted he was speeding. So now, answer my question.
The faster that someone's traveling, whether it be on land or water, the less time there is to react to a hazard in front of you.
According to the navigation rules that you quoted, and there are other ones out there that you haven't quoted or put in your report, did he have a duty to take evasive action if that fishing boat wasn't getting out of the way?
Objection to the former question.
Overruled. The navigation rules are written in such a way that the way they're written, if you're involved in a collision, you violated at least the rule that says you shouldn't run into another vessel.
Okay. And can you answer my question? Did he have a duty to take evasive action if that fishing boat wasn't moving out of the way?
Yes.
Mr. Bean, only one of your conclusions really has to do with the physical evidence in this case, isn't that right?
Let me refresh my memory if you can. Can you repeat your question, please?
I said only one of your conclusions has to do with the physical evidence, isn't that right?
No, ma'am, that's not correct.
Okay. So, other than conclusion number 4, which you write based on physical evidence, what were your other 3 conclusions based on?
There's physical evidence to support those conclusions. For example, conclusion 1, the bass tracker was in violation of Rule 15.
But we know it's at nighttime, right?
My point is there was physical evidence to support my conclusion, which is what you asked.
Okay. But we already know when in a crossing situation, they have to be in sight of each other, don't they?
Objection.
Sustained.
Let's go to conclusion number 4. This is where you take measurements and looking at the striations on the bass tracker bow plate. Isn't that correct?
Sorry, can you repeat the question, please?
This conclusion is based on your measurements and your 3D scan of the boats. That's what this conclusion is based on, right?
Yes, ma'am.
Okay. And this is also where you decided, or not decided, but you looked at the striations on the bass tracker bow plate as well?
Yes, ma'am.
Okay. And you also came up with this angle of penetration, I guess you want to call it, of 47 degrees. Is that right?
It was similar to that. Didn't match exactly, but it was close.
Okay. I think yours was like 47.1, I think, when I looked at the pictures. Do you recall that?
No, I mean, it may have been 49. It was close.
Okay. So you agreed essentially with Mr. McCullough's report that that same angle that he got from measuring those striations of the bow plate were the same ones that you got. Is that right?
They were essentially, yes, they were consistent.
And you're used to dealing in numbers and formulas as an engineer. Is that right?
Yes, ma'am.
Do you know what amount of force it takes to penetrate that bayliner at that area in the bow there?
I don't have a number, no.
So you don't know like the amount of foot-pounds it would take to actually penetrate that fiberglass, do you?
No.
Have you investigated or recreated accidents or crashes that occurred at low speeds as well?
I've been involved in accidents through a wide variety of speeds.
Okay. Can you say whether or not the amount of damage on that bayliner would have been created at a low speed?
Tell me what you define as low speed.
Less than 10 miles per hour.
All right. With that in mind, please restate your question.
Would that amount, or what amount of damage would have been created had that collision been done at a low speed, less than 10 miles per hour?
I don't have any numerical calculations or empirical data that I can provide for that.
When you went out to see the boats, obviously you saw the bass tracker and the trolling motor. And I believe you said you had the trolling motor kind of put back up on the bow deck so you could see where it would have been during the collision. Is that right?
Objection.
Basis.
I'm trying to develop it so we don't have a confusion, Your Honor.
Set the stage.
I'm trying. Do you recall that, and Mr. Ulas showed you a picture of the trolling motor on top of the bow deck? Do you recall having that done? Now, from your picture of that, did you see any what is commonly referred to as transfer marks along the side of the bayliner that would coincide with that trolling motor and bass tracker?
There were some marks that could have potentially been from that, yes.
Okay. And did you have any reason to disagree with Mr. McCullough's report, which described those transfer marks?
You have to be, specific in which paragraph or wording you're referring to.
Okay. Do you recall a time during his report that you disagree that it was a transfer mark?
Definitely disagreeing. Not necessarily questioning, yes.
Okay. So you do recall a transfer mark that you disagreed with?
I recall a statement that he made regarding some marks about that subject.
Okay.
Where I questioned it and
And what were you able to say when you went out there? Were you able to say that those weren't transfer marks?
My work in the field that day was a much broader scope than just that area.
Okay.
So I didn't spend much time focusing on just that particular issue.
Were you aware of where the DNA of the victim, Brian Cuppett, was found on the bow of the bayliner?
I know the general location.
Okay, and where was that?
It was near the front of the bayliner.
Okay.
Just above the rub rail, I believe.
All right. And can you tell us on that bayliner, what's the widest part of that boat? Just in general.
The number or where?
I'm sorry?
You want the numerical value or do you?
No. Where would the widest part of that boat be on the bayliner?
Generally, in a boat of that design, it's going to be near about halfway along the length.
Oh, okay. So you already testified before on direct that the bayliner sits higher than the bass tracker, is that right?
My testimony was that in the perspective view of, at a certain point during the impact, that the bow of the bayliner, the gunnels of the bayliner would have been higher than those of the bass boat.
Okay.
But at rest, I didn't address that, if that's what you're getting at.
All right. I was just trying to see if the bayliner was higher than the bass tracker. That rubber around the bayliner, what's that called, that black piece?
It's called a rub rail.
A rib rail. Is it a rub rail or a rib?
It's a rub rail. It acts as a type of a bumper. So when the boat is docked, pulled up against a pier to keep the boat from getting scratched.
And because of the shape of that bow and the shape of that hull, would that rubber extend out further than the location of that gash in the bayliner?
Yes.
Would that part, even if we don't say that the boat went over the bass tracker, would that part at least go over the top of the bass tracker?
I'm not following you. I hear your words, but I'm not following your concept.
All right. You said before on direct that there's no evidence that the bayliner went over the bass tracker. Is that your testimony?
Yes, it is.
Okay. So there's no evidence on the hull of it that it like plowed over top of the bass tracker. It was penetrated by the bass tracker. Is that right?
That's correct.
Okay. Would that rub rail be over top of the gunnel on the bass tracker at that point of penetration?
I'm just trying to picture in my mind what you're describing. The way I'm picturing what you're describing, I would say no.
So that part that extends out from the gash in the bayliner would not go over top of the bass tracker?
Are you inferring it would have been a location where it would have been struck? Is that what you're asking?
Yes.
No, because the elevations are different.
Okay. The elevations are different, meaning that the bayliner was higher than the bass tracker?
Meaning that the point at which the bow of the bass tracker penetrated the bayliner was at a point below the rub rail.
Right. So the rub rail would have been up further
Would have been up
right?
further.
And actually closer to the bass tracker than where it was made contact with, correct?
Not in any significant way.
Okay.
Not in a way that would increase its likelihood of being contacted by the bass boat.
What about a person sitting in the bass boat?
Sorry, I didn't see the question in there.
I said, what about a person being in the bass boat? Could it have contacted a person sitting on the bass boat above the gunnel of the bass tracker?
I think there's a more complex geometry in what you're asking than that can be really visualized in just a broad brush description like that.
Okay. Could this bayliner have been going faster than 25 miles per hour?
Theoretically, the top speed of the boat is 40 plus miles an hour, so theoretically the boat could have been traveling at a fairly high, a higher speed than 25.
Okay.
I don't see any reason I don't see any evidence that indicates or supports that.
That's right. You didn't see any evidence of it being on a plane. Is that what you said?
Said it was indeterminate.
Okay. You couldn't determine whether it was on a plane. Is that right?
Not with a high degree of certainty, no.
Okay. But the top of the gash that's in the bayliner is horizontal or parallel with the water. Isn't that correct?
In general, I'd say so. In general.
Okay. And when boats go at a low speed, are they level with the water? If they're at a very low idle speed, that kind of thing, before making any wake?
When they're operating in a displacement mode, as we discussed before, yes.
I'm sorry?
Yes, when a boat is operating in a low speed in a displacement mode,
Okay.
then they're going to be, the water line will be level.
Okay. And what about at transition?
In transition, the boat is typically going to be traveling at anywhere from a 12 to 16 degree angle, nose up attitude.
So if something had penetrated that boat at level, something that was level, penetrated the boat that was in transition, that was going to be tilted up, would we see the angle tilted up on that gash?
Depends on how the gash was made.
Okay. What about in this situation? This is another boat sitting still in the water, and a boat in transition hits it. Would we see an angle going upwards instead of horizontal?
Objection. Rephrase.
Would a boat in transition angle be different than horizontal?
The trim angle of a boat in transition would be different. The trim angle of a boat in transition is different than a boat that is on plane, fully on plane.
So it's going to be, you said, a 12 to 16 degree angle?
For a boat in transition, yes.
Did you have that in this case?
Are you asking if I concluded that the boat was in transition?
No, I'm asking you if when you looked at that gash, the V, the top of the V, if it was 12 to 16 degrees.
The top of the V is not necessarily an indicator of the trim angle of the bay liner.
What about the horizontal line at the top of the gash?
We discussed this earlier this morning. The horizontal line at the top was the assumption of the DNR officer that that line was made in a way that assumed the bay liner was level, and therefore his conclusion was on plane, was what his conclusion was. And we had a long discussion earlier this morning about how that wasn't necessarily the case and why.
Actually, we never talked about why. So, would you have seen an angle on that top line if he was in transition?
Not in the way that I believe that line was created.
So you wouldn't. Would we have had this amount of damage if that bay liner was going only 10 miles per hour?
Objection.
Sustained.
You talked about, in your cause of accident, that other boat traffic should have been expected. Do you recall saying that in your report?
Yes.
Was other boat traffic to be expected by both boaters in that situation?
I would say yes.
So the bay liner should have also known that other boat traffic should have been in that lake, is that correct?
From the operator of the bay liner's perspective, he was basically in the center of the channel heading for the bridge and intended to cross underneath the bridge at the widest point available, which would have been the center. That was the widest span between the two bridge supports. And that was a common. My understanding is that would have been a common path for boats to take that were intending to cross underneath the bridge.
Do you know how wide that opening is?
I haven't measured it, no. I've seen the photograph of it.
How many boats could you fit under there at one time? Recreational boat.
You mean if it was a parking lot?
Yes.
Quite a few, I suppose, but that's not the way we allow for safe distances between boats that are traveling on a waterway.
And what would be the reason he needs to go to the center of the bridge?
It's the logical place. It's the section of the bridge where the supports are the farthest apart. It gives him the widest open and the widest, safest path to cross underneath.
Even if there's someone in his way? Is that right?
No, he wouldn't choose that if there were boats that were obviously in his path.
You said channel. Have you been given some information that this is a channel?
I haven't studied an official chart of the lake to identify where the official channel markers are.
Are you aware that there are no channel markers on this lake?
Only in the sense that when I stood on the, was on the bridge looking out over the accident area, I didn't see any channel markers. So it would not surprise me to learn that there are none.
You said that in your cause of accident, each vessel was in violation of, at least in part of Rule 19, which states every vessel shall proceed at a safe speed, adapted to the prevailing circumstances and condition of restricted visibility. What speed was the Bass Tracker going? Was it not going at a safe speed?
We covered before that I don't have any reason to believe that the Bass Tracker was traveling at a significant or a high rate of speed.
So how is he in violation of that safe speed?
The rule has more to do with the speed.
The what?
The rule is not just about speed.
Okay. It's about restricted visibility, right? As well.
You have it right there. Would you read the rule again for me, please?
19B, every vessel shall proceed at a safe speed adapted to the prevailing circumstances and conditions of restricted visibility. A power-driven vessel shall have her engines ready for immediate maneuver.
That last part to me is critical.
Okay.
Power-driven vessel having its engines ready for immediate maneuver.
And that's in the restricted visibility rule, isn't it? Rule 19? We've already talked, wasn't it a clear night that night?
It was a clear night. It was dark.
There was no fog, right?
There's no mention of any fog. There was statements in regards to the fact that there were other boats on the water that could be clearly seen. And the DNR reports indicate visibility was good.
Okay. So this is not a situation of restricted visibility.
Objection.
Sustained.
Is this a situation of restricted visibility?
Objection.
Would counsel approach?
You had evidence that the Bass Tracker's motor was kind of tipped forward and the propeller was out of the water at the time of the impact. Is that correct?
Yes.
And so it's your opinion that the Bass Tracker should have put its motor back in, started it up, and gotten out of the way. Is that right?
I believe that the Bass Tracker should have been in a position to use the outboard motor to get out of the way of any oncoming traffic if necessary.
So if someone just happens to be driving too fast down the lake under the influence, they should have to get out of the way?
Objection.
Sustained.
Do you know the time it would take to put the motor down and get it started?
I believe the point of the rule is that the vessel should be ready to use that propulsion system to get out of the way at a moment's notice.
And that's in a restricted visibility situation, isn't that right? Is that right?
From from a common sense standpoint, it's in any situation where you're in a position of obstructing another vessel that you have to give way to.
Are there lane markers on the lake?
You said there were no channel markers on this lake.
Right. So is there a certain, you only have 10 feet to go through the lake on, or anything like that? Any restrictions about how much of the lake to use in order to cross?
Most boaters would tend to cross under a bridge, like the 224 bridge, at what they deem to be the safest point, the deepest part of the channel, which is going to be in the center of that bridge, between the bridge supports that are the widest apart.
Do you know where this fast tracker was in relation to the bridge? How far out it was?
Only a general idea as drawn and sketched in the DNR reports by their investigation. They give a diagram that shows the relative location of the boats to the bridge.
Is that diagram to scale?
I don't believe it's to scale.
Do you know when that diagram was made, whether it was before the reconstruction efforts by Mr. McCullough or after?
Objection. Overruled.
Do you know?
No, I would have looked at the date on the report and used that as the approximate time of the creation of that diagram.
You talked in the beginning of your direct examination that you were engaged as a client by Attorney Lynn Morrow's office, right?
I was retained by Lynn Morrow's office, yes.
How much are you getting paid to testify here today?
Objection. Overruled.
My standard billing rate is $175 an hour for working on an investigation, and that rate applies to engineering work, testimony at trial, report time, trial, whatever I'm doing to work on the case.
And how many hours have you already spent working on this case?
I don't recall the specific number.
Is a certain minimum number of hours that you require before being retained?
No. I'm not specifically being paid to testify. I'm being paid according to the hourly rate that I don't, would charge on the case.
But that's what I understood, Mr. Beam. I'm sorry. That's what I got from your first statement. Can I have 1 second, John?
Yes.
Mr. Beam, do you fish at all? Do you go fishing?
I did in my youth, but I don't now.
Familiar with why they use a trolling motor as opposed to the regular boat motor while they fish?
Yes, somewhat.
And why do they do that?
Trolling motor it's quieter. It is often considered to be more reliable because it's electric. It doesn't have an engine that has to start. It doesn't have a gasoline-powered engine that has to start.
Are they you said before, typically quieter, right?
Yes.
I have nothing further.
Viewers.
have a few things, Mr. Bean. Just going back to what you were just asked now about the trolling motor. Does the trolling motor in this boat have the ability to start with the foot pedal?
I didn't see it as it was originally mounted in the boat. It was after the accident. But it would not be uncommon for a trolling motor to have a foot-operated control.
Okay, so that motor could be used to try to get out of the way, correct?
It could.
Is there anything about the fact that you want to troll around quietly to try to catch fish that changes your legal obligation to get out of the way if there's a boat approaching you from the starboard side?
No, sir.
The size of the boats here are roughly the same, is that correct?
That's true. In overall length, they're approximately the same.
Okay. So when you were being asked all those questions about freighters and stuff, this isn't a Bayliner versus the Saratoga or anything, is it? These are boats of approximately the same size?
That's right.
And when she asked you some questions about the lantern having the ability or possibility of blinding someone, doesn't your report say blinding the side lights from view?
That was my concern, yes, that the combination of bow light, which displays the red and green indicating which side you're looking at, would be obscured by the lantern.
Okay. You were asked a whole bunch of questions about, did you measure from the campground down to the point of the impact? Do you remember those questions?
Yes, sir.
Did you review the state's report as part of what the work you did in this case?
I did review that.
Were there any measurements taken by any agents of the state of Ohio to measure the distance from the campground down to the alleged site of the crash?
I don't recall any specific measurements. There may have been a general statement of, approximately a quarter mile or approximately some distance, but I don't recall, any instrumentation used to make a specific measurement of a distance between two known points.
Yes.
Just going to put up here for 1 second again, Defendant's Exhibit, Z as in zebra. This is the one that has 6 of the scans that you produced in connection with this case, correct?
Yes, sir.
Directing your attention to number 4, which is one of the points of impact. You were asked some questions about the rub rail going over the top of the bass tracker. You remember those questions?
Yes, sir.
Does that scan show whether or not the rub rail would have been able to go over the top of the bass boat as this collision occurred?
From the overhead view, there is a portion of the rub rail that would be, in elevation terms, being higher than the bass boat.
Okay. Is there anything in any of your scans to show whether it went over the top of the bass boat?
So I'm confused by the different phrases you used of.
All right, let me try this. Is there anything that showed that the rub rail would have struck either of the passengers?
I can see where it might be possible for the rub rail to have an impact on the passenger that was sitting in the chair on the foredeck.
Is that because the collision forces the front or bow of the beam down a little bit, as you described earlier?
That's part of it. The other part of it is the concept we discussed earlier, that the bass boat is being rotated rapidly, in effect yanking the boat, in layman's terms, out from under the occupant that's sitting in it. And so the bayliner is progressing on a path that has now pushed the bass boat out of its way, and the passenger or the occupant is still essentially for a brief moment where he was. And for that brief moment, it's enough time for the rub rail of the bayliner to make contact with that person.
Did you see in your report, in reviewing the state's report, anywhere that the state requested any weather reports?
As part of their investigation?
Part of its investigation.
Not that I recall.
Okay. And did you see that the state conducted any studies to determine the depth or the width of the lake?
Not that I recall.
Okay, that's all I have. Thanks.
Any requests?
Mr. Beam, did you do any tests on the lantern to check for brightness, anything like that?
No, ma'am.
I'm sorry?
No.
No further question.
Did you see anything that anybody else conducted a test on this lantern?
No, I didn't see any.
That's all I have. Thank you.
No, nothing. Thank you.
You may step down, sir. Thank you. I think for Kathy's benefit, let's take a recess of about.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you for the afternoon hours here from Midtown Manhattan. They're taking a break in the Urick case out of Ohio. That's the doctor accused of 4 charges currently. Originally, he faced 5 charges, but charge number 4 was set aside by the judge prior to trial. The most serious is a second-degree felony, aggravated vehicular homicide. After that, he faces aggravated vehicular assault, a charge of operating a vehicle while impaired, and a charge for failing to stop after an accident. The doctor is accused of boating recklessly while drinking, or after drinking, I should say, and ramming his boat into another boat around the midnight hour on a lake in Ohio, killing one person and injuring another. While they go on this break in the Urick case out of Ohio, we're going to switch back over to a case that we were covering earlier last week that we couldn't bring a few days of testimony to you regarding, but that's the Campbell case out of North Carolina, where a defendant there is accused of joining his father on a multi-state crime spree, which ultimately led to the death of a husband and wife in North Carolina. We're back covering that case, so let's go back to that courtroom now live.
And Detective McPhee, drawing your attention back to State Exhibit 433, what is underneath, what do you see underneath the 2 guns there?
On this particular end, you have a box of gloves, you have a toolbox, and this is a bolt that goes to a crossbow.
How many bolts did you find in the Suburban, Detective McPhee?
I believe there were 2 found in the Suburban. One in the.
I'm sorry, you found one in the back there?
Yes, ma'am.
And where was the second one found?
I believe it's in the behind the center console in the front passenger area.
I'll approach, Your Honor, with State's Exhibit number 519. Detective, I'm showing you what's been marked in State's Exhibit 519. Do you recognize that, sir?
Yes, ma'am.
And what is it?
This will be the container that's holding the bolt taken from the SUV.
And how do you know that?
I'm the one that sealed it.
And has it been in the care, custody, and control of the Granville County Sheriff's Office since you took custody of it?
Yes, ma'am.
And does that packaging appear to be in the same condition it was in?
Yes, ma'am.
You packaged it on January the 13th.
Yes, ma'am.
Your Honor, the state would ask Detective McPhee to open State's Exhibit 519.
That's fine.
They're taking it the other way because of the box inside for packaging.
I would mark the contents as 519A, and do you recognize the contents of the of 519?
Yes, ma'am.
And is this, what is this?
This is the bolt that would have been shot with that crossbow, or could have been shot by that crossbow.
And is this the one that was found in the back of the Suburban?
Yes, ma'am, it is.
And is it in substantially the same condition as it was when you found it?
Yes, ma'am, it is.
Your Honor, the state would move to admit State's Exhibits 519 and 519A into evidence.
Yes, yes, sir.
Permission to publish, Your Honor.
Yes, ma'am.
Do those appear to have the tips on the bolt?
Yes, ma'am.
So would that make up what's called the arrow?
The arrowhead, yes, ma'am.
Are there several in there?
There are 4 fins on this particular blade, yes, ma'am.
Okay. May I approach? Was this box that you pulled out, was that just in there so it wouldn't move around?
Yes, ma'am.
Okay.
Put that in.
Mm-hmm. Detective McPhee, I'm drawing your attention back to the screen. State's Exhibit 432. Do you recognize that?
Yes, ma'am.
And what is it?
We're not exactly sure. It appears to be some type of homemade metal spike.
And did you collect that?
Yes, ma'am.
And did you also collect a sword from the back of this SUV?
Yes, ma'am.
And where was that collected from?
It's behind the rifle cases.
So back behind there?
Yes, ma'am.
You don't have a picture of that?
No, ma'am.
May I approach your Honor?
Yes, ma'am.
Detective McPhee, I'm showing you what has been marked for state's identification purposes is State's Exhibit 208. Is this the metal rod and the sword?
Yes, ma'am. They are just combined together.
I'm sorry?
Yes, ma'am. They are just taped together.
And is that how you package them?
Yes, ma'am.
And did you mark or were these recovered from the back of the SUV on January the 13th of 2015?
Yes, ma'am, they were.
And have they been in the care, custody, and control of the Granville County Sheriff's Office?
Yes, ma'am.
Do they appear to be in the same or substantially the same condition as they were in when you bagged these?
Yes, ma'am.
Your Honor, the state would move to introduce State's Exhibit 208, the metal rod and the sword.
Any objection? Nothing allowed.
And I would just ask Detective McPhee to show this to the jury.
Yes.
We have the metal rod taped to the sword case itself.
Can you take that apart?
Which one?
I'm sorry, the metal rod from the sword?
Yes, ma'am.
Detective McPhee, I'm drawing your attention back to the screen. State's Exhibit 434. Do you recognize that?
Yes, ma'am.
And what is that?
That is one of the blades that has broken off the tip of the bolt, similar to the one we had displayed a few minutes ago.
But the one that we saw a few minutes ago had all of its arrows. Is that correct?
We had 4, yes, ma'am.
So, but this was similar to the tips that were on the bow that we just looked at, or the arrow. I'm sorry, the arrow.
Equivalent to one of them, yes, ma'am.
State's Exhibit 435. Do you recognize this?
Yes, ma'am. This is a bow that was in the rear passenger area. We had gone through, this is actually the last passenger area in the vehicle. You could have seen this green case earlier in a few pictures. When we opened it up, this is what was inside this case.
Are these arrows different from what we just saw in State's Exhibit number 419?
Yes, ma'am, in every way, in make and style.
And does this crossbow appear to, I'm sorry, this is not a crossbow,
No,
is that correct?
That's correct. This is a normal bow, compound bow as it's called.
Thank you. State's Exhibit number 436. What is this?
This is one of the tubs we've taken out and set on the table, just an overall picture of before we start taking stuff out. Appears to be some clothing items.
Full of things?
Yes, ma'am.
State's Exhibit 437. Do you recognize that?
This is down inside that particular tape, and as you can see, it appears to be books or ledgers, checkbooks from Jerome and Dora Faulkner.
Does that appear to be a piggy bank there to the left?
Yes, ma'am. It appears to be an upside-down piggy bank right here.
Perhaps a towel or something like that to the right?
To the right, yes, ma'am.
Showing you State's Exhibit 438. Do you recognize this?
Yes, ma'am. This is the clothing basket we've saw since the very beginning that was stashed in between the chairs, and this is just the items that were down inside of this particular.
Including those pill bottles?
Yes, ma'am. Everything that you pictured here was down inside of this. You had the food items, you had the pill bottles.
Drawing your attention to State's 439. Is that a close-up of the pill bottles there?
Yes, ma'am, it is. You see the prescriptions themselves were written to Jerome Faulkner. They have a prescription for tramadol and a prescription for hydrocodone.
Drawing your attention, sir, to State's 440. What is that?
All of these items were stuffed inside of this alternator box. So we opened the box, just laid the items out so we could photograph them. You have black zip ties, one box of 4 master locks, U-bolts again, nuts, supposedly I would imagine for the U-bolts. You also have some other screws and again the empty box for the alternator.
Do these appear to be the same U-shaped bolts that were in the
camo bag?
Telescope bag?
Yes, ma'am.
Same type of bolts that are listed there?
Yes, ma'am. It does appear that way.
The alternator, did you do anything about that alternator? Did you look look on the Suburban to see if there was an alternator that matched this box?
Yes, ma'am.
And what did you discover?
There was a new alternator had been placed on this Suburban.
And did it appear to match what came out of this particular box?
Yes, ma'am. Same make and model.
Drawing your attention to State's Exhibit 441. Do you recognize that?
Yes, ma'am.
And what is it?
This is going to be the rear seating area still.
So did we see this earlier? There was like
part of it, yes, ma'am. We still had all the tubs and everything there.
And was there a frying pan over the?
There was. The frying pan would have been sitting here earlier in the previous pictures. This would be the back pocket where the IDs came from earlier as well.
So the IDs and the passports?
Yes, ma'am.
And State's Exhibit 442. Do you recognize that?
Yes, ma'am. This is a small chemical sprayer of some sort. It's a handheld pump. As you can see, it's a flow master, and you can almost make out the model there. That's just a small chemical sprayer.
May I approach?
Yes, ma'am.
We are going to break back out of the Campbell trial out of North Carolina to bring you back into the Ohio courtroom of the trial of Dr. Joseph Urich, because the defendant's wife is on the witness stand now. Let's listen into her testimony.
All right, so the two of you coordinate your schedules to get this half day off. The three of you go out to Berlin, is that right?
Yes.
Remember stopping any place on the way out, anything like that?
Yeah, we stopped at Sparkle on Western Reserve to buy some groceries for the next day. Our friends, Candy and Matthew, were coming from Akron to have a cookout.
And did you guys then drive out to the home on Hawthorne?
Yes.
Do you know what And it's sort of at one end of the lake, is that right?
Yes.
Can you tell us, if you remember, what you and Joe and Charlie did once you arrived out to the lake?
Sure. Basically unloaded the groceries, unloaded a few of the things that we had brought for Charlie for the weekend, started to put away the groceries. I packed a little cooler with Charlie's milk and, you know, some snacks to go out on the boat for the afternoon.
Okay. Do you remember, I know you're not looking at your watch exactly, but can you give us some rough idea of what time you think you guys arrived at the lake house?
Probably about 2 p.m.
Okay. And after you unpacked the groceries and all that sort of stuff, were you and Joe doing separate things?
Yes, I was unpacking the groceries and getting Charlie ready to go out on the boat. And Joe often does, went down to the boat to kind of untarp it and get it ready. It had been sitting all week, at least, you know, at the dock, so getting the boat ready for us to go out.
Okay. I'm informed that you still need to speak up even louder.
Okay.
That probably seems difficult from where you're sitting, but if someone asks you that, yell at me a little louder, okay?
Sure, no problem.
You say that Joe went down to the boat. We haven't been out there during the course of this trial. Can you sort of describe for us where the boat is in relation to your home?
Yes, the water, the dock and the water where the boat sits is about a football field away, 300 feet or so. There's a slight incline going down to the water. Depends on, there's a drop off as well, with some stairs going actually down to the dock and the water line. It depends on the level of the water, whether or not you can actually see the dock or the boat. Just depends on the time of year.
Okay, does the level of water fluctuate at Berlin Reservoir?
Yes, sir.
Okay. And so when you say it depends on the level of water, when you can see the boat, are you talking up from the perspective of the house?
Correct.
Okay. You mentioned some stairs going down from the house down to the dock area. Do you remember if those stairs were in good repair or not good repair?
My father built them. They were not in good repair at the time. This day, the accident
this weekend
occurred.
we're talking about?
Yes.
Okay. Remember what was wrong?
I believe one of the steps was kind of sideways and one was actually missing.
Okay. Do you remember if the boat dock, yeah, I assume you have to walk out onto a dock to be able to get onto your boat, correct?
Correct.
Do you remember if there was anything damaged or in need of repair on the boat dock itself?
Yes, because of winter and we leave the dock in place during the winter, there was a missing board walking out to the dock.
Okay. And is that something you'd have to negotiate to be able to get from the shore to into the boat?
Yes.
All right, so I think before I asked you for the geography lesson, you were telling me that you were up at the house doing some things and Joe had gone down to the boat.
Yes.
You guys have communication? How do you coordinate what you're going to do after that?
Usually we would call each other, so that day I called Joe just to check to see if he was ready and if I should start packing up the baby to head down.
Okay. When you say call, on cell phones?
Yes.
And did Joe have the boat ready?
Yes.
So then tell us what happened next, please.
So I just got the baby and the stuff and went down to the boat and got on the boat.
So did the three of you then go out on the boat?
Yes.
Who was driving the boat?
Joe.
And do you remember what part of the lake you went to?
Yes.
What part?
We refer to it as the beach.
Okay. I'm not going to try to put you on the spot, so you tell me yes or no. We have a map behind you that if you think you can help us out with, I'll put it up here and ask you to sort of, you think you can do that?
I think so.
Okay. Mayor?
Yes.
Thank you. So So let's start with a couple of the basics. First of all, we marked this as State's Exhibit 4. Do you recognize this to be a photograph of Berlin Reservoir?
Yes.
Okay. If the judge will allow you, if I were to ask you, would you be able to come down here and show me, first of all, about where your home is on Hawthorne?
Sure.
Yes. Thank you. And now that you're away from Kathy, I'm going to ask you to talk even louder if you can believe that. And if you don't mind, turn toward her so she can take down everything that you say. Can you show us the general area where Hawthorne is, where your house is?
Yes. Here.
Okay. Now, you were talking about you and Joe and Charlie going out to an area that you call the beach. Can you tell us about where that is? And you know what? I'm going to swap with you so now you're facing Kathy. How's that?
We would have come up our cove here. I believe this is the railroad truss. Come around there, and the beach is
Sort of off the picture there?
I don't see it on the picture,
Okay.
but it's around here.
Okay. But that line that's running sort of up and down is the railroad line, is that right?
Yes.
And is there a bridge that crosses part of the Berlin Reservoir
Yes.
with the railroad track on it?
This here, yes.
Right there. Okay. So do you go under that to get to this beach area?
Yes.
You see where the 224 bridge is on this diagram, on this photograph?
Yes.
Did you folks that afternoon go up in the area of the bridge?
No, sir.
Okay. Did you cross the bridge and go up to the other part of the lake?
No, sir.
Okay. Thank you. Yeah. To the best of your recollection, when you go out to this beach area, do you encounter anybody that you know?
Yes.
Who's that place?
Andy Krogan.
Okay. And I know this sounds stupid, but you have to tell us because none of us were there. Was Andy on a boat? Did he fly in? Did he drive in? How did you run into Andy?
He was on his boat.
If you remember, was Andy already at the beach area or came later, or you don't remember?
I don't remember.
Fair enough. Do you remember if anybody was on the boat with Andy?
Yes, his friend Ben, and his friend Ben had a female friend, of which I don't know her name.
You don't remember her name? All right, fair enough. So there's 3 of them, on Andy's boat, and the 3 of you on your boat, correct?
Yes.
So tell us then, what do you do at this beach area?
We generally would tie up. Joe pulls up onto the shore, the front of the boat, goes off the front and ties to like a tree in the front, and then.
So this is an area where you can sort of run the boat aground without permanently running it aground.
Yes.
All right.
And he ties to Andy's boat as well to the left of us.
And then what do you guys do?
I stay on the boat, hang with the baby, listen to music, just kind of sit there and chat.
Would you be able to give us some estimate of how long you think you were out there hanging out? I'm sorry, before I ask you that, if you remember, did anybody else come down to your little gathering that day, any other friends or anything like that?
Not that I recall.
Right. So it's just the 6 of you as best you can remember?
Yes.
All right. Now I'll ask you, about how long do you think that you were there?
We were there probably about 1.5 to 2 hours.
And then what happens at the end of that 1.5 to 2 hours?
We untie and go home.
Who's driving the boat when you go home?
Joe.
Okay. The 3 of you on the boat again?
Yes.
Does Andy and his friends, do they follow you over to your house?
No.
No. So it's just the 3 of you guys that arrive back at your dock?
Yes.
All right. Then tell us what happens after you arrive back at your home.
Well, Joe ties up the boat. We walk together up to the house, get Charlie settled in, and Joe prepares dinner for us.
Okay. Do you remember what Joe was doing or what he was cooking, anything like that?
Yeah, Joe usually does all the cooking. This day it was hot dogs on the grill.
So after he's done cooking, did the three of you have dinner?
Yes.
I know you're not looking right at the watch, but can you just give us a general idea of about what time you think it was when you're having dinner now?
About shortly after 6 p.m. or so.
Okay. Sun's still out at this point?
Yes.
If you remember, how's the weather?
Pleasant, I don't remember exactly.
Okay. All right. So then after dinner, tell us what happens next.
We set up Charlie's playpen that she sleeps in when we're at the lake in the spare bedroom, get her settled, kind of sit in the living room for a little bit, and then I go and change into my pajamas. That's about the event of it.
Does there come a point in time when Joe leaves?
Yes, eventually.
All right. And we're going to talk about what sort of leads up to that from what you observed.
When I was changing into my pajamas in our bedroom, Andy called and had asked Joe to go hang out. And we spent a bit of time, I spent a bit of time pouting and throwing a fit over it.
All right, you say pouting. First of all, I know that we talked about Charlie being 10 months old. What is your condition otherwise at this point?
About 4 or 5 months pregnant.
Okay. All right, so you and Joe get into a discussion about Andy's request for Joe to come and meet him.
Correct.
Okay. And you said you spent some time pouting about that.
15 minutes or so.
Okay. What ultimately happens? How do you give up the pout?
I do. Joe works very hard and spends most of his time, any downtime, with myself and the kids. So I give in and basically say, okay.
All right. And then tell us from your observation when Joe leaves, and when I say from your observation, are you outside watching him walk down, or you just stay in the house and Joe leaves?
I just stay in the house.
Okay. Are you able to hear the boat from where you are inside the house, or does it kind of depend on what's going on?
No, I can't hear the boat.
Can't hear it? Okay. Are you able to give us some idea of either what time Andy called or what time Joe left, or both?
The first time Andy called was around 9 p.m. and the second call was, like I said, after our discussion, maybe 15 minutes later, and he left just briefly after that.
Joe left briefly after that?
Yes.
Okay. And then do you hear from Joe again while he's out with Andy? I mean, are you guys talking on the phone or anything like that, or is it pretty much Joe's just out?
We didn't talk on the phone until just before he was getting ready to come back home. There was a couple text messages here or there, mainly from me kind of asking when he's coming home and pressuring him to do so.
So if you said text messages and a phone call maybe?
One phone call just prior to him leaving Andy's dock to come home.
Okay. Any idea about what time that phone call was?
Yes, it was about 11:30 p.m.
And then do you go to sleep because you know that Joe's coming home, or are you waiting up for him?
No, I was waiting anxiously for him.
Okay. And then tell us the next thing that you remember happening in relation to whether Joe came home.
I talked to him around 11:30. He let me know that he was wrapping it up and going to be coming home very shortly. And about probably 15 or 20 minutes later, my friend Melissa texted me that he had just left the dock, just to let me know he was on his way home.
Okay.
But like I said, you know, I was worried about him being out at night by himself, so I was watching intently for him to pull in.
Okay. And do you see Joe pull in?
I do.
Okay. Are you able to see the boat, hear the boat, or both?
Neither. I could see the lights on the boat.
I see. Okay. So you can see the lights coming into your dock area, is that
yes.
it? So then what's the next thing that you remember happening after you see the lights pulling into the dock?
I looked at my phone. I could see him. There's 2 solar lights that my dad had placed at the top of the stairs, and I could see basically his shadow, his feet going past those. And I kind of felt like it was taking him a while to come up to the house.
Okay. Do you have any idea about what time this is?
I remember looking at my phone because I was, worried and watching the time from the time he left to get home, and it was 12:05 a.m.
All right. So then you mentioned you can sort of see Joe's feet, I guess, from these solar lights, correct?
Yes.
All right, and it seems to be taking a little longer than you think it should. So then what happens next?
I call him to basically say, "What are you doing? When are you coming up here?"
All right. And you remember any idea what time that call was?
Not exactly, but within probably 5 or 10 minutes of seeing him get into or pull into the dock.
Okay. And once you have that phone call, does Joe, what happens? Does Joe come up or does he not come up?
He comes up very briefly after that.
Okay. And when you see Joe, how would you describe him? How would you describe what you saw?
He was shaken up.
Okay. Did the two of you have a conversation about him being shaken up?
Yes, he comes up to the house and basically told me that he had hit something.
Okay. Did he tell you what he had hit?
No, I thought he hit the neighbor's dock or something was my initial thoughts pulling into the cove.
You said Joe was shaken up. Did he seem upset?
Yeah, he seemed upset, anxious, and like I said, pretty shaken up.
Okay. Did you get up close to him and talk to him?
Yes.
Okay. Were you able to observe, besides his demeanor and his emotional state, were you able to observe how he appeared?
Yes.
Did he appear to you to in any way be impaired?
No.
Objection.
Sustained.
Was he slurring his words?
No.
Did you have a strong odor of alcohol emanating from his mouth coming toward your nose?
No, sir.
Was he in any way unable to walk or maintain his balance or anything like that?
No.
Other than being upset, was he unable to communicate with you effectively?
No.
Did his speech seem slurred?
No.
Objection.
Rephrase.
How would you describe his speech?
Normal.
Was it clear and coherent?
Yes.
How about his eyes? Did you notice anything about his eyes, if they were unusual in any way?
No, sir.
So after you have the conversation with Joe about he hit something, then tell us what happens next. Are you guys outside, by the way, while this is going on, Angelina?
He was where we met when he came up to the house. I had opened the sliding glass door, and he was just walking up to the house.
Okay. So you're sort of in and he's out?
Yes.
Okay. Does he come into the house then?
Yes.
All right. So then I interrupted you. Tell us what happens then after Joe comes up and comes into the house.
I basically try to ask him questions about the last thing that he remembered, trying to figure out what he hit and exactly what had happened when he's saying he hit something.
Was he able to tell you what he had hit?
No.
Did you guys call the police at that point in time?
No.
Why?
I felt it was important to figure out what had happened first before calling the police.
Okay. And did you guys do anything to try to figure out what had happened other than you asking Joe questions?
Yes, we made numerous phone calls to our friends whom he had just left at the dock.
Okay. Do you remember calling anybody in particular?
Eventually, yes. I call our friend Nick and Sherry. Neither one of them answer, but they do eventually call me back.
So, as a result of these, well, let me ask you, does Joe at any point want to call the police?
He does.
Okay. And do you guys call the police then?
Probably 5 or 10 minutes after that.
Okay. And why don't you call right away when Joe wants to call the police?
Because I still hadn't figured out exactly what he had hit and what had happened.
All right. Now, you can't necessarily tell us what people told you, but as a result of the texting and the phone calls that you were engaging with the friends, did you come to believe something about what Joe had hit?
Yes, I knew that there was this talk about a distress call, so they both basically just divulged to me that the distress call involved a boat and there was an ambulance on site.
Okay. So are you beginning to sort of put 2 and 2 together that maybe that this was, that what Joe hit was tied to this?
Yes.
Has he still been able to tell you what he hit?
No. Actually, I was afraid to tell him because he was so emotionally distressed and I was there by myself with him.
All right.
I spent a couple minutes kind of explaining that to Sherry on the phone before we ended our conversation.
Okay. So then, any recollection about what time you're talking to Sherry?
Yeah, just after 1 a.m.
And then, once you finish talking to Sherry, what's the next thing that happens?
I hang up the phone. I just basically say to Joe it was a boat and immediately call 911.
And when you call 911, what sort of information do you give them?
I believe I just told them my husband had hit a boat.
Did you later identify Joe in that call?
I don't remember.
Okay. Do you remember if you identified yourself?
I don't remember.
Okay. Do you remember if you gave the police some way to figure out, well, where do we go to talk about this?
I remember asking them, I called 911 and I remember asking them for the Deerfield Police Department or something like that. And then the dispatcher started asking me questions, our address and things like that.
While all this is going on, are you in the same room or the same proximity with Joe?
Not during the entire time from the time he came home to calling 911, but at that moment, yes.
Okay. Had you had, I realize you weren't in the same room with him all the time, but had you had a fair amount of contact with him during this time? Okay. Around the time you called 911, can you describe Joe's physical appearance? Was he unable to walk?
Well, no.
Was he losing his balance?
Objection. No.
What can you tell me about Joe's speech during this point in time in terms of whether it was normal or not?
It was normal.
What can you tell me about Joe's ability to walk and move around?
Completely normal.
What, if anything, can you tell me about Joe's eyes?
Normal.
Now, after you call 911, if you remember, does anybody else come over to your house on Hawthorne?
Yes, Sherry sent Andy and Nick, Nick's friend, a female. Again, I don't know her name.
Okay. And do they stay long or do they not stay long?
No, just briefly.
And then do the police arrive?
Yes.
And are you with Joe when he is talking to the police?
Yes, the whole time.
What's his emotional state at this point?
Well, it depends on what point you're talking.
All right. Let's try it this way. There comes a point in time during the evening, isn't there, when Joe learns that there's been a fatality?
Yes.
All right. Let's talk about between the point in time that the police arrive and that point in time. Can you describe Joe's emotional state or condition?
Yes, at this point, it's clear that there was a boat that he had collided with. So he was very emotionally distressed, panicking in a sense.
How about physically, though? Has it changed in any way physically?
No, sir.
Are you there when the police arrive?
Yes.
Are you there for at least some of the time when Joe talks to the police?
Yes.
If you know, is there a point in time where Joe leaves with the police detective to go down to look at the boat?
Yes.
Do you go down with them?
No.
And this is probably an unfair question, but do your best with it. How long would you say the police were there? Was it minutes or hours?
The entire night.
Okay. We were talking a few minutes ago, there's a point in time where Joe learns that there's been a fatality.
Correct.
Are you present when that happens?
Yes.
Can you tell us about that, please?
I'm sorry. You're on it.
It's okay. Take your time. You need some water?
Maybe a tissue.
There's one right there.
I'm sorry for the composure. I don't need to be disrespectful. There is a point in time where Lieutenant Johnson comes back into the house and tells Joe basically that there was a fatality. And at that point, clearly, Joe became severely psychologically distressed.
How about his physical appearance? Does he still appear to be coordinated?
Yes.
Is there a point in time where the police ask? Is there a point in time where the police ask if they can take the boat?
Yes.
And you guys agree to let them take the boat?
Yes.
Do you agree to let them take the trailer?
Yes, the tags were in the glove compartment. And basically, I got them all set up to do what they needed to do.
Did you ever see a time during this evening that we're talking about where Joe was unable to maintain his balance when walking?
Objection. No.
Oh.
No, sir.
Did you ever see a time where he was swaying or anything like that?
No.
Did you ever see a time where his speech was incoherent?
No.
Angelina, I have just a couple more questions for you. I asked you about when Joe cooked dinner. Do you remember how, you said he cooked hot dogs.
Yes.
Do you remember how much he had to eat?
At least 3 or 4 hot dogs.
Was Joe in the military?
Yes.
If you know, did he ever serve overseas?
Yes.
If you know, since coming back, has he ever been diagnosed with anything?
Objection.
May I see counsel?
Do you know if Joe was ever, sorry, did you say it correct or not?
Could not.
I'm sorry. Strike that. Have you ever seen Joe had too much to drink?
A handful of times.
How about that night? Did you notice, well, when you've seen him do that, have you noticed how he's acted or behaved?
Like he's had too much to drink.
Okay. And what sort of things would you notice about him?
Similar to anybody I've seen that has too much to drink. Little bit slurred speech. I've never seen him severely intoxicated or impaired. Usually it's mild.
That night, did you see any of those signs?
No.
Yes.
That's all I have, thank you.
Cross?
Good afternoon. Do people call you Mrs. Urich? Or they call you Ms. Dr. Rodriguez? I mean, both apply, right?
You can call me Angelina.
Okay, Angelina. My name is Dawn Cantala Mesa. I'm one of the prosecutors here. So you were pregnant back on May 8th, 2015, is that right?
Yes, ma'am.
While pregnant, did any smells get on your nerves? I mean, some people recall having a heightened sense of smell during that time. Did you have that sort of reaction to being pregnant?
I had 3 pregnancies. It's hard. I'm not sure.
Okay. So you already said you didn't sense or recall any slurred speech or odor of alcohol on your husband that night, correct?
Objection to the form of the question and
Compound.
All right. You already said that you didn't smell an odor of alcohol on your husband that night, is that right?
No, ma'am.
Okay. So you obviously, that night you didn't drink anything, is that right?
No, ma'am.
And you were there when Lieutenant Johnson was at your house when he was talking to your husband? From my understanding? You recall him telling Lieutenant Johnson that he had a couple beers that night?
Yes.
Have you seen any of the evidence in this case? Like the surveillance video from Ben's restaurant or anything?
Just what I've seen at the lawyer's office.
Okay. Did you see him taking the shot at Ben's restaurant on the video?
I didn't see that video.
Objection.
She said she didn't see it.
Are you trained to detect alcohol impairment?
No.
Have you been to any law enforcement training with regard to what to look for when detecting impairment?
No.
So you heard him tell Lieutenant Johnson that he had a couple beers, but you did not smell any alcohol on him. Is that right?
To the first part, no. And is that right? Yes.
Okay. But you heard him say to Lieutenant Johnson he had a couple beers. That's the part you did know.
Yes, ma'am.
Okay. And you didn't smell any alcohol on his breath, is that right?
Sustained.
How often would you go to the lake house prior to that weekend? How often did you go there?
With Joe?
Yeah.
Well, we used to go more often than after I had Charlie. So maybe once a month, twice a month.
Okay. Before Charlie or after Charlie?
I can't generalize because we'd only been out there a couple of times with Charlie.
Okay. And how many years you said you knew him about 6 years total?
I had mutual patients and we did the same training. We did training at the same place, so I knew of him in passing longer.
Did you ever see him at the lake prior to you guys dating?
No.
Do you recall when he bought that boat?
That was before my time.
Okay, so we already had the boat?
Yes, ma'am.
Do you know where he kept that boat prior to you having that house together on the lake?
I guess it would depend on the season. I don't know.
You guys have been going out there a number of years prior to this happening, out to the lake?
2 summers.
Okay, so pretty familiar with that lake, would you say?
Myself?
Yes. Yes. And what about Joe? Is he pretty familiar with that lake?
Objection.
If she knows.
Seems to be.
Okay, so he knew right where this beach was, right? That you guys like ran around and tied off and kind of hung out on this beach?
Objection.
Did you have to show him?
Objection.
I guess there was a question posed and then you just moved on, so could you rephrase?
Did you have to show him where that beach was?
No.
Had you been there before?
Yes.
How many times do you think you've been out to that beach with Joe with that boat?
I'm not sure.
Had you been up to High Oaks Campground prior to this date?
Yes.
And had you been up there with Joe?
Yes.
Is that where you knew all these people to be at on the weekends? Like Melissa, Adam, Andy?
Those were my friends prior to meeting Joe.
So you've known them longer than
Correct.
Joe? Okay. Did you have a boat up there prior to Joe?
No.
You never had a boat? You recall him leaving around 9 o'clock or 9:15 soon after he talked to Andy, is that right?
Yes.
Did he have anything to drink with dinner when he was having these hot dogs?
No.
No beer at the house?
I don't know that.
Okay. Did you buy any beer at Sparkle when you went and picked up groceries that day?
No.
Do you recall having any beer in the fridge already?
I don't recall.
You said that you were worried about him after he left. Is that correct?
Yes, ma'am.
Did you know where he was planning to go once he left to go meet Andy?
Yes.
And where was that?
Andy's dock.
Okay. Did you know any of the plans from that location?
I don't recall.
Do you recall anyone or him mentioning that he was going to go to Ben's?
It's something we often did, yes.
Do you recall, what time did you say the clock said when he got home?
That night?
Yes.
12:05.
And you're sure about that?
Yes, ma'am.
How long does it take to get from your dock up to Andy's dock by High Oaks?
By boat?
Yes.
15, 20 minutes.
What about at night? How long does it take?
I'm not sure.
Do you know of a speed limit on that lake at night?
No, ma'am.
You've never seen any of the signs posted around the lake about the speed limit at night?
No.
Have you ever gone out on the boat at night before?
With Joe, I can't recall.
You said he got home at 12:05 and he was slow coming up to the house, is that right?
Not sure what you mean by
Isn't that what you just testified to? He was kind of coming up the stairs, you were watching the solar lights, and he was coming up slowly to the house, so you called him.
He physically wasn't slow.
Rephrase, please.
Was he slow coming up to the house?
I felt he was down there for a prolonged period of time. Yes.
So he was taking too long to come up to the house?
With my anxiety, yes.
You're saying when you saw him, you went and met him at the door. Is that right?
Yes.
Is this a two-story house, one-story house? What is this?
It's a one-story house, but it has a walkout basement.
Okay. So where were you looking out the window when you saw him on the dock?
The sliding glass door in the dining room.
Okay, so you never went to bed that night?
I was originally in bed when he left.
Okay. And then what made you stay up and go look for him at the door when he was coming home?
I always worry about my loved ones.
When Melissa, you said Melissa texted you that
Yes.
he was on his way?
Yes.
And what time was that, do you recall?
I don't recall exactly what time. Shortly after I talked to him on the phone.
And right, that was around 11:30 you thought, right?
Yes.
You said you didn't call the cops right away.
No.
Did he say he hit something?
Yes.
Did he know what it was?
No.
Did he mention anything about a rock when he came in?
No.
So he never said the word rock to you?
I don't recall.
And you decided not to call the police at that point?
No, ma'am.
I think you said before that you wanted to see what he remembered. Is that right?
I wanted to see the last thing that he remembered, yes.
Okay, was he having some problem with his memory that evening?
Not prior to that, no.
Just that night he was having some problem with his memory?
At that moment, he was.
And you still can smell any beer on his breath?
No, ma'am.
And no shots of Fireball on his breath?
I don't know what that is.
You didn't smell any other kind of alcohol on his breath?
No.
So you talked with Joe for over an hour before deciding to call the police, is that right?
I can't say exactly how long it was.
Didn't you tell Lieutenant Johnson when he was there that you guys talked for over an hour before deciding to call the police?
If that's what's in the statement, I can't recall at this time.
You said when Joe first got home he was emotional, is that right?
He was shooken up.
Okay. And you said he was emotional.
Objection. Sustained.
Did you say he was upset?
No.
When he first got home, you didn't say he was upset when he first got home?
I don't believe I used that word.
Anxious? Did you use the word anxious?
I don't recall.
You said that when he first finds out that there was a fatality on the boat, that he became emotional then. Is that correct?
Correct.
Didn't you already tell us he was emotional before that?
Objection. Sustained.
Didn't you say he was shaken up?
Yes.
So wasn't he already shaken up prior to learning that there was a fatality?
Yes.
Did you ever go look at the boat to try to figure out what Joe hit?
No, ma'am.
You said that you kind of determined that he hit another boat by talking to other people on the phone. Is that right?
Yes.
And this would be Sherry. Is there more than one person that you talked to on the phone?
Yes.
And who was that?
Nick and Sherry.
Okay. Is that the same phone call, or would that have been different phone calls?
2 different phone calls.
Do you know whether or not Nick or Sherry were at the site of the rescue?
No, I don't know.
You said before that there had been an ambulance deployed or something about an ambulance. Do you recall who told you that?
Sherry.
Did you call anyone else to find out what had happened with the ambulance?
No.
Did you notice any injuries on Joe at the house?
Yes.
What did you notice?
He had an abrasion on the side of his neck.
When did you notice that?
Not till sometime later, not immediately.
Was that before Lieutenant Johnson got there, or after Lieutenant Johnson had left and come back?
I'm not sure, I believe after.
You said you were a little anxious that night, isn't that right?
Yes.
That you were worried about Joe, is that right?
Yes.
Are you worried about him every time he leaves the house?
Generally, yes.
One second.
You may.
Did you hear the defendant, your husband, tell Lieutenant Johnson that it was a rock that he hit?
Objection. Overruled.
Go ahead.
Yes.
Is that the first time you heard the word rock mentioned at that time?
I'm not sure.
Did you ever hear the defendant, your husband, tell Lieutenant Johnson that he was worried the boat would sink?
I don't recall.
What about, do you recall the defendant telling Lieutenant Johnson about being injured? Did he say he was injured?
I'm not sure.
You're not sure if he said it, or you're not sure if you recall that?
I'm not sure if he said it.
Okay. Nothing further than thank you.
Redirect.
Can I go for a quick way through
Yes.
this? Thanks. Yeah, that's it.
Pictures will be in the file. It's in that box.
Yes.
Angela, I'm going to hand you what we've marked. As State's Exhibit 45, which has previously been marked, and then I think the second one is marked Defendant's Exhibit GG, correct? It should have a blue label on it.
Correct.
Can you tell us what those are?
Pictures of my husband?
All right. Now, you were asked some questions about whether you saw an injury on Joe, correct?
Yes.
Is State's Exhibit 45 a picture that was taken while you were present of Joe's injuries?
Yes.
Do you remember about what time of the day or night that picture was taken?
About 4 a.m.
Okay. And can you tell us under what circumstances, that is, who took the picture and what you saw?
This was very shortly after Lieutenant Johnson had left for the night.
Okay.
Then he came back in specifically to take this photo.
Okay. I noticed in the top picture, Joe's sort of like his lip and his tongue are kind of out. Did you see Joe do anything between the time Lieutenant Johnson left and when he came back to take that picture, State's Exhibit 45?
Yeah, he put a dip in.
Okay. Of snuff or chewing tobacco?
Correct.
Okay. Defendant's Exhibit GG, which is the one below that, do you recognize that?
Yes.
Is that also a photograph of Joe's same injury?
Yes.
Was that taken also by Lieutenant Johnson?
Yes.
Did both of those pictures fairly and accurately depict what Joe looked like?
He's posing in this photo. We asked him to pose so he could get his neck, but...
All right, when you say this photo, I'm going to ask you to tell me, is that State's Exhibit 45?
Yes,
Okay.
45.
All right. Did both of those fairly and accurately depict his injury that you saw that night?
Yes.
Now, Ms. Campbell, let me just ask you, some questions about when Joe made dinner, if he had anything to drink. And I think she asked you questions about if there was beer in the house. Do you remember those questions?
Yes.
And I think you said you weren't sure, you didn't remember. Is that right?
Yes.
Do you know, do you remember or do you not whether Joe had anything alcoholic to drink when he had those hot dogs that night?
No.
No, you don't remember? Or no, he did not?
He did not.
And then she asked you questions if you worried about when your husband leaves, correct?
Yes.
Were you worried this, why were you worried this night when Joe left?
I always worry about him, and he was going by himself on the boat.
Okay. If you remember, has he gone out on the boat before at nighttime?
No.
No? Is this the first time you remember him going out at nighttime by himself?
Yes.
That's all I have, thank you.
Any follow-up?
No, Your Honor.
You may step down, thank you.
Thank you, sir.
Nancy Counsel. All right, a good opportunity to break for the day. We will resume tomorrow morning at 9 o'clock.
All rise.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'm here with Ken Belkin, one of our regulars, and he's been listening to the testimony of the wife of Dr. Joseph Urich, the Ohio surgeon who's on trial right now, facing a series of charges related to this fatal boating accident. And we got somewhat of a picture of what was going on that night. She said that there was a barbecue, that he ate like 4 or 5 hot dogs or something like that. But she just can't remember him consuming any alcohol. It didn't appear to be inebriated, intoxicated, impaired, nothing like that when he came back. But, you know, she said he was messing around with a boat after he came back to the dock, and she didn't call police for a full hour until after he returned home. And that was after she played amateur police officer herself, trying to figure out what he had hit. So overall, was that a successful defense witness?
You know, I think she did reasonably well. She helped defeat the proposition that he was intoxicated or impaired. You know, I think that that's really the crux of it. For 2 of these charges, they need to prove that that he was impaired by cause of alcohol or drugs, or that he was driving the boat recklessly.
Well, I don't think we had any smoking gun evidence there of any sort, but the question then becomes whether or not this witness is to be believed because she has skin in the game.
Yeah, certainly she has incentive to fabricate testimony. She is his wife, and a good wife will lie for her husband on the stand. But, you know, I do think the fact that the chemical test evidence was thrown out, suppressed rather, you know, there's a bit of a stretch here getting that impaired evidence in.
Well, they don't have it. That's the bottom line. And the only thing that I'm seeing here is some evidence that he had consumed some drinks before this happened, but no one seems to want to say that he in any way looked impaired, including the police. So, you know, I'm seeing 2 charges here that just don't look to me like they're going to stick.
Yeah, it doesn't look like the aggravated vehicular homicide or the aggravated vehicular assault is going to stick.
Well, I think that the first one could, because this first one they just need to prove recklessness.
Well, recklessness, you know, it depends how he was operating the boat. It's also very dark out. This could have just been a terrible accident. However, the fact that he left after the accident occurred, that's a problem.
Well, that charge could stick, but it's just a misdemeanor, so it's not going to affect his medical license in any way based on the way I'm reading the medical code in Ohio. So I think that the second charge and the third charge, which both would require evidence of impairment, it just looks to me like there's just not enough there.
It's very tough, and typically, you know, in cases where someone's charged with operating a motor vehicle while impaired, you know, even if you don't have the chemical tests, inside the criminal complaint or the indictment, they will insert this like standard language that says the police officer observed, you know, the classic signs of intoxication: unsteady gait, blurred vision, blurry eyes, red bloodshot eyes, slurred speech, all the typical things you would associate with one being drunk. And the fact that the police officers themselves are not describing him in that state, that's a big help, I think, for the defense.
I mean, and again, I mean, it seems that the overall evidence is lining up that he really didn't exhibit any issue as far as impairment. So I think that the only thing that the prosecution has to go on is the first charge, which could be proven through recklessness, and the last charge, the failure to stop after an accident, because there is some evidence on the record to say that the boat was going way too fast for the conditions, that the collision does not look like the sort of collision that would have happened had he been observing the 10-mile-an-hour speed limit on the lake in hours of darkness. So we have eyewitness testimony saying the boat was moving very quickly down the lake, impact evidence from the status of the busted up boat. that would suggest it was a greater than a 10-mile-an-hour impact. So, I mean, is that enough to prove the recklessness on the aggravated vehicular homicide charge?
With respect to eyewitness testimony, you know,
eyewitness and then the examination and the photos of the impact.
Well, with respect to the eyewitness testimony, you know, you've got dark conditions, visibility is not so great, and people, you know, can't always tell how fast something is going. You know, there's room for doubt there. With respect to the impact damage, you know, yeah, that's going to be a problem.
Yeah, so I mean, if I were to take my guess on this, I think that they've got a moderately strong chance of getting a conviction on the top count and a reasonably strong, if not a very strong, chance of getting a conviction on the misdemeanor failure to stop after an accident, because there's some evidence that there was yelling out on the lake back and forth between the two boats, the striking boat and the boat which was struck. So based on that evidence, it would seem that this whole story that he gave later about you know, thinking I hit a rock, well,
yeah.
a rock doesn't yell back at you,
and
or
there was an explosion.
You don't yell at a rock.
Rocks
you know?
don't typically explode.
Yeah,
so
it seems to me that those might still stick, but the aggravated vehicular assault, the third-degree felony, might not stick, because I just don't see enough evidence there to say that there was in any way intoxication or impairment. And I think the operating vehicle while impaired is going to have to go as well. But we'll wait and see. We'll be back probably in about an hour, because we also have the Campbell trial continuing out of North Carolina. Well, actually, it appears that we don't, because they took a 15-minute recess in that. So, of course, the minute the Urich case goes on its break to be resumed tomorrow, then the other case takes a break as well. So I think what I want to go is dial all the way back to clip 31 in the Urich trial, because this is the critical examination of the police. This is Gregory Johnson, who is the deputy sheriff, who did most of the primary investigation, and this is about a 15-minute clip. This is really gets to the core of whether or not there was alcohol in the defendant's system, the doctor's system, whether there's any evidence that he looked like he was intoxicated, impaired, whatnot. And the sheriff seems to back up the testimony of the wife that we just saw. So let's listen to that clip, and we'll be back with more analysis in a few minutes.
Out to go check on the baby, but she was there primarily the entire time.
Tell me about where his boat is docked from his house. How far is it?
Based on what Mr. Urich told me, it was about 300 feet from the house down to the boat.
Okay. And were you able to see it from the house?
No.
And did you follow him down to the dock?
Yes.
Does anyone else show up while you're at that scene?
While we're down at the boat?
Yeah.
No.
What about any time while you're at that scene?
While we're at the house, one of my detectives shows up, Detective Zwick. She came over to assist me.
Okay. Where is she while you're talking with defendant?
She is still over at Les's bait shop.
Okay.
Because she had responded there.
When did she arrive? At what point?
Yeah, if I could refresh, I may have it in my report.
Sure, go ahead.
She had arrived after we had returned back up to the boat. I don't have an exact time, but we were back up when she had arrived.
So you had already seen the boat before she got there?
Correct.
And when you get down to the boat, what do you see?
I see a boat that matches the description that was given, that it was a maroon and white boat. I notice that there is substantial damage to the left front side of the boat. I do take photographs of the boat at that time.
Did you take them while you were down there that time?
Yes.
Okay. Are you still able to see that screen?
Yes, ma'am.
Can you see that all right?
Yes, ma'am.
I'm showing you what's been marked as State's Exhibit 17. Can you tell me what that is?
That's the photograph of the boat that Mr. Urich indicated he had been driving that night.
And is that the boat you say matched the description of the maroon and white?
Yes.
And what, tell us what's pictured in this picture, describing like an angle that we're looking at.
I'm looking at the left front of the boat. You can see below the bow line, you can see some damage on the upper part of the hull.
Primarily, you can see on the top of the boat, right?
Yeah, that's correct, ma'am.
I'm going to show you State's Exhibit 18. Do you recognize that?
Yes, that's another view of the same boat.
I don't know if you can see it. Can you see anything else in this boat, or in this picture, in this photograph depicted that the boat's docked to? Can you see the dock?
Yeah, the dock is there on the, would be on the left side of the boat, on the right side of the photo.
I'll show you State's Exhibit 19. Can you tell us what that is?
Again, that's the same boat, picture of the left side. You can see the damage to the bow of the boat.
And this is more underneath than the last picture, correct?
Correct.
And then State's Exhibit 20.
A little closer view of the same damage.
Is there a hole in that boat?
Yes, ma'am.
All these photos that I've shown you this morning, have those all been fair and accurate representations of the photos you took?
Yes, ma'am.
That evening? Did you ever ask the defendant if he had any injuries or if he fell during this crash?
Initially, I asked him if he had suffered any injuries. Later, as the investigation went on, I did notice that he had some abrasions on the left side of his neck.
Okay.
I asked him if they were related to the crash, if he had fallen down as a result of the crash. He wasn't even aware that he had any of those abrasions and said he couldn't recall if he had fallen down or not.
He couldn't recall. He didn't say whether or not he felt fallen off his chair or anything on his boat?
No, he said he couldn't recall how he got those marks on him, and he said he couldn't recall if he had fallen or not from the crash.
Did you ask him if he had drank anything after getting home?
Yes, I did. I asked him if he had any alcoholic beverages once he arrived home, and he stated no, that he hadn't.
You talked about him saying he had a couple beers and then maybe some beers. Did you continually ask him about that during your interaction with him?
During the course of the interview, I did speak to him about the alcohol, anything that he had consumed. He did make the comment that I would find alcohol in his blood.
Objection, strike.
Sustained.
Your Honor, please sidebar.
Yes. Yes, as it relates to an admission by a party opponent, the objection is overruled and the witness may answer that question.
I'm sorry, again, what was that?
Mr. Urich did state that I would find alcohol in his blood.
Did you ask him again whether he knew if he stopped and said anything like that, right immediately after the crash?
During the course of the interview, I did ask him, had he said anything? Did he hear anything? He maintained that he hadn't, that he had just hit what he thought a rock and that he had kept right on going. During the course of the investigation, I did have the opportunity to stop by University Hospital Robinson. I obtained some additional information at that time, and based on that additional information, I did go down and make contact again with Mr. Urich at his residence.
Okay. Is that when you talked to Bruce up at the hospital?
That is correct.
Okay. And what, based on that, is that when, you already said that's when you went and talked to him again. What specifically did you ask him when you went back?
I had concerns with what had been told previously by Mr. Urich based on this new information. I specifically asked him that, based on this information, I believe that he knew he had hit a boat, and he maintained that he still thought he hit a rock. And I said, well, I gained information that you actually had said something to the person that was in the water. And I told him what my understanding of what had been said to him. And he immediately said that, no, he didn't say that. And then he went on to state that if he did say something, he now didn't recall saying that, didn't recall, now his answers became vague, didn't recall, he didn't.
As to the term vague, you can state exactly what he told you.
He did not recall having any kind of interaction with anybody in the water. Then he stated that if he did say something, he didn't now recall. If he had said something, he could not recall what he had said. But he maintained that, he throughout the interview, he maintained that whatever, after he hit what he thought was a rock, he kept going. So even after he said that he couldn't recall if he had said something to someone in the water or somebody, he still maintained that he just kept going.
You said before that you saw some scratches on his neck. Is that right?
That is correct.
Did you take photographs of that as well?
Yes, I did, ma'am.
I'm going to show you State Exhibit number 45. Do you recognize that?
Yes, ma'am, that's the photograph I took of Mr. Urich.
And what is depicted in that photograph?
Some abrasions on his left side of his neck.
And is that how Mr. Urich or the defendant looked that evening?
Yes.
At that time?
At that time.
So at the time you took those pictures, that's what he looked like?
Yes, ma'am.
What exhibit number?
45.
Thank you.
Did you observe any other injuries on him while you were with him?
No, ma'am.
At what point, when were you done with your interaction with the defendant?
After I had returned back to his residence, after I left the hospital, I had spoken to him, and that's when I had that conversation with him about any interaction, verbal interaction with anyone. That's when I left the house, was my last interaction with Mr. Urich.
Did you ever tell the defendant that the person had died in the boat?
Yes, I did.
What was his reaction?
Became very emotional.
defendant, did you see any signs of intoxication?
Obvious signs of intoxication, as in someone not being able to walk. No, he was able to walk, and he was able to talk clearly.
Did you smell an odor of alcohol about him?
I did not detect that, but I always like to preface it. I have extremely bad sinus problems, so I'm not the greatest one to ask that question, but I did not detect any.
And you had already heard from the defendant that he admitted about drinking beers that night, correct?
Right from the beginning of my first contact, he acknowledged that he'd been consuming beer.
When you say obvious signs of intoxication, what do you mean by obvious?
When I was interviewing him, Mr. Urich, I had recorded quite a bit of it, but that was just audio. So I wanted to make sure I had a clear documentation in my report of what I was visually seeing. And so he wasn't falling down. He wasn't staggering. Did not mean that he wasn't impaired. I'm just saying that I didn't see anything visible.
Objection.
Sustained.
How long is, during your interaction with him, how long is it from the initial calls from the initial crash?
I'm sorry, ma'am.
That's all right. During your interaction, this time period, how long is that from the initial calls of the crash?
Well, you know, the calls are coming in at 10 minutes after midnight.
Okay.
I arrive at approximately 1:48. So you've got a minute and an hour and 38 minutes between the time of the initial 911 calls till I first have contact.
Okay. And do you have continuous contacts with him for a number of minutes or a number of hours?
For the good part of the next 4 hours, I'm with him. The exception is when I leave to go up to the hospital and then come back. But for the most part, I'm with him or he's with me the entire time.
Welcome back to the LawNewz Network, everybody. We're reviewing some testimony from earlier in the trial of Dr. Joseph Urich, the surgeon in Ohio who is facing 4 charges related to a deadly boating accident which killed one and left another injured. Ken Belkin is still here with me, and interestingly enough, I wanted to play that clip because the Sheriff's Department investigator said that, well, I didn't smell alcohol or see signs of impairment. And that's what the wife testified to earlier today. So the only thing I'm noticing from the element of impairment that's required for at least 2 of the remaining 4 charges is independent witnesses corroborating and saying, well, it didn't look like he was impaired.
Look, I mean, this is where, you know, don't make statements to the police, because without his statement that he had consumed alcohol, there is literally no evidence in this proceeding that he consumed alcohol.
Well, we did have a friend say that he had some kind of a drink earlier at an event. So,
yes, but that friend
was
brought in to testify to the fact that he could say, yes, he had a drink, but he wasn't impaired.
Yes.
They wouldn't have even needed that friend had he not made that initial statement to the police that he had consumed a couple of beers. It's very important. Whenever you're charged with a crime, people have the impulse to talk to the police. The police take on this tone where, like, if you talk to me, I can help you. They never help you. Their interests are extremely adverse to your own. You know, you should never make statements.
So the false friend narrative from police is best viewed through the Ronald Reagan quote that there's no such good from I'm from the government and I'm here to help.
Yeah, it doesn't work out well.
Okay, so you think that the doctor and his wife handled the police interaction pretty well,
yeah.
But for the fact that she called the police to try to get the ball rolling with the investigation.
Yeah, I mean, she certainly called it an hour later. You know, it begs some questions, but his statements are very troubling. Without that statement, I mean, you heard that cop testify. He didn't see he was able to walk. He didn't notice his speech being slurred. He said he couldn't smell any alcohol, but then he couched it with the fact that he has sinus problems. So I don't know, maybe it's pollen season.
Yeah, you know, who knows? I mean, so the bottom line is that it doesn't look like there's a lot of evidence on the table to say that the second and third charge, which again require evidence of intoxication, will stick.
Yeah, it seems that's a tough hurdle for the prosecution at this point.
So should those charges be dismissed on a defense motion that they shouldn't stick, or should the judge actually deliberate about them and then return a not guilty verdict?
You know, I think that the standard is from trial order of dismissal. The standard is, you know, at the conclusion of the prosecution's case, defense will make a motion. Some defense attorneys make a more extensive motion than others, where they say, look, in the light most favorable to the prosecution's case, they have failed to elicit any testimony or present any evidence that could prove these elements. I do think that probably some evidence was introduced that could support the fact that he was drinking. I don't know if it proves it beyond a reasonable doubt. So I don't think a trial order of dismissal is appropriate here, but it should certainly go to the trier of fact to deliberate, which is the judge.
Which is the judge ultimately anyway. So the judge will probably then, when this continues on tomorrow, actually force himself to deliberate about all 4 of the remaining 5 charges.
Yeah, very interesting that they went with a bench trial here over a jury trial, because I feel like a jury trial might have been more beneficial.
I was wondering the same thing, interestingly enough, because at this point, well, I don't know. I mean, if there's case law in Ohio, which I don't practice there, you don't practice there, to really raise the definition of recklessness as to the aggravated vehicular assault charge up and make recklessness more extreme than it is in some places, maybe I could see the bench trial being the better decision. Because at this point, I figure charge 5, the failure to stop after an accident, it seems that that's been proven beyond a reasonable doubt pretty well. The drinking charges, charge 2 and charge 3, I think there's not enough evidence beyond a reasonable doubt there. Again, this is just my opinion, but it seems to be a general consensus. But the reckless operation charge, if that is a very high burden in Ohio, I could see maybe a judge actually saying, hey, look, I know the case law, it's too high of a burden, state you haven't proven it beyond a reasonable doubt. Whereas maybe a jury would turn around and say, oh yeah, you were going too fast, recklessness, you're done.
I wonder if the defense attorneys were taking a calculated risk. They thought maybe, you know, a jury might be too emotional, that someone died, that we need to have justice. But in my opinion, I would think I would prefer the jury, because I would harp on the fact that there's no evidence of intoxication, and I would ram that into the jury's thick skulls to really drive it home that he was not drunk, that this was just an accident, and accidents happen sometimes without criminal culpability.
Well, how would you get over the fact that there is witness testimony on the record here saying that the boat was speeding down the lake to some degree that was definitely faster than the 10-mile-an-hour limit? And then how do you get over the actual status of the wreckage of the boats, which the experts testified that looks like more than a 10-mile-an-hour impact? So, you know, if it were a negligence case, we'd have negligence violation of the law that imposes the 10-mile-an-hour limit on the lake. You know, the jury might look at that and just say recklessness in the top charge is the issue for the doctor. That's the charge that's the most serious. It's the charge that carries prison time, and it's the charge that would have an effect on his medical license.
I mean, I think there's room for argument there. You know, no one is an expert. No one can definitively tell you how fast something is moving unless they have a radar gun and they're checking it. You know, according to the evidence presented so far, there was no one, you know, checking the boat's speed with a radar detector. On the other hand, the impact is a problem, but, you know, depending where you hit something, you know, impact can be greater. So I think there is room to argue that maybe, you know, he just happened to hit a particularly vulnerable area of the hull, and that even at 10 miles an hour, or even 15 miles or 20 miles an hour, you know, 20 miles an hour, even though it's double the speed limit, it's not. Is that really reckless to drive something at 20 miles an hour?
Well, yeah, I mean, it could be some percentage of the or could be any numerical value after that, but it just seems that many people would look at that and say, okay, well, you know, there was definitely speeding. Does speeding equal recklessness under Ohio law? That answer I don't have. Maybe that's my research homework assignment for the evening. I want to continue listening to the testimony of Gregory Johnson, though. He's the lead investigator from the Sheriff's Department in the case. We've got another clip where he talks about some of what he did after his initial discussion with the defendant in this case.
You okay, Kath? Just to clear up one area which I'm sure is going to be raised on cross-examination, but there was an objection posed as to Lieutenant Johnson's, whether the lights were on at the time he looked at the boat or whether they had already been turned off. And obviously it's a multiple question, and I know that's an area at issue, so the objection was overruled as to the second part of that question, whether they were on or off when he saw the boat. If I could move that along. Attorney Morrow.
Thank you, Your Honor. Good morning, Lieutenant.
Good morning, ma'am.
You have, through the course of your testimony this morning, several times referred to your police report, correct?
Yes, ma'am.
Those were the notes that you took shortly after this incident.
I wrote it up after the incident, yes, ma'am.
You weren't, as you were sitting there writing things down, as people were telling you things. You went back, I believe, and reviewed your audio recordings.
Yes, ma'am.
You did not record audio while you were at the hospital that evening, correct?
No, ma'am.
Okay.
If, I guess I should...
Let me clarify that.
Yes, ma'am, please.
When you went to the hospital and spoke to Mr. LawNewz, you did not audio record that.
No, ma'am.
That portion of your report is from your recollection of sitting and talking to him.
I did write notes when I was talking to him.
Fair enough. Do you have those notes with you?
No, ma'am.
It's important when something happens and you're investigating to make sure you document as much as you can at the time, correct?
Correct.
Because as you just said, you were still investigating.
Yes, ma'am.
You don't know what's going to be important and what's not.
No, ma'am.
You don't know what's going to be useful to some of the other investigators and what may not be useful.
Correct.
So you have to document as many details as you can, correct?
Yes, ma'am.
And from that documentation, you prepared the report you've been referring to today.
Yes, ma'am.
And it's quite possible, as happened here, it may be several years before you testify, correct?
That is correct.
Or before the information you put in your report may be needed.
That is correct.
So, you would agree with me if you wrote something down back then 2 years ago is probably a little more accurate than your recollection here today.
Depending on if it was something I had recorded or if it was something that I had just written down at that time.
And if it's neither, you didn't record or you didn't write, you're going off your best recollection as you sit here today.
That would be correct, yes, ma'am.
You were asked a couple minutes ago if Mr. Gersh had left by himself that night in his boat. And you said, yep, he said he left by himself. And when he returned, he said he was by himself, correct?
He said that he had left his house, his wife and his child was at the house when he left alone. And he said at the time of the crash, no one was in the boat with him.
And you don't have any evidence to indicate somebody was in that boat at the time of the crash, besides Joe Gersh?
Other than his statement, no, ma'am.
Well, you didn't find anything to contradict that statement?
Not that I'm aware of, no, ma'am.
picture sometime around 4:05 a.m. on May 9th, correct?
Yes, if I recall correctly, I have the time in there, but it was
And
after
I
4.
put up on the screen State's Exhibit 45, which you testified to a little bit ago.
Correct.
You yourself did not notice that mark until shortly before 4 a.m., correct?
I think I noticed it just before 3 a.m.
Right around 3 a.m.?
Yes, ma'am.
So you get there around 1:48, shortly before 3 is the first time you noticed this mark.
That's correct.
And you don't document it until shortly after 4.
That's when I take the photograph, ma'am.
Okay, folks, we're going to break out of that replay, that review of testimony in the Uritz trial out of Ohio, because we're back live in the courtroom in the Campbell case out of North Carolina. That's the son who's accused of joining his father on a multi-state crime spree leading from Texas all the way to the Atlantic coast, which resulted, prosecutors say, in the death of a husband and wife in North Carolina. Corin Powers is on the stand. She's a gunshot residue expert. Let's listen live to the testimony there now.
Details,
No.
those kind of information. Now, in this case, in West Virginia, in addition to Mr. Edward Campbell firing the 38 6 times, there's also evidence that Lieutenant Dove returned fire 7 times with a .40 caliber Smith & Wesson. And every time either of those firearms discharged, we would get that explosion and we would get gunshot residue entering the area. Is that fair to say?
Yes.
And and you can't determine from any particular gunshot residue, globular or molecule, which gun or which type of ammunition fired to produce that. Is that correct?
That's correct. Gunshot residue is for the most part the same from ammunition to ammunition and from caliber to caliber.
So if Mr. Eric Campbell had gotten gunshot residue on him during that shootout, you couldn't say whether it was from Edward Campbell's gun or from Lieutenant Dove's gun.
I can simply say that there was gunshot residue present on the sample labeled as from his right hand.
I have no further questions. Thank you.
Briefly, Your Honor. Ms. Powers, the 4-hour rule that defense counsel was asking about, why do some labs have rules like that?
Typically, it's used as a management tool to help manage backlog incidents. If your laboratory is particularly far behind in gunshot residue analysis, they may impart that rule to help cut down on the number of kits that come in. Our laboratory is relatively caught up on the number of gunshot residue kits that come in, so we don't have to employ that tool as a management technique.
With respect to the amount of time, just as defense counsel was asking about the amount of time that elapsed, if Eric Campbell fired a gun 16 hours before, a .22 pistol, is it possible that gunshot residue could remain on his hands that length of time?
It is possible, depending on his activity.
I don't have any other questions.
Yes, Your Honor. Now, if someone fires a gun and gets gunshot residue on their hand, or gets gunshot residue on their hand from any circumstance, is your testimony today that wiping your hands, rubbing your hands together, or wiping your hands is very likely to remove that residue?
It could possibly. Any kind of action of rubbing or wiping or washing your hands or perspiration or anything like that has the potential to move particles if they are present.
And that likelihood, that the ease of removal, either intentionally or just from interacting with your environment, is the reason why many places have a rule that they won't go beyond a certain period of time because they're not likely to find anything that has meaning.
Again, for most of the other laboratories that I've spoke with, it's used as a management tool because I can never say whether the gunshot residues were particular to a specific incident, whether it be an hour ago or 8 hours ago. Again, it's just the likelihood that it could be lost over time due to normal activity does exist. So many laboratories employ that to cut down on the number of gunshot residue kits that they analyze.
I have no questions.
Anything further?
Nothing further.
Okay, you stand down. You ask me to issue the leave for Mr. Stanley?
Yes, Your Honor.
Any objection? Yes, sir. That'd be fine. Ladies and gentlemen, we're going to take our evening recess at this point. You can find it coming on. During our evening recess period, it is your duty not to talk among yourselves about this case. It's your duty not to talk to the parties, the witnesses, the lawyers about anything at all. It's further duty not to talk to anyone else, to allow anyone else to talk with you to say anything in your presence about this case. If anyone communicates with you in any way or any form, you need to let the sheriff know about it and come in. Don't do any individual research or investigation unknown about any issue touching on this trial. Stay away from computers in any form as it has anything whatsoever to do with this trial. Have no contact or communication with anyone participating in this trial, and do not form or express any opinion about this case during this time.
And it looks like the end of the day there in the Campbell trial out of North Carolina. That's the trial of a son who was accused at one point of joining his father on a multi-state crime spree. This case involves the death of a husband and wife in North Carolina. The father committed suicide in custody, so he will not be joining his son in what has turned into a capital murder trial in North Carolina. North Carolina has a capital murder statute, but they don't frequently employ it. So does that generally mean that juries there are saving the death penalty for the absolute most egregious, most serious murders that they come across? And is it possible that the son's defense that he was just swept into this thing along with his father, might that be enough to mitigate the death penalty in a state that doesn't frequently apply it?
I would hope that his defense attorney could bring enough mitigating factors to the light that, the death sentence wouldn't be imposed. Certainly this kid, if he's convicted, is going to get a very harsh sentence. I do think he was the victim of a drug-addicted, abusive, depraved man whose own wife had to escape in the middle of the night, and he really, he was dragged along through this thing, like a Stockholm Syndrome type defense.
Well, I mean, the testimony from the abuse within the family last week was pretty compelling, as I remember it. She's talking about being tied up in such a way that if she tried to escape, it would like hang her or something like that. I rember some of the testimony.
Yeah, I mean, that is absolutely, disgusting behavior. This guy was a real monster, and, I don't think that the kid should be punished. On the other hand, putting my prosecutor's hat on, not a hat I wear very often, he is an adult. This was a multi-state crime spree. He had ample opportunity to get away. There was a point even when the father was incarcerated briefly in Texas where he could have, bailed out. He could have escaped at that point. Instead, he chose to bail his father out. So I don't know, it's a tough one.
Well, to get out of a conspiracy once you're in it, you have to take affirmative steps to get out, and there's no evidence that the son did that. So it would seem to me that the charges might stick just based on what you alone mentioned here.
Yeah.
So you did put your prosecutor's hat on, and you did win the argument for that side.
Well, I'm going to put the defense hat back on, and I would say, look, this kid is so traumatized. To the objective person, yes, he could have removed himself from the situation, but that's looking at it objectively. After, you know, suffering decades of abuse and torment and just the authoritative manner which the father conducted the family affairs, I don't know that in his mind there was ever any escape.
There may not have been, and we've been watching the Campbell case, and again, you know, we've got these family pictures that make everything look nice and buttoned up here, but we had testimony behind the scenes of that very photo last week that indicate that the image belies the reality. So it's a case that we've had to cover in bits and pieces here. We should be back with it this week, pending its outcome, and the Urich case, though, has gone on longer than expected. We had a full day of defense testimony today, and that's going to spill into the day tomorrow. This was supposed to be wrapped up last week, so this trial is taking quite a while. The prosecution called 21 witnesses. That's quite a few witnesses for a case like this, and we know that someone did die in the crash, but we've seen quite a few witnesses here, and there are still factual scenarios to be resolved by the trier of fact, in this case the judge, as to whether or not the defendant truly was impaired from drinking alcohol earlier that day. We know alcohol was consumed. We don't have any testimony that his eyes were bloodshot, that he was slurring his speech, that he smelled of alcohol in the hours after the crash. So, okay, well, consuming alcohol is not a crime. You can drive after you've consumed alcohol. You just can't do it while you're intoxicated or while you're impaired.
Yeah.
So does it look like he did anything illegal as it relates to the charges that require evidence of impairment?
Look, I mean, with respect to the amount of witnesses they've called, you know, what did you say? It was something of 21 witnesses.
Is my count for the prosecution.
You know, sometimes the prosecution likes to overwhelm with the quantity of witnesses, but not necessarily with the quality. I've had cases where, you know, 10 prosecution witnesses, and I only called one witness, and we got a full acquittal. You know, I do think this is a case where I don't think this man has any criminal convictions. He might have some traffic violations for speeding. He might be a good client to put on the stand. He's a doctor, he presents well, he's a relatively upstanding citizen. You know, it might be good to put him on the stand and hear some testimony that he didn't know what he hit. You know, maybe he could testify to how fast he was going, and maybe he could defeat some of that evidence of the impact, or the eyewitness testimony attesting to the fact that the boat seemed to be moving at a fast pace. I think he could be particularly useful if he can testify in a way that benefits himself.
Well, that gets into a sticky area, and the reason why it gets into a sticky area is because the whole, you know, failure to stop, he's going to have to say, I thought I hit a rock, and I think the greater fear is not so much the outcome of the criminal charge, but if he says anything that could result in a perceived self-statement of dishonesty on the stand, that has medical license implications, and I think that that's really sort of the end game here, is to try to avoid the felony and keep the medical license. Because, okay, so if he gets nailed on the last charge, the misdemeanor, again, I keep saying this, that doesn't affect his medical license. But if he says something that could be perceived as dishonest, then you talk about license implications that could affect him long after the criminal case is
moral
over.
turpitude.
Yeah.
Look, I think he would have to be really prepared to testify. Whenever I've had a client or any witness really testify, I prepare with them for hours. I prepared one guy for upwards of 20 hours to testify, and he may have testified for 2 hours tops. He needs to be prepped on what questions are going to be asked on direct, how he should answer them, obviously always answer them truthfully, and he should also be prepared with a mock cross-examination, questions that the prosecution might ask. But I think he could do a lot of good for his case here. He's not someone that, you know, if they put him on the stand, the prosecutor's not going to be able to impeach his credibility by a prior criminal history.
The other thing he has are some prior speeding things, but I don't know if they would necessarily come in.
May not be relevant could be relevant given the allegations that the boat was speeding. However, you know, just because someone has speeding tickets doesn't mean that they should be disbelieved entirely when they testify.
Yeah, I'd have to really think through the evidence analysis on that to see whether or not it would stick. But want to go back to some of the previous testimony in the case. We've been listening to some of the testimony of Gregory Johnson, who was one of the investigators who was at the doctor's house after the crash. The reason we've been going back over this is because the doctor's wife was on the stand this afternoon, and many of you listened to her testimony in full. And so much of what she said is corroborated by the so-called disinterested, the independent sheriff's investigator, that I think that any evidence that the wife was somehow trying to cover the husband, you know, I don't know if those accusations would stick in this case, because she's really saying the same exact thing that the law enforcement official is saying. So we'll continue listening to some of his testimony. We'll be back in about 10 minutes.
You've had extensive DUI training, is that correct?
Yes, ma'am.
All right. And do you have any concerns when you're investigating a DUI after a crash with regard to giving someone field sobriety exercises?
There's always a concern about anybody that's been involved in some kind of a traumatic effect incident. They don't always show signs of impairment.
Okay. And what else are you concerned about? Like if they've hit their head or something like that?
Sustained.
I'm sorry. Are you concerned about whether they have any injuries as a result of that crash as well? Objection.
Overruled.
Yes, I'm considering that if they have any physical injuries or if they have struck their head.
And you already know that this boat was in that crash at that point, don't you?
That is correct.
When we're talking about field sobriety exercises, what kind of exercises are we talking about? Like what are the normal field sobriety exercises that you would have given had it been just a normal run-of-the-day DUI along the side of the road? Objection, speculation.
Overruled.
Refer to it as the one-leg stand, where you have the subject stand with their leg elevated off the ground and count to 30, okay. 30 seconds. Walk and turn, the heel and the toe test, where they walk heel and toe 9 steps, turn around and come back. Then we also do the eye and the nystagmus test to see if there's any effect on their eyes, on their ability to track.
And after talking with the prosecutor that night, you decided not to do those field sobriety exercises?
That's correct.
What was the reason for that? Objection.
Overruled.
When I was speaking to Prosecutor Vigalucci, it was the focus on that time was that we were dealing with a homicide from the boat crash, and that we weren't looking at an OPI, and to look at doing alternate forms of testing that if Mr. Urich was willing to do that.
Objection.
I can certainly distinguish the answer, so you can proceed.
Thank you. Had you ever met the defendant before that night?
No, ma'am.
Did you know how he spoke normally on any other night besides that night?
That was the first time I'd ever met him.
When you went to that house and spoke to the defendant, you've already testified that he thought it was a rock that he ran into, is that correct?
That's what he said, he thought he'd hit a rock.
Did he say it might have been something else as well?
He thought it was a rock. He wasn't even positive it was a rock that he had struck.
Okay. So did he keep going back and forth, and maybe it was a rock, maybe it was something else?
He never specifically said that he knew he hit a rock. Okay. He thought he hit a rock. He didn't check. He kept going. So he never made any attempt to verify what he had struck.
So did he seem confused about what he hit?
Yeah, he wasn't sure. I mean, here he had struck something, but he maintained that he didn't even stop to find out what he had struck.
What about when you asked him whether he stopped and said something after the crash? Was he confused about that?
He didn't think he had said anything, but then when I pointed out what I had, my understanding of what was said, he immediately said, "I know I didn't say that." So he's initially telling me he didn't think he said anything, and then but if he didn't think he said anything, how would he know if he did or didn't? How would he know if what I was telling him he said or didn't say? When he doesn't now, he's maintaining he didn't know if he said anything, and if he did, he didn't recall what he said.
So he didn't remember either?
Correct.
That was possible, right?
Correct.
So when you say that there's no obvious signs of intoxication in your report, you already mentioned that he wasn't falling down, correct?
That's correct.
And you couldn't smell an odor of alcohol on him like you testified before, that's right?
Correct.
But he did make, didn't he tell you several times that he had a number of beers?
He never gave me, yes, he did say that, and he never gave me a specific number, so I knew that he had been drinking, consuming alcoholic beverages.
So you didn't need to smell an odor of alcohol in order to know that he consumed beers, did you?
Rephrase.
Did you need to smell an odor of alcohol in order to know that he consumed some beers?
He acknowledged that he had.
Did he tell you how long he lived on that lake, or you said before that he was familiar with that lake. Did he say how long he lived there or anything?
I don't recall if he gave me an exact time. I know they said that they'd had the cottage for a while, but I don't know what that would mean. But he said he was familiar with the route back from Ben's restaurant back to where the cottage was at.
Okay. And would that mean he'd be familiar with his dock as well?
Objection.
Speculation sustained.
That was the dock connected to his house, correct? That you went and took the pictures of his boat?
Connected to the property, yes, ma'am.
Did it look like that dock had been there for a number of years?
Yes.
And you already mentioned that there was one of the steps was in disrepair, is that right?
We had commented about, because the winter had been so severe, that about there had been damages to the docks and that down there because of the ice during the previous winter.
And when you're in the car, again, you've never met the defendant before that, right?
No, ma'am.
So you've never heard him talk before that day, is that right?
Overruled.
No, ma'am.
Does the defendant repeat himself a lot in the car?
He does.
When you said to Attorney Morrow that you were trying to calm him down to keep him cooperative, did you want him to stay cooperative throughout the entire time you were talking with him?
Yes, ma'am.
Did you also ask for permission for his trailer at some point?
Yes, ma'am.
And what was that for?
Watercraft wanted to take custody of his boat. He agreed to allow us to take the boat, and he also provided permission to use the trailer for the boat to take custody of the boat.
And did you feel that those statements you made to him kept him calm? Objection.
Rephrase.
Did you feel that those statements you made to him kept him cooperative? Objection.
Speculation sustained.
Did he stay cooperative after you made those statements?
Yes, ma'am.
Did he stay calm after you made those statements?
Yes, ma'am.
During this entire time, are you still investigating?
Yes, ma'am. I'm trying to gather as much information as I can.
So while making these statements in the car, are you still investigating what happened that night?
Yes, ma'am. The closest it came to that, he wasn't sure. After they had talked to some people prior to my arrival at the house, and there had been indication that a boat had been struck, and that's where he thought that he might have hit a boat. But he never came out. He was never sure what he had hit.
So it was your understanding that they knew he hit a boat before you got there?
Objection. Sustained.
Didn't they tell you they knew he hit a boat before you got there?
Objection. We just testified.
Overruled.
They had talked to some friends, and they knew a boat had got hit.
And that's what they told you?
Correct.
One second.
You may.
Anything further?
Welcome back to the LawNewz Network, everybody. We're close to wrapping up for the day, but we're reviewing some of the testimony from the police in the Ohio trial of Dr. Joseph Urich. He's a surgeon, and he's accused of a boating accident which left one person dead and another person injured. So as I see it here, and maybe I'm looking at it from a broad brush stroke, Ken, the doctor on trial here is facing testimony from both the police and his own wife, which for the most part seem to line up.
Yeah.
So it would indicate that the wife is a credible witness.
Yeah, I think it makes the wife seem a little bit more credible, the fact that her story is corroborated by the arresting officer. You know, it's going to be interesting to see how they go. I would personally put him on the stand. As long as he's prepped and can testify reasonably well, and, you know, I think I would go with him as a witness.
Okay, so let's say that he gets pinned into a corner and he says something that's going to mess up his medical license or lead to some administrative punishment by the medical office, though. I mean, does he run a risk of that happening?
Look, he's got to testify truthfully. He can't perjure himself. He can't lie under oath. But, you know, I do think his best defense is his testimony, his subjective experience. No one else can say what he experienced on the date in question.
Is it really going to help, though? Because I can just picture a skillful prosecutor really going after him and lining up exactly how many drinks he had, when he had them, you know, and then in theory, the prosecution could, after that point, call the rebuttal expert to say that many of drinks with that food, with this body weight, would result in an impairment, and then they might have him.
I don't know. They might be able to do that anyway without him going on the stand.
But
at least with him on the stand, he can testify to the fact that, you know, he didn't feel impaired. He could testify to the speed the boat was going, whether he was speeding or not, and he could testify to the fact that maybe he didn't realize what he had hit, and that he did his best when he got home after an hour later. He did call it in.
I don't know. I think that there's a stronger risk. I think, you know, I was wondering why we didn't see like a drink expert or someone like that, because we've seen that in other trials. We had the Tai Chan trial out of New Mexico, and we had this drink expert who conducts these big university studies where basically she gets people drunk and measures the effects and publishes the scholarly work on it. An interesting job to have as a professor is actually getting your test subjects drunk and seeing how they react to things, and then taking all the measurements about what they eat, when they ate it, et cetera, et cetera, et cetera.
You know where there might not be one in this case? Because the prosecution might have already looked into it, and they might have determined there's a good chance he wasn't impaired.
Well, that might be true, but I think that the other reason they might not have gone that way is because they don't know exactly how many drinks he did take in. And so if they don't know how many drinks he took in, they might not have enough detail to even give to an expert to try to do the calculation. There's evidence that he had a couple of drinks in one place and a couple in the other, and the time frames are a little bit muddy, at least from my perspective, and I haven't sat through every minute of the testimony in the trial, but they just might not have enough on the record to even say, well, he did drink this much or he didn't drink that much. You know, friends are saying, well, I don't know, I don't think I saw him drink anything, but I wasn't next to him through the whole party. And you know, so you know, that's not enough for someone to sit down and actually do a calculation. Maybe the reason we don't have that evidence is because we don't have the exact calculation, but if he's on the stand and he's forced to say, yeah, I had one drink here, one drink there, an hour later I had 2 drinks and a shot, and then all of a sudden we start getting actual numbers.
But I don't think the prosecution's going to ask him those questions, because the first rule of cross-examination is do not ask a question you do not already know the answer to. And as far as they're concerned, they only know of a couple of drinks. So if they start asking him questions, well, did you have a drink there? And he says, no. And like, well, what about here? And he says, no. You know, it almost helps his case.
But he would at that point have to have an encyclopedia-like knowledge of what his friends testified that they thought he drank. And
believe me.
And if he turns around and says, my friend had it all wrong, I only had one drink, then...
His defense attorney's getting daily transcripts from this trial, and he's not going to let him go take the stand unless he knows exactly what the words coming out of his mouth are going to be. It's a tough call. Look, it's a tough call anytime you put a client on the stand to testify. He is the exception to the rule, I think, that you don't want to have your client testify. He can testify competently. This man's a doctor, an upstanding citizen, no criminal history really to speak of besides some traffic violations. He's a good candidate for testimony. Smart too, presumably.
Well, we'll see what happens tomorrow. I mean, I guess it is possible, but I thought that that I had heard that he was not going to testify, but then some other people are saying, well, maybe he would last minute. I'm not sure, but
it's also smart for not to testify.
That's a question for tomorrow. So that trial is going to resume at about 9 o'clock. I think the Campbell case is going to get going a little bit after then, but we're going to wrap up for the day here at the LawNewz Network. Ken Belkin, it's always nice to have you back around the round table here with a matching tie and pocket square, I'll point out. There's an inside joke in there. Anyway, we're going to wrap up for the day. It's about 5 o'clock. A reminder that we're on the air from 9 until 5, Monday through Friday, unless we have late testimony in a trial, which today we do not. And another reminder, on Thursday of this week at 1 p.m., you're going to want to be right here on the LawNewz Network because our founder, Dan Abrams, who covered the original O.J. Simpson trial in California, will be here covering the O.J. Simpson parole hearing out of Nevada. This is for the case that involves Simpson's imprisonment on conviction that he and a group of others forcefully entered a motel room and made off with some sports memorabilia that he believed was his anyway. That was a conviction on 11 or 12 counts, and Simpson is up for parole this week, so it'll be interesting to see what happens in that case. But Dan Abrams will be sitting in the host chair for that, covering a defendant that he knows probably as well as any other journalist on the planet. So that is Thursday at 1 p.m. For now, though, this is Aaron Keller at the LawNewz Network, and for all of us here, we wish you a good evening.